ಅಷ್ಟೇ ಮೆನ್ಷನ್ ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಕು, ಇಲ್ಲೇ ಇಟ್ಬಿಟ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಫ್ರೆಶ್ ಆದ್ರೂ ಅಷ್ಟೇ.
ಓಕೆ ಸರ್.
they are permitted to retire long back. ಅವರು ಹಂಗೆ ಅದನ್ನ ತೆಗೆದು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಇಲ್ಲಿಗೆ ಹಾಕ್ಬಿಡ್ತಾರೆ. ಹಳೇದು ಯಾವ್ದೋ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ.
ಕೋರ್ಟ್ ಆಫ್ GM ಕನ್ಸ್ಯೂಮರ್
6186 ಒಂದರಲ್ಲಿ ಇದೆ. ಅದು ಆ ಲಾಯರು ತಗೊಂಡೋಲ್ಲ ಅಂಡ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ನವರು ಯಾರು ಬರಲ್ಲ. ಇವತ್ತು ತಂದಿದ್ದೀನಿ, ಆ ಲಾಯರ್ ತಗೊಳ್ಳೋ ಹಂಗಿದ್ರೆ ಈಗಲೇ ಕೊಟ್ಬಿಡ್ತೀನಿ ಅವನ ಕೈಗೆ. ಅವನ ಕೈಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅವನಿಗೆ ಇನ್ನೂ ಆಥರೈಸೇಷನ್ ಬಂದಿಲ್ಲ. ದಟ್ಸ್ ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್. ಆ 6186 ಅಲ್ಲಿ ಒಂದು ಮೆಮೊ ಇದೆ ನೋಡಿ, ಅದರಲ್ಲಿ ಒಂದು ಜಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ. ಇಟ್ಸ್ ಡೈರೆಕ್ಟ್ಲಿ ಕವರ್ಡ್. 11 ಐಟಮ್ 11. ಹಾ ಹಾ, ಅದರಲ್ಲಿ ಒಂದು ಮೆಮೊ ಇದೆ, ಅದರಲ್ಲಿ ಒಂದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಇದೆ, ಡೈರೆಕ್ಟ್ಲಿ ಕವರ್ ಆಗುತ್ತೆ. ಅವರೇ ಹಾಕಿರೋದು ಅದು. ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತಾರೆ.
ಇನ್ನೊಂದ್ಸಲಿ ಕಳ್ಸಿ, ಇನ್ನೊಂದು ನೀವು ಮಾಡಿ ಕಳಿಸಿ ಸ್ವಾಮಿ. ಸ್ವಲ್ಪ ಬಂದಿಲ್ಲ, ನಿನ್ನೆ ಮಾಡಿದ್ದೀವಿ ಅಂತ. ಫೋಟೋ ಸರ್ ನಾಳೆಗೆ ಆಯ್ತು. ನಾಳೆಗೆ ಡಿಸ್ಚಾರ್ಜ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿಕೊಡ್ಬೋದಾ? ಜಿ ಎಮ್ ಬೋರ್ಡ್ ಇದು ಬಂದಿದೆ ಸರ್, ಬೋರ್ಡಿಗೆ ಬಂದಿದೆ ಅಂತ. ಅಲ್ಲ ಸರ್, ಅದು ಮೊನ್ನೆ ನಾನು ರಾಂಗ್ ಕೊಟ್ಟಲ್ಲಿ ಮೆಮೊ ಮೂವ್ ಆಗಿತ್ತು, ಸಬ್ಮಿಷನ್ ಮಾಡಿಕೊಡ್ಬೋದು. ಹಾಂ ಓಕೆ. ಮೆಮೊ ಎಷ್ಟು ಬೇಕು ಅದು ಅರ್ಜೆಂಟ್ ಇದೆ.
ಸರ್ ಗುರುಗಳೇ ಗುರುಗಳೇ 15 RFA ಕೊಟ್ಟೆ. ಎಸ್ ಸರ್.
ರಾಘವೇಂದ್ರ ಅವರೇ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದಿದ್ರಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಸರ್. ಪೆಂಡಿಂಗ್
ಬರಿಬೇಕಲ್ಲ. ಒಬ್ರು ಕೊಟ್ಟಿದ್ವಿ, ಏನಂತ ಬರ್ದಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ನಾನೇ ಸ್ಕೂಟಿನಿ ಬರ್ದು ಕೊಡ್ತಿದ್ದೀನಿ. ಹಿಂಗೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರಲ್ಲ. Thank you. Fresh notice.
With your lordship's kind permission.
Yes,
One urgent matter for tomorrow, my lords.
urgent.
My lords, 3 matters have been transferred from the first additional to the 3rd additional at the behest of the complainant. Without an application being filed, without me being heard, and without notice being ordered to me.
Yeah, how you, right to forum illa nammali. Unlike in UK, in India,
Yes.
we have not recognized right to forum as such. Forum change ಆಗೋದ್ರಿಂದ cause of action ಇಲ್ಲ ಅಂತ hold ಮಾಡ್ತದೆ.
That is my grievance, my lords. At his request, these cases have been transferred from one court to a specific court, which is, should not be encouraged. He is a serial litigant, my lords. He's been filed.
ನಾಳೆ.
Lords, I'm the first respondent in this writ petition. As between the arbitration proceeding as between the first and the second respondent has been stayed. The petitioner is a third party who is not at all related to the arbitration proceeding. I request for a date in the coming week, Your Honor. I've informed the
ಯಾವ year complaint?
Your Honor,
ಯಾವ year WP ಯಾವ year?
24.
24. Second week of January.
My lord, in
Any earlier date if I
Yeah,
may.
really it's difficult. ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಪಾರ್ಟೆಡ್ ಎಲ್ಲ ಇಟ್ಕೊಂಡಿರೋ ಅದಕ್ಕೆ ಅದರ್ವೈಸ್ ವುಡ್ ಹ್ಯಾವ್ ಟೇಕನ್ ಅದಕ್ಕೆಲ್ಲ ಬಹಳ ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಟೇಕ್ ಇಟ್ ಇನ್ ದಿ ಥರ್ಡ್ ವೀಕ್ ಆಫ್ ಡಿಸೆಂಬರ್ ಇಟ್ಕೊಳ್ಳಿ ವಿಲ್ ಟ್ರೈ ನಾಟ್ ವೆರಿ ಶೂರ್ ಡೋಂಟ್ ಪಿನ್ ಎನಿ ಹೋಪ್ ಆನ್ ಅಸ್
Okay.
ಓಕೆ
My lord, in WP number 2911 for 2024, my lord, it's WP number. In execution proceedings 5/2024, NBW is issued. I'm under the apprehension of arrest. Kindly may I attend today's
Naale.
call, my lord.
ನಾಳೆ ಹಾಕೊಳ್ಳೋಣ
Please, your lord.
ಸಾರಿ
Your lordships, it's a
Much
matter.
obliged, Your Honor.
Premature transfer, your lordships.
ಪ್ರಿಮ್ಯಾಚುರ್ ಟ್ರಾನ್ಸ್ಫರ್
Premature.
ಯಾವಾಗಾಗಿತ್ತು?
And then your lordship, last it was listed on 2810 and it's an,
ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಯಾವಾಗಿಂದು?
not sure of,
Huh?
not sure of the date. your lord.
ನಾಟ್ ಅವೇರ್ ಆಫ್ ದಟ್.
But
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ.
last it was listed on 2810, your lordships.
2810.
2810, it came before your lordships and you directed that it be listed immediately after service of
Service.
notice. Service of notice has been completed,
noted.
your lordship, so
Service
kindly
ಆಗಿದ್ದು
a
ಒಂದು
date
post.
may be given.
All. Yes, brother.
serial number 19, my lord.
Ah,
I left on next week.
Jay Prakash. 19, huh? ಯಾವ year? 24. All right, week after next. On request, counsel for petitioner, huh? ಬರಿಬೇಕಾ? ನಾವು ಹೇಳಿದ್ರು ನೀವು ನೋಡ್ಕೊಂಡು ಬರಿಬೇಕು.
My lord,
Okay.
serial number 7, my lord.
12,
7, my lord.
7.
Wait.
ಆರ್ಡರ್ಸ್ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಬರ್ತದೆ? ಹೇಳಿ ಏನಾಯ್ತು?
I appear for the appellant. that it
To
appears
comply
that
office
the
objection, my lord,
respondent
a
number-
week time.
I will give you, wait.
Yes.
You need not wait, we will give you. You go.
In the first matter,
Ah,
the respondent number 2 has died. I want to file a LR application. Exact date of death is not known, but
Second
only a few
respondent
months
is
back.
stated to have died, stated to be dead.
My lord,
First,
one-
steps to be taken.
One submission, my lord.
Ah,
On the last date of hearing, my learned friend had filed a memo saying for dispensation of the exhibits D1 to D8 as the same were not available. After the hearing, my learned friend approached me and the copies of D1 to D8 have been provided.
you have provided.
He has given, I will,
ಅದೊಂದು
I
ಹಾಕಿ.
will,
In addition to taking steps, appellant to prepare additional paper book in respect of documents at exhibits,
D1 to the entire.
P1 to P6 and two.
D1 to D6,
D8, my.
all exhibits.
Yes, all
Respect of documents that were produced and marked as exhibits in the court below.
yes,
Okay. Call after 4 weeks. 4 weeks?
4 weeks.
Okay. Yes.
Madam, for,
In this matter, my lord.
for respondent, my lord.
There is some office objection raised on the memo filed by them. Where they
Memo
have
for
reported the
reporting
death of
death.
respondent 4.
Reporting death ಇದ್ದಾಗ ಏನ್ objection ರೀ ಆಫೀಸ್
ಅಲ್ಲ ಅದರಲ್ಲಿ
ಹಾ.
ನಾವು ಹಾಕಿರೋ ಕಾಸ್ಟ್ ಟೈಟಲ್ ನೇಮ್ಗೂ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ನೇಮ್ಗೂ ಮ್ಯಾಚ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ. ಫುಲ್ ನೇಮ್ ಇದೆ, ಇಲ್ಲಿ ಬರೀ ಸಾಲಮನ್ ಅಂತಿದೆ, ಅಲ್ಲಿ GM ಸಾಲಮನ್ ರಾಜು ಅಂತಿದೆ. ಇಟ್ಸ್ ದ ಸೇಮ್
ಹಾ.
ಪರ್ಸನ್.
ಹ್ಮ್.
And I
But death ಆಗಿದೆ.
please, and I have requested the particulars of the legal representatives, my lord, since they were representing them.
You are for appellant.
Please, my lord.
ಯಾರಿಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಿರಿ? ನಮ್ ಕೋರ್ಟಿಗೆ ರಿಪೋರ್ಟ್
The
ಮಾಡಿ.
respondent
And
4
for
has
respondent
filed
number
that.
4, my lord.
He has reported death now.
The death of.
So you have to take steps, sir.
Please, my lord, he was representing them. I have requested the particulars of the LRs of R4. He has said he'll furnish it,
Please,
but
my
take steps.
please, I will furnish.
Counsel for the respondent to furnish material particulars of LRs of the deceased respondent number 4.
4, please, my lord.
Come on. If they are available with him. Otherwise, how we?
They have said then, no,
All.
ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಕೊಡಿ.
Please.
Please.
Office objection. ತೈರಿ ಓವರ್ ರೂಲ್ಡ್. ಡೆತ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಯಾರಪ್ಪ, ಅದನ್ನ ಪೂರ ಹೇಳಿದ್ರು. ಸ್ಟೆಪ್ಸ್
Please, please,
within 4 weeks.
please, man. Please.
ಕುತ್ಕೊಂಡ್ಬಿಡಮ್ಮ, ಅಲ್ಲೇ ವರ್ಕ್ ಕುತ್ಕೊಂಡು ಚಿಕ್ಕ ಆರ್ಡರ್ಸ್. Memo for rectification of cost title, number 3.
Lordship, in this matter,
Imran.
the last.
I appear for appellant, my lord.
Your Lordship had passed it over and they still did not come, and therefore it was kept for this date. Matter of 20 years old, Your Lordship, 2005 suit.
Yeah.
2015, it was, they had filed 3 appeals.
1 second. What do you say, madam?
My lordship, some rectification was there. In the previous memo with amendment of cost title has been
Cost title.
rectified, respond number 6, my lordship.
ಮಾಡ್ಬೇಕಲ್ಲ.
ಮಾಡಿದೆ, memo has been filed.
ಅದಾಗಿದ್ಯಾ?
First time ಏನಾಗಿತ್ತು ಸರ್?
ಹಾ.
1 to 3 of 18 allow ಆಗಿತ್ತು.
ಹಾ.
Respond number ಎಲ್ಲ respond number 6 A to H was allowed to include sir.
ಹ್ಮ್.
ಇದು ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್
ಹಾ.
ಒಬ್ಬರೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ 6A ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಇವ್ರನ್ನ 6 ಅನ್ನ
6, only his wife has come in. They had made the brothers. Your Lordship, the brothers were brought in as LRs. And then since it was incorrect, the wife was brought in.
6A ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿದ್ರೆ ಡಿಲೀಟೆಡ್. ಅದು ಅಲೋ ಆಗಿದೆ ಈಗ. ಅಲೋ ಆಗಿದೆ. ಆ ರೀತಿ ಅಮೆಂಡ್ ಮಾಡಬೇಕಾಗ್ತದೆ ಕಾಸ್ಟ್ ಟೈಟಲ್.
First IA 1 to 3 allow ಆಗಿದೆ. Next ಇರೋ ಸೇಮ್ IA 1 of 22 to 3 of 22 ಫೈಲ್ ಮಾಡಿ. ಅದ್ರಲ್ಲಿ R6A ಅಂತ ಮತ್ತೆ ಬರುತ್ತೆ. ಟೈಮ್ 6A to H ಅಂತ
ಆಗಿತ್ತು. ಮತ್ತೊಂದ್ಸರಿ 6A ಅಂತ ಬರೆಯೋದು.
ಬರೀ 6A ಮಾತ್ರ ಮಾಡೋದು. ಅದು ಬೇರೆ ಪಾರ್ಟ್.
ಅವ್ರು 6 ಬಾಲಾಜಿ. No, this is by LR ಅಂತೇಳಿ. ಇದರೊಳಗೆ ಯಾರು ಲತಾ? ಇವ್ರು ಲತಾ ಎಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲಲ್ಲ. ಮೇಡಮ್ ಇಲ್ಲಿ ಏನು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕು ನೀವು?
Your Lordship, D6.
We have filed a memo ಹಾಕಿ ಮೆಮೊ ನಲ್ಲೇ ತೋರಿಸಿದ್ದೀವಿ.
ಮೆಮೊ ಹಾಕಕ್ ಬರಲ್ಲ. ಇಂಥದಕ್ಕೆಲ್ಲ IA ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
You have filed a affidavit saying that respond number 6 had left behind him 6A to 6E. ಹೌದೇ?
That is deleted. Those were the brothers.
Delete ಆಗಿದೆ. Again, we have filed a memo also with regard to that, and amended petition also we filed, my lord.
ಅಲ್ಲ ಡಿಲೀಟ್ ಹೆಂಗಾಗುತ್ತೆ?
ಆಗಿಲ್ಲ.
Your Lordship, it is his. Your Lordship, no. Might I clarify? There was another application we filed stating that brothers could not have been brought in as LRs since they're not class 1 heirs. And they have conveniently left out the wife is what we brought to your Lordship's notice. So our application for deletion of the brothers was allowed and permission to bring in the wife was also allowed.
When it was allowed?
Your Lordship, this was allowed on IA to delete and LRs was in 2022.
ಆರ್ಡರ್ ಆಗಿತ್ತು.
July this year, Your Lordship.
ಆಯ್ತು, ಅಲೋ ಮಾಡಿಬಿಟ್ರೆ.
If your Lordship grants.
Represent the estate at all. Widow represents.
Widow.
ಹೌದು.
If your Lordship permits, counsel for respondent himself will bring in these, all the amendments, please, all the whatever requirements, because the appellants are never going to do it. It's been pending for 10 years. If your Lordship permits, he will do it so that the matter could be heard, Your Lordship.
Amendment has to be carried
Wait,
out by.
I understand, but they will not.
I have already filed, my lordship. Amended application also has been filed along with the memo, my lordship.
ಸರಿ, ಅದೆಲ್ಲಿ IA ಎಷ್ಟದು? 6A to 6H ಅನ್ನ ಡಿಲೀಟ್ ಮಾಡಬೇಕು ಅಂತ ಬರ್ದಿರೋದು ಯಾವ್ದು? ಅಲ್ಲ, ಅದು IA.
IA number, where is it?
ಇಲ್ಲ.
IA 1 to IA.
This one.
ಅದು ಅಲೋ ಆಗಿದೆ, ಅಲೋ ಆಗಿ 6A to 6H.
We have filed on 15th July.
ಡಿಲೀಟ್ ಮಾಡಬೇಕು.
ಡಿಲೀಟ್ ಮಾಡಬೇಕು.
ಅದಕ್ಕೆ IA ಎಲ್ಲಿದೆ? ಅದಕ್ಕೆ IA ಬೇಡವೇ?
ಬೇಕಾದ್ರೆ ಕೋರ್ಟ್.
ಹೌದು, ಅದು IA number ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
Now we have understood.
Please.
Earlier applications IA 1 to IA 3 were for bringing brothers on record when brothers cannot represent
Correct.
the estate.
Correct.
Therefore, your submission is that widow would represent because she figures in
That was
schedule.
also allowed.
Class
also
1.
Class one.
Therefore,
Huh.
she alone to be brought on record
Correct.
as LR of DC
Correct.
response number 6.
Correct.
6. That is the case.
And those applications are allowed. Even deletion of brothers have been allowed.
ಆಗಿದೆ.
6A to H ಅನ್ನ ತರೋದಕ್ಕೆ 1 to 3 ಅಲೋ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಅಲವ್ ಆದ್ಮೇಲೆ ಅದನ್ನ ಡಿಲೀಷನ್ ಅಲವ್ ಆಗಿದೆ.
ಇದೆ ಅದು.
ಆ ಡಿಲೀಷನ್ ವಾಸ್ ಇನ್ ಅಬೌಟ್
is not
July.
there.
ಇಟ್ಸ್ ದೇರ್.
ಕೊಡಿ ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಒಂದೊಂದ್ಸರಿ ಆರ್ಡರ್ ಶೀಟ್ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಲ್ಲ.
Your Lordship, in this, there are 2 appeals and 1 MFA, so probably there is some
Wait.
ಮತ್ತೊಂದೊಳಗೆ
ಅದೇ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಆಯ್ತು.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇರ್ಬೋದು. ಇನ್ನೊಂದು MFA ನೂ ಇದೆ ನೋಡಿ, ಕ್ಲಬ್ ಆಗಿದೆ ಅದ್ರಲ್ಲೂ. ಇಟ್ಸ್ ಹಿಯರ್.
ಎಲ್ಲದರಲ್ಲೂ ಸೇಮ್ ಪಾರ್ಟಿ
Permitted to delete, ಇಲ್ಲಿದೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ.
Same parties, my lord.
ಹಾ, ಅವರೇ ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಅಪಲೆಂಟ್ 1B to 1I ಅಂತ ಅದು 1A ಅಲ್ಲ.
I clarify, my lord. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ IAs ಎಲ್ಲ ಅಲೋ ಆಗಿದೆ, ಈವನ್ ಬ್ರದರ್ಸ್ ಡಿಲೀಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ 6th ರೆಸ್ಪಾಂಡೆಂಟ್
ಯಾವ್ದ್ರೊಳಗ ಬೇರೆದ್ರೊಳಗ ಆರ್ಡರ್ ಮಾಡಿಸಿದಿರಿ, ಇದ್ರೊಳಗ ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ಇದ್ರೊಳಗೆ B
ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಏನಾಗ್ಬೇಕಂದ್ರೆ
ಇದ್ರೊಳಗೆ A to H.
6 LRs ಮಾತ್ರ ವೈಫ್ ಅನ್ನ ಬ್ರಾಟ್ ಇನ್.
15 ನಿಮಿಷ ಆಗಿದೆ ಇದು ಕೇಸಿಗೆ. ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ 1 ನಿಮಿಷದಾಗ
It is noticed that in the RFA 848 of 2015, in the place of deceased respondent number 6, his brothers were brought on record as 6A to 6H. And the IA 1 to 3 of 2018 came to be allowed to that effect. Later, another application is filed stating that he said the respondent number 6A to 6H being brothers are not the legal heirs as per schedule 1 to the Hindu Succession Act, and therefore only the widow would be the legal representative. Corresponding application was filed in connected matters, but in that it was appellate number 1B to 1I. Such order is not reflected in the present RFA number 848 of 2015. Therefore, next paragraph. Therefore, the order passed in WP 799 of 2015.
UP ಎಲ್ಲಿಂದ ಬಂತು?
ಅದು WP ನ RFA.
RFA. 2 RFAs, 1 MFA.
Of 2015, deleting appellate number 1B to 1I would also inure to the corresponding respondent in RFA number 848 of 2015 also.
MFA.
And MFA number
4414.
also. Corresponding amendments to be carried out by the appellants in all these matters.
Your Lordship, time frame, Your Lordship, 20 years he's
Within,
been waiting.
within 2 weeks.
Date.
Much obliged.
2 ವಾರದಲ್ಲಿ ಅದು ಕರೆಕ್ಟ್ ಇದ್ದನ್ನ ಅದನ್ನೆಲ್ಲ ಹಾಕಿ.
List. Okay, on
Much
date
obliged.
time. December ಅಲ್ಲಿ.
ಹಾ?
December ಅಲ್ಲಿ on
ಅದ್ನ
date.
ಮಾಡ್ಲಿ ಮೊದಲು, ಆಮೇಲೆ ನೋಡು.
Obliged.
Much obliged.
ಆಫೀಸ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಎಲ್ಲ ಇವರು. ವೇಸ್ಟ್ ಮಾಡಿ. ಎಸ್ ಟೈಮ್ ಹೋಗುತ್ತೆ ಎಲ್ಲ ಇಂಪಾರ್ಟೆಂಟ್. ಎಸ್
Respondent number 2, my lords. Pray for time for furnishing PF.
Time for?
Furnishing fresh process in respect of R1 A and C.
For R1 A and C, I undertake to file wakalat, my lords. I'm already on record for respondent number 2 and R1 B. For 1 A and C, I undertake to file wakalat.
R1 A to C.
R1 A
For
and C.
A and C.
A and C.
1 B, I'm already on wakalat.
Third counsel Ismail M. Musba appearing for respondent number 1B. And it takes to appear for respondent number 1A and C as well. ಅಲ್ಲಿಗೆ ಏನ್ ಹೇಳ್ತೀರಿ?
ILR application.
3 ಏನ?
3 IAs.
I heard both sides on IA 1 to 3 of 2020. The delay of having satisfied with the contents of the affidavits filed in support of these applications regarding the delay and setting aside the abatement, applications are allowed. And the delay of 284 days is condoned, but abatement set aside. 1A to 1C are ordered to be brought on record. Going to carry out the necessary amendment within 2 weeks. And file the amended cost item within 2 weeks.
ಅಮೆಂಡ್ಮೆಂಟ್ ಇಲ್ಲೇ ಮಾಡ್ಬಿಡಿ. ಆಮೇಲೆ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿ ಎರಡನ್ನೂ ಮಾಡ್ಬೇಕು. ಓಕೆ. Then Rao's name will be
Rao, he deleted and the name of Sri Balakrishna Shastri alone.
For petitioner notes.
And for the R4, you will have second set of the copy.
ಸೆಕೆಂಡ್ ಸೆಟ್ ಇವಾಗ brought now. ನೋಡ್ರಿ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ. ಜಸ್ಟ್ ಹಂಗೆ ಚೆಕ್ ಮಾಡಿಕೊಳ್ಳಿ ಸರ್.
Objections.
One set.
In this case, my lords, I moved the memo before this honorable court. As earlier, the matter was listed before this honorable court on 29/10/2024.
Are you ready in the matter?
Yes, my lords.
But ready?
Monday, Monday, your worship.
My lords, now the petitioner has been terminated.
Monday.
In view of the, as this,
Madam is asking for 1 week. You
Monday.
should be kind to
let
sister.
the petitioner may be taken the duty, my lords, because
Next week, the request.
Monday.
Yes. Memo.
There is one small office objection, my lord, which I have complied yesterday.
Apply ಮಾಡಿದ?
For the respondent.
Yes. Counsel for the petitioner says, and we agree that the office objection is complied with. Now, yes, brother, what is this matter?
My lord, this is relating to the child care leave, my lord.
Huh?
Child care leave,
Child care leave,
leave.
like maternity leave type.
Maternity leave is
Post-maternity.
different, child care leave is different. After maternity leave, the child care leave under Rule 43C of the Central Services, it has been incorporated. Under that rule, child care leave can be granted 730 days for the entire period of the service of the employee.
Okay.
My lord, what has happened? Any leave for that matter, my lord, my first submission is it is not a matter of right.
It depends upon the text of the rules.
Correct.
You can't say,
Then, my
now
lord,
it's a matter of right.
no, my lord, any leave for that matter, my lord, it depends upon the exigencies.
It depends upon the instrument of law.
Exigencies. Then, my lord, what has happened? Mine is an institute, which is a hospital, deals with the psychiatry and as well as the neurosciences, which is a special institute for the entire nation, not only for the nation, for the entire
Bench.
Asia. Then, my lord, this respondent was a nursing officer who was required to work in ICU in the neurosciences department, which is very, very crucial and important for the institution. She goes on maternity leave and afterwards, without even giving any intimation, she take it as a granted as the child care leave that I am entitled to under 43C, which was rejected by the competent authority because of the exigencies. My lord, what happens is, in an ICU,
How is the text of that rule? And any health issue with the child?
Please, my lord.
Health issue with the child?
no, my lord, what is?
Read the rule.
Yes, my lord. 43, I have incorporated in
Read
the
the rule,
in the
read.
writ petition itself, my lord, page 5,
Is 5.
page 5 in the writ petition.
With effect from which date it is incorporated?
But this has come into force, my lord,
under the CCA rules, 43C, my lord.
You're not answering the question.
Let the date, my lord. My lord, I will give the little date, my lord. May I read the para number 6, my lord?
All right.
My lord, para number 6, my lord, in the writ petition, I have extracted 43C, which is not.
Do you agree with the text of this rule? Is there any change which he has reproduced at page 5, in page running page 5? If you dispute, then we will go to the book.
That's not the entire text. I'm just.
In fact, tribunal also has extracted that.
Come to 6.3. Paragraph 6. Rule.
Rule 3, my lord.
That one, na? Roman small
The
3.
Roman sheet.
Ah,
My lord, it shall not ordinarily be granted during the probationary period itself.
Therefore,
Therefore,
to them, no question of right.
yes,
For rest of the people, it's right.
yes.
She a probationer?
She was not. She was a confirmed officer and working in the ICU, and she did not even report after maternity leave, and she takes the leave.
What the court has said.
Yes, my lord.
Hey, patient. Patient.
Then, my lord, para number 11, page number 26 of the CAT order, my lord.
Para 11,
Yes, my lord.
page 26.
Page 26. My lord, the tribunal goes on quoting the judgments without even verifying the facts of this case and grants the relief, saying that she is entitled to the child care leave. That's what, my lord, where I stand.
What is the health issue of the child?
Nothing, my lord, only breastfeeding, my lord.
Huh?
Breastfeeding.
My lords, the.
My lord, can it be a right?
We are asking him.
Yes,
You-
I'm sorry, I'm sorry.
My lords, the.
Breastfeeding, we say, right to breastfeed and right to be breastfed are fundamental right. We have held that way.
That we have read.
My lords, at page number 58, my lords, is the representation. He has detailed as to why he has availed this CCL leave, my lords. He says that.
How many years of service you have put in?
My lords, he has been in service since 2015.
2015,
Please.
16.
16.
any disciplinary inquiry against
No,
you?
my lords. And she
No
has never, this is
disciplinary?
the first time she has availed childcare leave also. my lords.
Only one child?
One child.
No adverse remarks in service records?
No. But the problem here is this, my lord, if your lordship permits, I will make submissions. The child care leave, my lord, even though 43 says that it can be taken by way of 3 spells and the total number of days, 713 a year, all those things are not disputed. The problem here is, in the name of the child care leave, an employee who works in an important
In
place,
ICU, you said that.
ICU, very, very important. In ICU,
How many, in ICU, how many employees you
yes,
have?
I have also followed that. May not may kindly see this.
Yes, tell us.
Yes.
How many employees are there?
Yes.
Nurses are there in ICU?
Yes, yes. Let me kindly come to page number 12 of the.
To answer our question.
Yes.
Don't make us to turn page after page. That's not our job. We are
Yes, ma'am.
asking you.
Yes, ma'am.
How many employees you have in the ICU?
Yes, madam. There are 773 nursing staff, out of which,
One second.
yes,
773.
nursing staff.
What is the bed capacity of your hospital?
Well, out of that, the beds capacity, my lord, in the ICU, that I have to ascertain it.
All right. Next, what you were
Then,
saying.
my lord,
something.
out of which more than 70% are female staff, my lord, out of this 773.
Because it is always see, ಈ ಮಕ್ಕಳನ್ನು ನೋಡಿಕೊಳ್ಳೋದು ಮಾಡೋದು ದೈವದತ್ತವಾಗಿ ಹೆಣ್ಮಕ್ಳಿಗೆ ಬರುತ್ತದೆ, ನಮ್ಗೆಲ್ಲ ಬರಲ್ಲ ಅದು. ಅವ್ರಿಗೆ ಅದು ಸ್ಪೆಷಲ್, ಇಟ್ಸ್ ಎ ಬರ್ಡನ್, ಇಟ್ಸ್ ಎ ಬೇ, ಇಟ್ಸ್ ಎ ಬೇನ್ ಅಂಡ್ ಇಟ್ಸ್
Correct, my lord. That I agree with that. Then, my lord,
773 ಜನರಲ್ಲಿ
ah,
ಈ ಒಬ್ಳು ಹೆಣ್ಮಗಳು ಹೋದ್ರೆ,
Ah.
how is that your institution?
no, nursing, I have only said nursing staff. Out of that, my lord, more than 70% are female staff, that is numbering 543.
Yeah.
Then, my lord, in CCL, that is this thing, the administrative challenges arising out of the long CCLs, that is child care leaves, unauthorized options of nursing officers, and annual resignations of nursing officers are required to be considered while deciding the granting of the CCL. my lord.
Correct.
There are rules for that separate.
How many had applied for resignation?
I have already produced the, my lord. My lord may kindly see these, the circular, my lord, with respect of CCL, which is relevant, my lord. If your lordship sees that,
We are agreeing with your circular point,
yes, my lord.
but you are not, you are uncircular in answering our question.
What is?
How many candidates had applied for resignation? How many had applied for leave during the said period? One mother going to feed the child, and the UN conventions are there. The child rearing arises under the United Nations conventions, to which India is a signatory. You have to read all these things, because Keswananda says all international conventions to be read into our Indian law unless they are contrary to domestic law. ಎಲ್ಲಿದೆ ಆ ಟೈಪ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಎಲ್ಲಿದಾವೆ? ಏನು ಇವರು ಇಲ್ಲ, ಅವರು ಇಲ್ಲ.
ಅಲ್ಲ, ಒಂದು
Hello, I have raised that.
UN convention you have placed that.
Please, madam.
Where is that?
Hello, page 77, it's
77.
part of my rejoin the madam.
You are right. I withdraw my comment as against you. 77. Yes, infant and young child feeding. Do you have that judgment where I said breastfeeding is fundamental right? Right to be breastfed is also a fundamental right. Do you have that judgment?
I don't have it at me right now, but I will use that.
My lord, what happens is this. If you look at the conduct of this employee, forget about that, my lord, as general, what your lordships have observed is right. That once the employee comes and says that I have to give the breastfeeding, that is, of course, my lord, it is recognized by even WH also. I am not on that point. Whether the child care leave can be taken merely because provision is there, irrespective of the hospital suffering with respect of the patient.
Treat the suffering, that you are not telling us.
Yes, my lord.
Which patient ran away from ICU and attacked other people, that any persons generally with psychotic.
That is related to the administration. My lord, may kindly see, may I request your lordships to take page 58. What is our representation with respect of child feeding? If your lordships understand this, my lord.
We'll
my-
try to understand, no
Yes,
problem. But
Page number 58. Request for sanctioning the child care leave for taking care of my infant daughter from 14/1/2023 to 14/5/2023. Then, my lord, she explains in the para number 2, my lord, if your lordships permits,
Inter-caste marriage namdu, ತಂದೆ ತಾಯಿ ಕೇರಳದಲ್ಲಿ.
then I have to take care of my husband. My lord, if every employee goes with the personal
Which,
reason.
how many employees have gone this way in the last 5 years? Therefore, we asked you, when the rule was amended.
That date I will give, my lord. That's not.
ಈಗ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗತ್ತೆ ಈಗ ನಿಮ್ದು.
ಅಲ್ಲ, that date I will give.
ಟೈಪ್ ಕೊಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ, ಈಗಲೇ ಹೇಳ್ಬೇಕು.
Yes, sir.
ಎಲ್ಲ ಇದೆ ಅಂತ. ಇಷ್ಟು ವರ್ಷದಲ್ಲಿ ಎಷ್ಟು ಜನ ಎಂಪ್ಲಾಯೀಸ್ ತಗೊಂಡಾರಪ್ಪ, ಎಷ್ಟು ಜನ ಓಡಿ ಹೋಗ್ಯಾರಪ್ಪ?
ಅಲ್ಲ.
ಅದರಿಂದ ನಿಮ್ಗೇನ್ ತೊಂದರೆ ಆತಪ್ಪ? All these things are relevant factors, because breastfeeding is a fundamental right, because right to be breastfed is part of Article 21 we have held, affirmed by the Supreme Court.
My lord, 43C, when it came into existence, that is not disputed, and I will give the date, my lord. That is not an issue.
ಬಿಡಿ, 3 ಸರಿ ಆಯ್ತು, ಈಗ ಕೊಡ್ತೇವೆ ಅಂತ ನಮಗೆ ಕೊಟ್ರೆ ಆಯ್ತಪ್ಪ. ನಾವು ನಿಮ್ಗೆ ಲಾದ ಬಗ್ಗೆ ಕೇಳುವಾಗ ಮಗು ಪೆಪರ್ಮೆಂಟ್ ಕೇಳತ್ತಲ್ಲ, ಹಂಗೆ ಕೇಳ್ತಿರ್ತೀವಿ. With lot of drooling.
Yes, yes.
Take out that judgment.
Please, madam.
Say that Krishna Dikshit on breastfeeding rights. Go to Google. Research ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. Research ಕಲ್ಚರೇ ಇಲ್ಲ ನಮ್ಮಲ್ಲಿ, ಬಾರಿಂಗ್ 1 or 2. ಆಲ್ ರೈಟ್, ನಿಮ್ಗೆ ಸಿಗ ಹೋಗ್ಲಿ ಬಿಡಿ. ನಾವು ನಿಮ್ಮ ಫಸ್ಟ್ ಕಂಟೆನ್ಷನ್ ಏನು?
My first concern.
Not as a matter of right.
Not as a matter of right. And I have issued circular to all this staff which is at R2 Millard, page 69 of the writ
ಏನಂತ?
papers.
ಏನಂತ ಸರ್ಕ್ಯುಲರ್? ಯಾರು
69 Millard.
ಏನಂತ ಹೇಳ್ರಿ?
69, I have produced general conditions for the right to live, which is in the conduct rules. It is there. My lord, may kindly see the.
Well, the CAT has discussed about that. Your circular, CAT said, when I read yesterday, the CAT said, your circulars cannot override the statutory rules of the one paragraph.
But for that, my submission is this, my lord. My circular deals specifically with respect of how to maintain the ICU with the staff which is available who are trying.
Where have you stated? Because she went, we have suffered, ICU suffered. Yelli the contention.
My lord, kindly see.
ಅದು ಒಂದು ಹಿಪೋಥೆಟಿಕಲಿ ಹೇಳಿಕ್ ಆಗ್ತದ. 773 ಜನ ಇದಾರೆ ಅದರಲ್ಲಿ ನಿಮ್ಮಲ್ಲಿ.
ಅಲ್ಲ, ಒಂದೇ ನಿಮಿಷ. Kindly come to page 68, my lord, my circular.
ನಮ್ಮನ್ನ ಪೇಸ್ ತಿರುಗಿಸ್ತೀನಿ ಅನ್ನೋದು ಬಿಟ್ರೆ.
ಇಲ್ಲ, ಒಂದೇ ನಿಮಿಷ.
ಮಾರ್ನಿಂಗ್ ವಾಕ್ ಮಾಡ್ಬೇಕು, ಮೇಲೆ ಪೇಸ್ ತಿರುಗಿಸ್ಬೇಕು ನಾವು. ಅದ್ ನಾವು ಕೇಳೋ ಪ್ರಶ್ನೆಗೆ ಒಂದು ಉತ್ತರ ಕೊಡಲ್ಲ ನೀವು.
ಇಲ್ಲ, ಇದರಲ್ಲಿ
68 ಸರ್ಕ್ಯುಲರ್.
Yes, ma'am.
ಏನಂತ ಹೇಳ್ತೇವೆ ಸರ್ಕ್ಯುಲರ್?
Kindly see this, my lord. This has been done.
Which provision comes to your aid?
My aid, my lord, the para number 5.
5. CCL is restricted to, CCL ಅಂದ್ರೆ ಏನು?
Child care leave. Child care leave.
Child care leave is restricted to 5% of women employees in any section, department, keeping in view the staff available after consider. All right. ಇದು ಎಷ್ಟು ಯಾವ ಪರ್ಸೆಂಟ್ನೇ ಬರ್ತದೆ ಇದು?
5% ಒಳಗಡೆನೆ ಬರ್ತೀವಿ.
ನಿಮ್ಗೆ
ಅಲ್ಲ, ಅಂದರೆ 5% I have to maintain that in order to maintain my strength in ICU, my lord.
ಅದು ವೈಲೇಟ್ ಆಗಿದೆ ಅಂತ ಎಲ್ಲಿದೆ ಕಂಟೆನ್ಷನ್? 5% is violated. ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ದಲ್ಲಿ ಎಲ್ಲಿದೆ? ಅಲ್ಲಿ CAT ಮುಂದೆ. Her case falls outside this limit ಅಂತ ತೋರಿಸಿ. Where have you taken up that contention? ಬೇರೆ ರೂಲ್ಸ್ ಗಾಳಿಯಲ್ಲಿ ಓದಕ್ಕಾಗ್ತದ?
ಇಲ್ಲ. ನಾನು kindly come to page 63, my lord, para 4.
63.
Yes.
Para 4.
Para 4. The applicant, after availing 180 days of maternity leave, did not report back to duties. Instead.
ನೀವು ಹೇಳಿದ ಗ್ರೌಂಡ್ ಇಲ್ಲ.
ಅಲ್ಲ, ಬರ್ತೀನಿ ಸ್ವಾಮಿ. Let me read that paragraph which contains that.
ನೀವು ನಿಮ್ಮಷ್ಟು ಟೈಮ್ ತಗೊಳ್ಳಲ್ಲ ನಾವು ಓದ್ಲಿಕ್ಕೆ.
ಅಲ್ಲ, my lord.
ಓದಿದ ಮೇಲೆ ಹೇಳ್ತಾ ಇದೆ.
ಅಲ್ಲ, this 120 days in this paragraph.
ರೂಲ್ ಇನ್ವೋಕ್ ಆಗ್ಲಿಕ್ಕೆ ಬೇಕಾಗೋ ಫ್ಯಾಕ್ಟ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇಲ್ಲ. I don't need much time to read these things. Really, very humbly I say. I read at least 10 times faster than you.
Yes,
very humbly I say this.
Lord, I have said in this paragraph, my lord, in the objection statement, that at the time of applicant's request, 2 nursing officers who were working in EICU had resigned. And
5% nodri, simple arithmetics. Now I will take you to the mathematics.
Were conceived. As a result,
brother,
total
I am agreeing with you. Still, it does not fit into 5. Let us go to arithmetics now. We'll test our mathematics now. Kindly come to, sorry, judgment put on. 773, the 5%. Rough estimation, I carry on. 700 ಕ್ಕೆ ಎಷ್ಟಾಗತ್ತೆ ಹೇಳಿ? ಮುಂದಿನ 73 ಬಿಡಿ.
700 total staff, ICU, not ICU.
ನೀವು ನಿಮ್ದು ICU ದಲ್ಲೆಲ್ಲನ?
ಅಲ್ಲ, total staff is 700.
ಅಷ್ಟು ಹಾಕೊಂಡು ಬರೋದು. Simple arithmetics.
I will get.
Though it is alleged our Karnataka High Court does not know arithmetics well in Jayalalitha's case. Anyway, now we can disprove that.
I will clarify.
Yenilla, brother. Yenilla. These are rights. See, entire world is seeing feminist movement now. A lot many legislations, lot many political declarations, many UN conventions are animated by feminist movement. Feminist movement, we have amended CRPC for bail condition, etc. We said for women, the bail condition should be like this. Because feminist movement, animates the legislative instruments. ಹಂಗಾಗಿ ಏನ್ ಮಗುನು ಏನೋ ಎಲ್ಲೋ ಓಡ್ ಹೋಗಿದ್ಬಿಟ್ಟು ಆಮೇಲೆ 2016 ಇಂದ ಯಾವುದೇ ಅಡ್ವರ್ಸ್ ರಿಮಾರ್ಕ್ ಇಲ್ಲ. ಒಂದೇ ಮಗು ಇದೆ ಈಗ.
ಈಗ I am not on that point whether she has committed any act of misconduct or remarks. The problem for me is how to maintain my institute.
ಒಬ್ಳು ಹೋಗಿದ್ದು ಎಷ್ಟು ಜನರಿಗೆ ಕೊಟ್ಟರೆ ಎಷ್ಟು ಜನ ಕೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ನಾನು ಪ್ಯಾರಾಗ್ರಾಫ್ 4 ಅಲ್ಲಿ ನೀಟಾಗಿ because so many people have resigned and if you are also going, my work will get affected. Therefore,
ಅದಕ್ಕೆ ಎಷ್ಟು ಜನ ರಿಸೈನ್ ಮಾಡಿದ್ರಪ್ಪ?
Milord, as on 13/1/2023. 31.
Statistics ಇಲ್ಲ. How many had resigned?
Child care leave 4, Milord.
ಎಷ್ಟು ಜನ?
4 people.
4 people. When they resigned?
That is on 31/2023, when she went on leave for 120 days.
4 were on leave.
Yes.
Out of 773, it becomes.
No. Out of the people, those who were working in CCU.
ಅವರಲ್ಲಿ ICU ದಲ್ಲಿ ಎಷ್ಟು ಜನ?
ಅದಕ್ಕೆ ಹೇಳ್ತೇನೆ.
ICU ದಲ್ಲಿ ಎಷ್ಟು?
ಬ್ರದರ್, ಇಷ್ಟು ಟೈಮ್ ನಮಗೇನಿಲ್ಲ, ನಾವು ಪೇಷಂಟ್ಲಿ ನಿಮ್ ಹಿಂದಿನವರಿಗೆ they get agitated. ಎಷ್ಟು ಟೈಮ್
I will get
ಜಡ್ಜ್ಗಳು ಈ ಸಣ್ಣ ವಿಷಯ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ.
Milord, can I make one submission? I will answer all lordship's questions. Milord, kindly have this matter next week, Milord, with all the details.
Heard, rejected, reasons to follow. Yes, next. ಅಲ್ಲೇ Marco. Mention the fundamental right to breastfeed and
out of
be
total.
breastfed. Ruling that decision.
One submission.
Mention about UN conventions on about the feminist movement. All right. Complete statistical data for invoking para 5 or 6 of circular. Para 5 of circular, not forthcoming from the pleadings. First, nature itself has placed women arguably in a disadvantageous position, and more so when it comes to breastfeeding mothers. Semicolon. Man should not add to that. First off, the right to child care leave, CCL, cannot be said to be no right at all. Such an argument would make the employer a despot, contrary to the idea of welfare state, and model employer in terms of Bhupen Hazarika versus state of Assam. Rejected. Next. All right. We have 5 days to give our reasons now because of the apex court judgment. Rejected. Yes. Next. Do you have anything to say to this?
If I may just pass on one judgment of the Honorable Supreme Court.
Good. Idra ಬಗ್ಗೆ ಏನ ಇದೆಯಾ?
That's para 7.
About child care, right?
Yes.
Para 7 of judgment to be discussed.
My lords, I'm sorry.
In,
it's not a final.
Shalini Dharmini.
My lords, it's not a final order, but these are the observations made by the Honorable Supreme Court. In
Para
7, my lords.
Seven. This is reproduction of something in the final judgment. Get that judgment. Get that judgment. This is reproduction of another judgment.
I'll produce.
Refer to para 7. Get that judgment. And give all UN conventions on breastfeeding and right to be breastfed and child care also. What about Vega?
I'll
learn more. Dictations, otherwise, not a week. Yes, next. Sir, we consider everything. You will be happy after reading our judgment.
Not only
every aspect.
The out of that, my lord, child care leave, I have stated in my objection statement very clearly, not only the breastfeeding. Kindly see this, my lord. The personal problems of the employees.
Personal and the child care is someone padadu.
Although, see, that was one of the reasons he gave the representation, saying that my husband is away.
Representation of the employee to be referred to. Okay.
That
next.
That there are two contentions.
27 is ಅಷ್ಟೇ. Next. Not RS, yes.
Serial number 7, my lords.
12 days for compliance, failing which petition stands rejected.
Grant me 1 week time, your lordship. Grant me 1 week time, your lordship. I'll comply the office.
Yena compliance,
14(8), I have complied the office objection. Again, the office has raised the objection, your lordship.
entry objections. Important matter. Respond number 1 and party matilva?
We have made a party, your lordship.
Huh?
We have made a party and we have
Name a party, kudi.
the copy of the statement of the objection of the annexure filed by the KGL, if any is furnished, annexure to be shown before the respondent number 1 before the KGL not made a party.
Compliance ಮಾಡಬೇಕು. Compliance within 1 week, failing which petition stands
Kindly.
rejected on that ground per se.
Kindly.
My lord, in this case, my lord, I am for the petitioner.
N. Shankarappa.
And that annexure can be overruled, my lord, because it's attendance register, it's just only reference, my lord, it has produced.
Office objection being insignificant, on request it is overruled. Yes.
Date be kindly fixed, my lord.
Yeah,
I'll argue.
date
Like,
fix
it's a
ಮಾಡೋದು
simple
ಏನು?
issue, my lord, simple,
Petition ಗೆ ಬಂದಿದೆ.
simple issue, my lord.
Ah.
The husband of the petitioner has died died, my lord, due to heart attack. He was working as in, my lord,
ಕೂತಾಯಿ. ಕೆಳಗೆ.
he was working as a government servant, as a driver, in the respondent department. But after that, my lord, he has filed an application for appointment of, my lord, compassionate.
Compassionate.
My lord, that application has not been considered. My lord, on the other hand, my lord, they have asked me for clarification. One Sujata is there in the service register, name of the Sujata is fine. Then I have given clarification. I have also called as a Sujata and all. My lord, I have given clarification to the department. My lord, even then they did not take any action against that. Therefore, my lord, I have filed a writ petition before this honorable. This honorable for writ of mandamus, since my application has not been considered. This honorable court, my lord, has given reserving liberty for me to file an application before the KA. Because at the same time, my lord, this honorable court has directed to you consider the application in full fledged. But I filed an application before the KAT. KAT, my lord, honorable KAT has allowed my application, directed the respondent, my lord, consider my application on merits. Lord, without considering the application on merits, Lord, I have produced 26 documents saying that I am the wife and son of the deceased Narasimhappa. Widow. I have produced 26 documents before the authority. Even without referring the single documents, my lord, my application was rejected
On what?
on the ground that, Lord, the rival claimants is there. The name of Sujata is shown as in the service register, and she has produced survival certificate before the authority. Well, survival certificate.
ಆ ಸುಜಾತ ನೀವು ಇಬ್ರು ಒಂದೇ.
ಅದು ಫಸ್ಟ್ ಟೈಮ್ ಅದು ಸುಜಾತ ಬೇರೆ.
ಬೇರೆ.
Sujata from Sadali, not from the Chilgata district. But my husband is from Tulunuru, Tikolali post. But all the 26 government documents, including the appointment letter, stands in my name.
ಯಾವ್ಯಾವ
Tulunuru, Tikolali post.
ಯಾವ್ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯಾವ್ದು?
Documents, one, you lost me kindly annexure 1, 2. All invitation card, photos, appointment letter, birth certificate, rental agreement, caste certificate, income certificates, Aadhaar cards,
ಎಲ್ಲ
transfer
ನಿಮ್ಮ ಹೆಸರಿಗೆ ಇದೆಯಾ?
certificates, insurance, even insurance also, my lord, I have produced. Insurances, medical family, even the medical report, death certificate of my lord, I have funeralized in my funeral, death certificate is issued in my name. All the documents I have produced, even survival certificate also I have produced. Instead of, my lord, not even a single document have been considered while recording the reasons. My lord, you let me kindly see it, page number 20.
ಮಕ್ಕಳಿದಾವ?
Yes, sir.
ಆ ಸ್ಕೂಲ್ ನಲ್ಲಿ ಯಾರ ತಂದೆ ಹೆಸರು?
T.N. Narasimhappa from Tulunuru, 980. All the documents.
ತೋರಿಸಿ.
Annexure, my lord, you let me kindly see. Annexure.
ನೆಕ್ಸರ್ ಒಂದು 50 ನೆಕ್ಸರ್ ಇದೆ. ಯಾವ್ದೊಂದು ಹೇಳಿ.
Well, you let me kindly see. The annexure A6, my lord, page number 64.
What do you say?
Lord, service record is very important, Lord. Here the name of the nominee is Sujata.
Nominee is for the purpose of, we have held, nominee is for the purpose of receiving the terminal benefits, not for a compassionate appointment. Question is, under rule 13 yavudu nomination ಯಾವ rule ಕೆಳ ಮಾಡ್ತಾರೆ 13 yavudu, that is only for the purpose of handing the terminal benefits to the family, because ಆ ground ಮೇಲೆ daily ಆದ್ರೆ family will die of starvation, vagrancy, etc. ಆ ಕಾರಣಕ್ಕೆ ಮಾಡಿದಾರೆ ಅವರು. But he has produced transfer certificate ಇದೆ, ಎಜುಕೇಶನ್ ಅಡ್ಮಿಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಲ್ಲಿ ತಂದೆ ಹೆಸರು ಮೆನ್ಷನ್ ಮಾಡಿದೆ. ಯಾವುದೋ ಒಬ್ಳು ನಾನ್ ರೈವಲ್ ಕ್ಲೈಮೆಂಟ್ ಅಂತ ಬಂದ್ರೆ, ಯು ಶುಡ್ ಆಕ್ಟ್ ಅಪಾನ್ ವಾಟ್ ಎವರ್ ಗವರ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇಸ್ಡ್ ಅಪಾನ್ ಎ ರೀಸನಬಲ್ ಪರ್ಸನ್, ಎ ಪರ್ಸನ್ ಹೂ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಇನ್ ದಿ ಆರ್ಮ್ ಚೇರ್ ಆಫ್ ದ ಅಥಾರಿಟಿ. ಇವನ್ನೆಲ್ಲ ಒಂದ್ಸರಿ ನೋಡ್ಬೇಕು. ಪ್ರೈಮಾ ಫೇಸಿ ಹಂಗ ಅನಿಸ್ತು ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಕಂಪ್ಯಾಷನ್, ಅವರಿಬ್ಬರು ಫೈಟಿಂಗ್ ನಲ್ಲಿ ಜಾಬ್ ಇಲ್ದಂಗಾದ್ರೆ ಹೌ ದಿ ಫ್ಯಾಮಿಲಿ ವಿಲ್ ಸರ್ವೈವ್. ಅಲೋ ಮಾಡ್ಬೇಕು.
I'll take instructions. Also. I'll take instructions. Service records.
When are you telling that?
Next week.
They are trying to give the appointment for the Malad others.
In the meanwhile, call this matter week after next. In the meanwhile, no appointment shall be granted to anyone under the claim in question.
Was the family issue also, my lord? Divorce petition was also filed.
If you are ready, argue.
Yes.
If you want time, don't argue. Notice, AG is requested to accept notice for. But the admission still ಕೊಡುವಂತ ಪದ್ಧತಿ ಇಲ್ಲ ನಮ್ಮಲ್ಲಿ. Translation, etc. dispensed with. Which this one? Tomorrow. All right, call tomorrow. Next. One day ಕೇಳ್ತಿದ್ದಾರೆ ಅವರು ಪಾಪ. All objection, call next week. Yes. Next week. Next week. Next week.
Tomorrow. Objection.
Sir, nothing will happen within 1 week. ನಮಗೂ ನಾಳೆ ಏನೇನು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ?
ಇಲ್ಲ, ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಸರ್. Tomorrow.
Next week. Next.
Tomorrow kindly.
Next week. Next week. Yes. Yes, I.
ASG has been nominated to argue this case.
Better. You are not in the panel now.
No, I am on the panel, but I am on record. But ASG has been.
You are in the panel.
No.
You are not. You want to, your name is shown?
I have retired, there is a court order.
Why they permitted you to retire? You are a permanent counsel for a certain.
The government of India doesn't want me.
No. Government will always want you. You have been there right from the days when Babar came to India.
ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ ಟೈಮ್ ನಿಂದ
1526 AD. ಏನ್ ಮಾಡ್ಬೇಕು ಪ್ರಸಾದ್ ಇದರಲ್ಲಿ?
6186. Only my nomination is not withdrawn.
11.4 million. Department has not collected the file from his office.
ಅವ್ರು ಒಂದ್ರಲ್ಲಿ ಇದಾರೆ ಇನ್ನು.
But he is facing difficulty. Already communicated, but they have not come in to collect the file.
I have communicated saying that please collect the file. They have not come.
Start ಮಾಡಿ 2015 matter. You start ಮಾಡಿ. You are on record.
But
Call ASG.
No. Department already nominated by ASG, my lord.
Alright,
Please,
ask ASG to come.
2
15
weeks.
matter.
2 weeks, my lord.
Why? ಏನ್ ಎಷ್ಟು ಸರಿ ಓದ್ಬೇಕು ನಾವು ಇದನ್ನೆಲ್ಲ?
ಇಲ್ಲ,
ಓದಿ ನಮ್ಮ ಲ್ಯಾಂಗ್ವೇಜ್ ಲಾ ಎರಡನ್ನೂ ಪೊಲ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ತೇವೆ.
Any next week at least. 2 weeks ಕೊಟ್ರೆ.
Why you have withdrawn Prasad's?
No, my lord, it is up to the department. I am not.
ಅದೇ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅನ್ನೇ ಕೇಳಿದ್ ನಾನು.
ಇಲ್ಲ, ಜನರಲ್ ಏನಾಗಿದೆ, ರೈಲ್ವೆ ಪ್ಯಾನಲ್ ಅನ್ನ they have abolished and withdrawn all the cases from there. That is the.
ಅದು ಒಂದ್ ಯಾವ್ದೋ ಕೇಸ್ ನಲ್ಲಿ ಇದಾರೆ ಅವ್ರು ಇನ್ನು. All right. Reluctantly adjourned by 1 week. 1 week.
Covered by the judgment of the Honorable Court.
ಇಲ್ಲ, ನೋಡೋಣ next week ಮಾಡ್ಸಿ.
2 weeks at least.
At the request of.
2 weeks.
All right, 2 weeks.
Please.
At the request of the net CGC Shri SV Desai. ಅಲ್ಲಿ ದೇಸಾಯಿ ಹೆಸರನ್ನ ಸರಿ ಮಾಡ್ಕೋಬೇಕು. ಡೇಡಾಯಿ ಆಗಿ ನೋಡಿ. ದೇಸಾಯಿ.
Please.
Shri Prasad, you want to retire from the case? Those cases?
6180. Yes, my lord. I have already filed memos.
Shri learned senior panel counsel Shri NS Prasad on request is permitted to retire from the cases. ಯಾವ್ದಾದ್ರು ನೋಡ್ಕೋಬೇಕು. All. Ah. Yes.
My lord, in this matter, we have filed a memo reporting the death of respondent number 1. We've
Spot
also
number
fi-
1 is dead.
Yeah, please, my lord.
Yaru, you are for a?
I'm for the appellant, my lord.
Appellant report ಮಾಡ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. Appellant should bring LRs of the deceased on record.
We've filed an application to bring an,
Notice ಹೋಗ್ಬೇಕನು?
please, my lord.
Spot number. Appellant. Ah.
My lord, as far as respondent number 5 is concerned, even she has passed away. We are not able to secure the date of death, so I pray for a week's time, my lord.
All. 2 weeks. Issue emergent notice on the sack. Okay.
Grateful, my lord.
All. Yes.
First matter I appear for the petitioner.
And since there is a minor upset in my health, I was unable to file my counters.
You want to file counter?
Please,
Let him file. He had health issue. All. 2 weeks for filing a statement of objections, if any. Within 2, if any, failing which, right to file one stands forfeited.
Interim order.
Interim order to continue.
State to
On the, call this matter on.
2016 matter pending.
ಈಗ ರೆಡಿ ನಾವು ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಿ ವಿ ಆರ್ ರೆಡಿ ಡೋಂಟ್ ಮೇಕ್ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ದ ಜಡ್ಜಸ್ ವಿ ಆರ್ ರೆಡಿ ಇಫ್ ಯು ಆರ್ ರೆಡಿ ಟು ಆರ್ಗ್ಯೂ ನಾವು
My lordship rejected their objection.
call this matter on 5th of December. All right, 5th of December.
Much obliged.
Yes.
Appearing on behalf of DS Gautam, my lord.
Yes,
This
Gautam, ಏನಿದೆ?
Petition is challenging the impugned order passed by the Honorable Tribunal, my lord. The respondent number 3 was transferred from annexure A1, my lord.
Retention period ಎಷ್ಟು?
Lord?
Normative rules ಕೆಳಗಡೆ retention period of the post ಎಷ್ಟು?
Lord, it is not about retention period, my lord. We have issued the movement order, my lord. We have issued the movement order, my lord. Even after issuing the movement order, he has not reported back to the concerned authority, my lord, or he has not requested for his presence, my lord. That same period of 12/2/2021 to 21/7/2021 may be treated as leave, my lord, unauthorized leave, my lord.
Twelve 2/2021 ಇಂದ 21/7/21.
Yes, my lord.
Arrears of salary ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
Yes, my lord.
ಯಾಕೆ ಕೊಡ್ಬಾರ್ದು?
My lord, at annexure A4, my lord, we have page number 38, my lord, annexure A4, my lord. At the bottom, my lord, ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಸದರಿ ನೌಕರರು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಶ್ರೀ LS ಮಾದೇಶ್ ಶಿರ್ಸದಾರ್ ಇವರಿಗೆ ಶ್ರೀಮತಿ S ಮಂಜುಳಾರವರು ಶಿರ್ಸದಾರ್ ಹುದ್ದೆಯಿಂದ ಬಿಡುಗಡೆಯಾದ ನಂತರ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಳ್ಳುವಂತೆ ಚಲನಾದೇಶವನ್ನು ನೀಡಲಾಗಿದೆ. Movement order has been issued, my lord.
One second. Srimati Manjula, when she left?
Lord, she left on 22/7, my lord.
22/7?
Yes, my lord. 21/7, my lord.
21/7?
Yes, my lord.
21/7 ಇದ್ರೆ ನಿಮ್ಗೆ ಏನ್ ಕೇಸ್ ಇದೆ ಇದರಲ್ಲಿ? You have no case at all. That is the case.
He has not reported back to the relieving authority, nor he has reported to us and signed the attendance, my lord.
He has not signed the attendance?
No, my lord. They have not even produced that record, my lord, whether he has reported back or he has signed the attendance, my lord.
How this contention is treated by the tribunal?
My lord, I would like to take to the page number 132, my lord, that inside page number 9 of the order passed by the Honorable Tribunal, my lord. It is clearly stated, my lord, ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಸದರಿ, the same para has been extracted, my lord. And in view of the above observation, it is clear that the applicant reported for duty on 12/2/2021. The authorities have not issued any movement order, my lord. Above that only ಚಲನಾದೇಶ ನೀಡಲಾಗಿದೆ ಅಂತ ಬರೆದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೆನ್ಷನ್ ಆಗಿದೆ.
ಬನ್ನಿ ಓದಿ. In view of the above, see ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಸದರಿ ನೌಕರರು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಶ್ರೀ ಮಾದೇಶ ಇವರಿಗೆ ಶ್ರೀಮತಿ ಮಂಜುಳಾ ರವರು ಶಿರಸ್ತೇದಾರ್ ಹುದ್ದೆಯಿಂದ ಬಿಡುಗಡೆಯಾದ ನಂತರ
Yes, my lord.
ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಳ್ಳುವಂತೆ ಚಲನಾದೇಶವನ್ನು
Yes, my lord.
ಬಿಡುಗಡೆಯಾಗಿದ್ದು 21/7.
Yes, my lord.
ಅಲ್ಲಿ ಮತ್ತೆ ಅವ್ರೇನ್ ನಿಮ್ ಕಟ್ಟಿ ಮೇಲೆ ಬಂದು ಕೊಡ್ಬೇಕಾ ಎಂಪ್ಲಾಯಿ? ಯು ಓನ್ಲಿ ಸೇಡ್ ಅವಳು ಬಂದ್ಮೇಲೆ ಅವಳು ಬಿಟ್ಟ ಮೇಲೆ ನೀ ಬಾರಪ್ಪ ಅಂತ ಹೇಳಿ.
Yes, my lord. My lord, I should have either reported back to the relieving authority or he should have attended the office, my lord.
ಅಲ್ಲಿ ರಿಲೀವ್ ಆಗಿಬಿಟ್ಟಿದ್ರ ಅವರು?
Yes, my lord.
ಮೊದ್ಲೇ?
Yes, my lord. On 11/5 only has been, 11/2 only has been relieved, my lord.
ಅಲ್ಲಿ ಅವ್ರು ರಿಲೀವ್ ಮಾಡಿದ್ರು. ಇವ್ರು ತಗೊಳ್ತಾ ಇಲ್ಲ. Where he should go?
Yes, my lord. He has to either report back to the relieving authority.
Where have you stated?
Yes, my lord. I already explained, my lord.
Huh?
I had explained my.
He has been relieved.
Yes, my lord.
Issue. No, emergent notice. Stay of impugned order till next date of hearing. Subordinate AG is requested to accept notice for
1 and 2.
Huh?
1 and 2, my lord.
1 and 2. Emergent notice to third respondent. Interim stay.
Let's oblige, my lord.
No, this is maintainable. Not maintainable because of Justice Nagaratna's judgment. Counsel for petitioner absent, call tomorrow.
In this case, regarding qualifying service, they are seeking your lordship. 247 under 247 A lordship, they are not entitled to. Initially, they were appointed on daily wages, your lordship. Later on, they were.
Part of the service count ಆಗಲ್ಲ no?
ಆಗೋದಿಲ್ಲ.
1/3 ಅಲ್ವಾ?
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಲಾರ್ಡ್ಶಿಪ್ kindly see, they are not eligible because right on the date when they are retired, that rule is applicable. But they are claiming from the date they were appointed, your lords. Therefore, in similar identical case, your lordship, this honorable court has, coordinate bench has passed orders and there is a stay, your lordship, in repetition number 1342/427 of 22, your lordship.
The emergent notice, interim order as prayed for. First off, this interim stay is granted on the assertion of learned AGA that in WP
Repetition
number
13427 of 2022, your lordship.
12347 of 2022, comma, a coordinate bench of this court is considering the mat issue and has granted interim relief as well. Okay. Bharat
Please.
Relief Faruqi. Yes, Mr. Ajay.
Your Lordship, I am for the petitioner in this case. I am aggrieved by the order of the Honorable Tribunal wherein the delay was not condoned. Before moving to that, I would state that the person is a person with 100% disability. On the 11th of this month, there was a similar order passed wherein the right of a person who's 100% blind has a right to teach as a primary graduate teacher. Here it is for the same post. Same post, Your Lordship.
Teacher?
Teacher PGT, I'll refer to the application.
PT.
PGT, primary graduate teacher.
Primary graduate.
Social science, same subject.
Emergent notice, learned AG is requested to accept notice for respondent number 1. 2 yaru. Centralized administrative cell.
1.
For all respondents.
Yes, all respondents.
AGA for all respondents. All in the first week of January 2020.
Your Lordship, my humble request, one post may be kept vacant, Your Lordship.
Huh?
One post may be kept vacant because the
respondents are directed to keep one vacancy intact if any vacancy is available. Okay.
There is another similar matter, similar place, that is WP 18693.
Call this matter along with WP number.
The order may be extended to the same, to that as well.
Adellide.
That is in the board branch.
ಅಷ್ಟ್ ಆಗ್ದಂಗ್ ನಾವ್ ಹೆಂಗ್ ಆರ್ಡರ್ ಮಾಡೋದು? Yes. ಶ್ರೀನಿವಾಸ.
My lord, in this I'm appearing for petitioners, my
Ah.
lord. My lord, petitioners are working as cooks and assistant cooks, my lord.
Huh?
Cooks and assistant cooks, my lord.
Send
My
assistant.
lord, their initial appointment was daily wage employee.
Ah.
And later on, my lord, their names were notified under the Welfare Act, my lord.
Under
Under Karnataka State Welfare Act, my lord.
2012 Act.
2012, my lord. My lord, the order was passed in the 2018, my lord, by this honorable tribunal, my lord. My lord, that order was.
ಎಷ್ಟ್ ಸರಿ ಮೈಲಾಡ್ ಅಂತೀರಿ? ಅಷ್ಟ್ ಸರಿ ಅನ್ನೋ ಆಗತ್ತೆ.
It was implemented.
ಒಂದ್ ಸರಿ ಅನ್ಬೇಕಪ್ಪ, ಆಮೇಲೆ ಬಿಟ್ಟು ಹಾಕ್ತಾರೆ.
It was implemented in 2021.
Huh?
21, it was implemented. My lord, there was a delay of 8 years, my lord,
In implementing.
implementing. So I was
That cannot affect your rights ಅನ್ನೋದು ನಿಮ್
Please,
ಕಂಟೆಸ್ಟ್.
my lord. My sorry, arrears of salary has been not
Ah.
released.
Learned issue notice. Learned AG is requested to accept notice for the respondents. Copy ಕೊಡಿ ಅವರಿಗೆ. Please copy ಕೊಡಿ. Call in the third week of, in the first week of February 2025. In the meanwhile, it is open to the respondents to file objection statement, if any, failing which right to file one stands forfeited. Yes.
Petitioner, my lord.
Yes,
No,
Mr.
petitioner
Holla.
was initially appointed as a casual worker, my lord, 1986 in Postal Training Institute, Mysore, my lord.
Mhm.
Lord, as he was required to consider for conferment of temporary status, as per the scheme prevailing in the postal department in 1991, he was not conferred temporary status, my lord. Whereas 1998, he has been conferred the status, my lord. The tribunal in its earlier order has declared him as a regular employee, my lord, with effect from 1/1/1995, and actually A5 is the order. My lord, accordingly, he has been, the covered under the old.
ನೀವು
pension
appear
scheme.
ಆಗ್ತೀರಾ? Objection ಆಗ್ತೀರಾ?
ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು. ಎಲ್ರಿಗೂ ನಾನೇ.
ಇದ್ರಲ್ಲಿ ಮತ್ತೆ ಯಾಕೆ ಅಬ್ಜೆಕ್ಷನ್? ಏನೋ ನ್ಯೂ ಡೆವಲಪ್ಮೆಂಟ್ ಇದೆ,
Objections
ಬಟ್
ಏನಿಲ್ಲ.
ಅಲ್ಲಿ ಏನ್ ಹಾಕಿರ್ತೀರ ಅದೇ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಆಗ್ಬೇಕು.
ಅಬ್ಜೆಕ್ಷನ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇಲ್ಲ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಮೇಲೆ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರಿ.
ശ്രീ B. Pramod, Lieutenant Senior Panel Counsel, the CGC, is requested to accept notice for respondents. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
ಅಡ್ವಾನ್ಸ್
Second week.
ಮಾಡಿ.
Yes.
Of hearing, my lord, wanted to know whether I have deposited the amount.
I
have deposited the amount.
You have deposited the amount. Learned counsel for the petitioner
With the interest, my lord.
submits that he has
My lord,
deposited.
12,06,250 plus
Not call
the
yourself.
cost of 10,000, both are deposited. Page 2 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. On 37/2021. On page 2 of the deposit memo ಹಾಕಿದ್ದೀನಿ ನೋಡಿ.
There is no reason to doubt you.
Please.
If ನೀವು ವೆಂಕಟೇಶ್ ಹೇಳಿದ್ರೆ then we simply accept that. ಅದೇನೋ ಅಪೋನೆಂಟ್ ಇಲ್ಲ ಇದ್ರಲ್ಲೆಲ್ಲ
ಇಲ್ಲ ಸರ್.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ನೋಟಿಸ್ ಆಗಿದೆ, ಅಪೇರ್ ಆಗಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮು.
1, 2, 3 ನೀನು ಎಂಟ್ರಿ ಮಾಡರ್ ಕೇಳಿದ್ರೇನು?
ಕೇಳಿದ್ವಿ.
Entry order has sought for till next date of hearing. First. Memo filed with.
Let the deposit continue in the bank.
The amount in deposit shall continue without being released to anyone.
Please.
Huh? ನೋಡ್ ಮತ್ತೆ ಕಿವಿಟ್ರೇನ ಇದ್ದಾರೆ ಅವ್ರಿಗೆ ಬಂದಿಲ್ಲ. ಹಾಕಿ.
For the
Forty.
For the petitioner, my lord.
Ah.
Have challenged the order of the Karnataka State Administrative Tribunal allowing the application filed by the respondent number 3 herein, my lord. The transfer order has been challenged. And my lord, subsequent to the transfer order dated 31/7/2024 and another
Transfer order dated
31/7/2024, my lord.
31/7/24.
Please.
Retention period ಎಷ್ಟಿದೆ ಅದಕ್ಕೆ?
2 years.
2 years, sir.
My lord,
ದಿವಸ ಇದ್ರಿ?
subsequent to that, one more order was passed modifying the transfer order on 5/8/2024.
31-7 ಆದ್ಮೇಲೆ 5-8 ಈಗ.
ಹೌದು 5-8 ಗೆ one more order. is
After you
passed.
reported for duty or before?
No, I have not reported for duty. Allegedly, the respondent number 3 herein stated that he has already assumed charge. But in the annexure produced by him itself, I have not signed for having handed over the charge. That apart, my
When
lord,
he assumed charge.
anta he says.
All right, according to him,
According to him, he says he has assumed the charge on 5-8.
5-8.
ಹೌದು 5-8. Same day the order has been passed.
Same day? Same.
ಹೌದು
5-8.
ಮಾಡಿಫೈ ಆಗಿದ್ದ ಆರ್ಡರು ಅದೇ ಡೇಟು.
Charge ಹೋಗಿ
ಚಾರ್ಜ್ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳುದು ಅದೇ ಡೇಟು. ಬಟ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ದ ಚಾರ್ಜ್ ಅಂಡ್ ದಟ್ ಡಸ್ ನಾಟ್ ಇವನ್ ಬೇರ್ ಮೈ ಸಿಗ್ನೇಚರ್. That particular annexure has also been produced by the respondent number 3 before the case.
ಪೋಸ್ಟ್ ಇದು ಬಹಳ ಅಟ್ರಾಕ್ಟಿವ್ ಪೋಸ್ಟ್ ಇದೆ
ಇದು
ಕಾಣ್ತದೆ.
ಗ್ರೇಡೇ ಚೇಂಜ್ ಇದೆ ಇದು.
Assistant
ಇಲ್ಲ
director.
ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ವೇಕೆನ್ಸಿ ಆಯ್ತು ನನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಇಂದ. To that vacancy, he has been transferred. He is of grade 2, my lord, but this post is of grade 1. Administrative reasons ಗೆ grade 1 in post transfer ಆಗಿ ಖಾಲಿ ಆದಾಗ without promotion being made to that post, another person holding a post to the lower rank cannot be transferred, my lord. That is my case.
How this issued treated, this issue treated by the tribunal?
My lord, tribunal has held that within the same cadre without reference to the pay scale, it can be done ಅಂತ ಹೇಳ್ತಾರೆ. That is my particular grievance. ಆ ಕೇಡರ್ ಒಂದೇ ಅಲ್ವೇ ಅಲ್ಲ.
ಅಲ್ಲ ನೀವು ನಮ್ಗೆ ನೀವು ಹೇಳಿದ್ಮೇಲೆ ನಾವು ಅಸೆಸ್ ಮಾಡೋಕೆ ನಿಮ್ಮಷ್ಟು ಜನರು ಇರಲ್ಲ ನಾವು.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಐ ಆಮ್ ವೆರಿ ಸಾರಿ.
ಸ್ವಲ್ಪ ಪಾಸ್ ಬೇಕಲ್ಲ ಸ್ಪೀಚ್ ನಲ್ಲಿ.
ಸಾರಿ ಐ ಆಮ್ ವೆರಿ ಸಾರಿ ಮೈ ಲಾರ್ಡ್.
ನೀವು ಹೇಳಿದ್ದೇನು ಹೇಗಿದೆ ಕಾನೂನು ರಿಫ್ಲೆಕ್ಷನ್ ಆಗಬೇಕಾಗ್ತದೆ ಒಂದು ಕ್ಷಣದಲ್ಲಿ.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್,
ಮತ್ತೆ
ಸಾರಿ ಮೈ ಲಾರ್ಡ್. In page 4, page 13 of the order of the Karnataka State Administrative Tribunal at para 3, my lord.
ಪರ್ಸನಲ್ ಮಲಾಫೈಡೆ ಬಯಾಸ್ ಇಂತದೇನಾದ್ರೂ ಇದನ್ನ ಮಾಡಿದ್ರಾ? Any influence?
ಇಲ್ಲ, nothing like that, nothing. Moreover,
ಪೋಸ್ಟ್ ಅನ್ನ ಯಾರು ಹೋಲ್ಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ರೂಲ್ಸ್ ಅಲ್ಲಿ? Who holds that post?
Assistant director post is a taluk level post.
ರೂಲ್ಸ್ ತೋರಿಸ್ಬೇಕು.
C&R rules ಅವ್ರು ಹಾಕಿಲ್ಲ.
ನೀವು ತೋರಿಸಿ. You want to hold that post. How can you hold?
That are not placed, Lord. I will take it.
Interim order as prayed for.
Lordship, only one submission.
How on the 5/8/2024, ink has not dried?
That is what I will clarify, Lord. They have not placed the material. He has posted to that post in 5/10/2021.
5/10.
That is the reason that they have not placed.
Now, what is your right to hold?
My right,
higher post.
My right. No, it's not higher post. That is my submission is. She is a grade 1 holding a particular pay scale. The post is not grade 1. That I will demonstrate. Your Lordship, they are not. The petitioner herein is posted in the year 2021. This is a group B post. No doubt they have completed 2 years of minimum service or maximum service 3 years, what contemplated in transfer guidelines. 31/7/2024, transfer order has been effected.
31/7/24, but modified on 5/8.
That's why. Posting me to the post of the petitioner has been transferred to Kolar. Same. They have handed over and I have reported the duty. And subsequently on 5/8, a modification order has been passed by the government, retaining this. That was challenged before the Honorable Tribunal on 2 counts. Once the order is given effective, it's spent on itself. The contention of, because the spent on itself. Because
proposition formulate madi.
Let's say once the order is given effective and I have reported, the order has been spent on itself and it has been given effect thereafter. They are subsequent to modification will not arise this much. TB Mahale case which we are referred, Your Lordship, this has been considered by the Honorable Court. That ನಾನು annex ಮಾಡಿದ್ದೀನಿ ಅದನ್ನು. Annex ಮಾಡಿದ್ದೀನಿ. For 2 reasons, because they have not contested before the tribunal, in spite of the notice is served upon the petitioner, they have not appeared, they have not filed statement of objections also. They have placed at ex parte after serving the notice. Now they came before the Honorable Court stating that we have not handed over the charge. But 2 points has been considered by the tribunal. Once an officer holding a particular post completed his tenure as prescribed under the transfer guidelines, The person who occupies the right, the person who relieves from the post has no right to say who will occupy the post. Once his term is completed, he has no right over that.
But court, we are a supervisory jurisdiction. We
Obliged.
want to know
Obliged.
how government is functioning. That is 220.
Obliged. Once they have completed the term and the order is already implemented, subsequent without any reasoning, the order cannot be modified.
On
Continue.
the same day, 5/8/2024 is the government order.
That's it.
Same day you took charge.
No. I have already, that is also considered by the tribunal. I have already reported. Thereafter, the order has been given effect to.
You had reported when you had
In the
reported.
morning itself, the order ಅವರು ತಗೊಂಬಂದಿದ್ದ ಈ ಸಾಯಂಕಾಲ ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಆರ್ಡರ್ ಆಗಿರೋದೇ ಗೊತ್ತಿಲ್ಲ. It was when they placed it to us after my reporting. That is what the contention before the tribunal. Otherwise, your lordship, 5 days I have got a right to report to the duty, particular duty. 31/7/2024, they passed an order. Within 5th, I have to report. I supposed to relieve from the
5/8.
Yes. I supposed to relieve from the previous place.
You were relieved on which? day?
Relieved on 4th. 3/8. Sorry, 3/8 I have relieved. 3/8 I have.
3/8.
3/8.
Because you have 5 days time.
Saturday. Saturday is the 3/8. Sunday is the 4th. So 5th morning I reported. They have not contested that you are not eligible to vote. They have given the post. They have vacated the post.
Vacated the post when which date?
On 5th itself.
On 5/8.
5/8 morning.
But she's saying that.
No,
Contesting that she has not handed over the charge.
no.
That is their contention. But the fact remains, once a relieving officer, after getting relieved from the previous post, report, it is ambiguous for that they have to give the effect the order. The tribunal considered that. What is the legal right which is affected to the petitioner hearing? Once they have completed the tenure, subsequent modification by the government.
Years you have put in service there.
ಇಲ್ಲಿ ಎಷ್ಟು ವರ್ಷ ಇದ್ನ?
Lordship,
ಇಲ್ಲಿ ಎಷ್ಟು?
3 years, 6 months.
3 years.
That is 6 months in addition to.
In addition to
maximum
the
period.
that they have escaped because annexure A11 I placed it before the tribunal. Now in writ petition ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಹಾಕ್ತಾರೆ.
My lord, I may be permitted to produce the government notification.
What
Which-
is your right?
ಅಲ್ಲ.
What is your right? What he says is, it is sensible. Now,
Please.
I was under impression on 5/8, ದೊಡ್ಡಗಿರಿಂದ ನುಕ್ಕೊಂಡೆ ಅಂದ್ಕೊಂಡಿದ್ದಾನೆ ಅಂತ. That's not the case. 31/7 ಈಗ ಆರ್ಡರ್ ಆಗಿದೆ.
ಹೌದು.
5/8 ತನಕನೂ ಟೈಮ್ 3/8 ಅವನು ರಿಲೀವ್ ಆಗಿದ್ದಾನೆ. ಅವನು ಖಾಲಿ ಕೊಡಕ್ ಬರಲ್ಲ. ಹಂಗಾಗಿ within 5 days, he has to report for duty. He went there in absentia, charge is taken.
Now pursuant to learned tribunal orders, the authorities have given effect the order and that also placed me. I reported I am working over there.
My lord, my grievance is this, my lord. ಇದು within the same cadre transfer ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ ಅಂತ. That is the main ground on which this application has been allowed by the Karnataka State Administrative Tribunal. ಇಲ್ಲಿ ಕೇಡರ್ ಡಿಫ್ರೆಂಟ್ ಇದೆ, ಪೇ ಸ್ಕೇಲ್ ಡಿಫ್ರೆಂಟ್ ಇದೆ. ನನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಹೌದು, ನಾನು ಗ್ರೇಡ್ 1
Different ಆಗಲ್ಲ.
Pay scale different ಇದೆ.
Pay scale
Cadre
different.
remains same.
Grade is with
One
grade
promotional
pay
post grade
Or-
1 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೋರ್ ಓವರ್ ಇಲ್ಲಿ ಗೆಸ್ಟೆಡ್ ಮ್ಯಾನೇಜರ್ ಅಂತ ಹೇಳಿ ಎಷ್ಟು ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ ಹಿ ಕ್ಯಾನ್ ಬಿ ಪ್ರಮೋಟೆಡ್ ಅನ್ನೋದಕ್ಕೂ ಇದೆ. ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಪ್ರಮೋಟೆಡ್ ಆಸ್ ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಗ್ರೇಡ್ 1 ನನ್ನ ಜಾಗಕ್ಕೆ. ಇನ್ ದಿ ಸೇಮ್ ಪೋಸ್ಟ್ ಹಿ ಹ್ಯಾಸ್ ಬೀನ್ ಪ್ರಮೋಟೆಡ್.
What is your right?
My lord,
Your right to raise the issue is for the employer. If employer feels he is your employer also, he wants that particular officer to be in that post. In an extreme,
My
case,
lord,
perhaps
ಇದು
we may look into.
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ರೀಸನ್ಸ್ಗೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು,
ನನ್ನ
ಎಲ್ಲ
ಪೋಸ್ಟ್ ಇಟ್ ಇಸ್
transfers ಹಾಗೆ.
ಟೋಟಲಿ ಡಿಫ್ರೆಂಟ್.
ಎಲ್ಲ transfer.
ಕೂತ್ಕೊಳ್ಳಿ ನಿಮಗೆ
How you are agreed? Because 3 years, 6 months, why you want to cling on to this post? What is
My
your
lord.
justification? What's your right?
My lord,
Maximum is 2 years, plus 1 year, 3 years. You were there 3 years, more than 6 months. Right
My
or
lord,
not?
what I'm aggrieved is this. I was placed ex parte. At that time, my mother was ill. Thereafter, she expired. So I can't,
We will hear you fully now. You answer our question. You assume
Please,
that
ma'am.
we are a tribunal.
the ground and the sole ground on which I'm challenging the order of the state, Karnataka State Administrative Tribunal is that there is a finding at page number 4 that without reference to the pay scale, if it is within the same cadre.
How you are
transfer
concerned
is-
with that? Employer knows where his employee should be placed, subject to exceptions. In those exceptions, we may say this, that, etc. ಏನಿಲ್ಲ.
For that matter, my lord, his transfer is also premature because 10 months ಅಷ್ಟೇ ಮಾಡಿರೋದು ಅವರಲ್ಲಿ.
How you are concerned? He should be aggrieved. He should be aggrieved. Not you. Very Parkal. Challenges to the administrative tribunal's order dated 29/10/2024, whereby Nim client Janardhanana
ಹೌದು.
Complaint, sir. Who is the applicant before the tribunal?
heard respondents' application number 3938 of 2024 having been favored. Relief has been accorded to him as under, no, no, page number, running page 15, operative section of the order. Next paragraph. Learned counsel for the petitioner vehemently argues two essential points for voiding the order of the tribunal, which her client has not handed over charge of the post in question on 5/8/2024, and that the third respondent has no right to hold the post in question going by their grade. First, learned counsel appearing for the caveator opposes the petition, contending that in our legal system, please be seated. Right, our legal system operates on the grand maxim, ubi jus ibi remedium. And it is more so when power like writ jurisdiction is invoked before the tribunal. And now writ jurisdiction simpliciter is invoked before this court. 7. The petitioner, having held the post for 3.5 years, the retention period being 3, has no right to complain whatsoever. 7. He also contends that it is the employer's prerogative to deploy his employees in positions of his choice, subject to all just exceptions. And case of the petitioner does not fit into any such exceptions. First, next, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission made by learned counsel appearing for the caveator. First, once employee has completed the minimum period of prescribed retention, ordinarily he will not have any right to complain when somebody is sought to be posted to her place, his place. First, on this premise, the tribunal has structured its order. 7. There is scope for improvement even in heaven, said Oscar Wilde, and that may be applicable to the order of the tribunal and our order also. First, however, that does not constitute a ground for invoking the jurisdiction. First, the above circumstances, a petition being devoid of merits is liable to be, and accordingly it's rejected. Next. All right.
I appear for the.
To seek inspection in identical case, whether he has been.
Last time, along with a memo, had produced a government order.
Verify, I think same lot.
Whether case or the constable wide audited. You had given benefit to the other constable.
A
On
very
parity basis, you have to grant this, na?
Yes.
Padi. Ali, petition allowed on parity basis. First up, refer to our order dated 23/10/2024. First up, AGA replies that similar benefit has been given to another constable, KSRP constable, wide order dated 27/6/2024. First up, if that be so, petitioner is entitled to be treated on par with him, there being no derogatory circumstances warranting a differential treatment. First up, petition is allowed. ಏನ್ relief?
ಇದರಲ್ಲಿ what they have done is, my lord, because before the KATA had challenged only the show cause notice. But unfortunately, the advocate could not appear in that case and the tribunal had dismissed. ಇದರಲ್ಲಿ what
ಏನ್
are
relief ಏನ್ರಿ?
ಅಲ್ಲ ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ, they have for quashing my lords, after the order of the tribunal, they have relieved me.
ಕನ್ನಡ ಎಕ್ಸಾಮ್ ತಗೊಳ್ಬೇಕಾಗಿತ್ತು.
ಈಗ ಅದು ಪಾಸ್ ಆಗಿದ್ದೀನಿ.
You are passed also.
Yes.
ಇನ್ನೊಂದು support.
4th standard ಅಂತ ತಗೊಳ್ಳಿದ್ದಾರೆ.
Petitioner's contention that his client has now passed the qualification prescribed by Kannada Sahitya Parishat.
Yes, ಕಾವಾ examination.
Kawa.
ಅದನ್ನು ಮೆಮೊ ಜೊತೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Kawa also. Okay.
But that Kawa is not considered.
Anyway, you have to other person, you cannot be
4th
discriminated.
standard ಅಂತ ತಗೊಂಡಿದ್ದೀನಿ.
And annexure R ಅಲ್ಲಿ they have relieved me, my lords, from ಬರುವಂತ ಸೇವೆಯಿಂದ ವಿಮುಕ್ತಿ, that after the tribunal's order.
ನಿಮ್ಗೆ ಏನ್ ರಿಲೀಫ್ ಬೇಕು?
ಅದೇ R has to be quashed.
The petition is allowed. Tribunal's order ಎಲ್ಲಿದೆ? ಇದು ನೋಡಿ, ಅಲ್ಲಿ ನೋಡ್ರಿ, ಫಸ್ಟ್ ಹಾಕ್ಬೇಕಿದ್ನ ಟ್ರೈಬ್ಯುನಲ್ಸ್ ಆರ್ಡರ್ ನಮ್ ರೂಲ್ಸ್ ನಲ್ಲಿ ಹಂಗಿದೆ. ಯಾಕೆ ಹೊರಗಡೆ ಹಾಕೊಂಡ್ರು ಮತ್ತೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ ಮ್ಯಾಟರ್ಸ್ ಅನ್ನೆಲ್ಲ?
63
No, they are not supposed to. It creates violence to us. ಆರ್ಡರ್ ಹುಡುಕಕ್ಕೆ 10 ನಿಮಿಷ
ಆರ್ಡರ್ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಇರಬೇಕು.
ನಮ್ಮ ರೂಲ್ಸ್ ಸೇ ಫಸ್ಟ್ ಆರ್ಡರ್ ಹಾಕ್ಬೇಕು. ದಟ್ ಬಿಕಮ್ಸ್ annexure A. Rest of the orders become annexure A1 series because it is structured that way under rules. KAT rules ನಲ್ಲಿ ಹಂಗಿದೆ.
ಅಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ಸ್ ನ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರಿಟ್ರೀಟ್ ಮಾಡಿ.
ಅದ್ರಿ 67 ಅಲ್ವಾ? The impugned order of the tribunal is set at naught. Petitioner's application 2442 of 2020 having been favored, the government order dated
annexure R,
orders date memorandum dated 15/2/2020 and 3/7/2020 respectively at annexures A15 and A14 and 16 issued by yaru third respondent third respondent or quest. ನಿಮ್ಮನ್ನು ರಿಸ್ಟೋರ್ ಮಾಡ್ಬೇಕನ್ನು ಇದಕ್ಕೆ?
Yes, Minister. What happened was after
any issues for the reinstatement of the petitioner, the post in question forthwith. Entry ಮಾಡಿರ್ತಾ ನಿಮ್ಗೆ ಟ್ರೈಬ್ಯುನಲ್ ನಲ್ಲಿ?
ಇಲ್ಲ,
I was in service. After the tribunal order, I have been removed. Relieved. ಅದಕ್ಕೆ annexure R also.
Appear.
Yes, sir, Joyce.
Matter relating to discharge of probationer.
Discharge of probationer.
When she has appeared for the examination, results are awaited. Rule 4(1) of the KCA probation rules contemplates if a person is under probation and they appeared for examination, results are yet to be announced. Till such time, discharge should not be made. That is how Rule 4(1) is there.
Rule 4 of
KCS probation rules.
ಬಡಿ ಎಲ್ಲಿ ರಿಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಾ?
ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
ನಿಮ್ಮಲ್ಲಿ ಇದೆಯಾ?
I've got it.
KCS probation.
But subsequently also she has not completed the
That
exam.
is there, that is, but subsequently she died.
ಮಾಡಿಲ್ಲ. Discharge. Before publication of the result of the examination, she could not have been discharged. Huh? No more. Now she is no more.
She is no more, she is dead. If legally, by legal fiction, the order of discharge is certified
Compassionate appointment.
by this order.
ಅಲ್ಲ ಬರೋದಿಲ್ಲ ಯಾಕೆಂದ್ರೆ
ಅಲ್ಲ ಅದಕ್ಕೆ last time at that stage your lordship asked, how
Lordship may kindly appreciate she has taken exam also. She didn't succeed.
She failed.
Therefore, probation itself is not declared. When she is not.
no,
entitled to
probation
the
declared,
probationary
Allah, there was already an order which is illegally.
We'll assume now. We'll assume now you were not relieved at all.
Allah, then the only legal consequence is if an order is wrong, it is contrary to law. The court will say that the order is wrong. If the subsequent events, subsequently she has died, she has not passed the exam, those are subsequent. To find out if the.
They are subsequent is true.
Yes.
But they are significant.
No, the similar case, in matter of. In the mass.
Well, your client had not, that the DC had not passed the examination at all.
No,
What is your right?
the question is, as on the date when the order was passed, is
That may
valid
be
or.
wrong, we agree.
Yes.
Technically speaking, as an English judge, perhaps we may say this is wrong, but it's not end of the matter. Subsequently, when results were published, you had failed. Even then you have to give, what is the order?
The consequence is this, my lord. Why I am urging this ground is.
Ali
the-
compassionate ground ತಗೋಕೊಂತ
Compassionate
appointment ಅಲ್ಲ.
ಒಂದಲ್ಲ, ಇವಾಗ 3 ಹೆಣ್ಮಕ್ಳಿದ್ದಾರೆ ಈ ಪರ್ಸನ್ಗೆ.
ಅವ್ರು ಗೌರ್ಮೆಂಟ್ ಏನ್ ಮಾಡ್ತದೆ?
ಅಲ್ಲ,
ಅವ ಹಿಡ್ಕೊಂಡ್ರೆ.
if the court is kind enough to say that the order is bad in law, as it is bad in law, as on the date it was passed, it is bad in law. If the court is say that order, the livelihood of this one family will be saved. If legal infirmity in the order comes to their rescue, a family will be saved. That is the only order.
Petition is dismissed. Dismissed. The prime reason being.
I will just one
that the.
Supreme Court
Yes,
judgment.
I'll refer to that judgment also.
Supreme Court judgment on ಕೊಟ್ಟಿರಿ.
In as much as, though arguably petitioner could, the deceased could not have been relieved pending declaration of result in the departmental examination, comma. When results were declared, she was found to have failed. Full stop. Therefore, she could not have derived any milk on the fact matrix that came into existence subsequently, which would cast its shadow on the arguable rights of the deceased. Full stop. The argument that it only subsequently happened, and what the court has to see is, when she was discharged wrongly, comma, that wrong alone should be set at naught, and nothing beyond appears to be too far-fetched an argument. Full stop. In matters like this, we have to assume that the candidate was alive when the results were declared, and if that be so, the action taken cannot be faltered. In other words, the subsequent event feeds the animation to the action in question. First, next part. Counsel's reliance on the decision of the apex court in civil appeal number 5030 of 2014 between Nagamma and others versus DG, IG of police and others, disposed of on May 2, 2014, would not advance case of the petitioner. Full stop. At the second half of para 8, the apex court has observed as under. No law as such has been declared under Article 141 of the Constitution of India, comma, the decision being fact specific. First, dismissed.
Petitioners were working in KSRP.
Working in KSRP.
Please. They were,
Reserve Police.
please, madam. The revised pay scale fixed was recalled on the basis of audit objection and it was sought to be recovered. First, tribunal interferes with the recovery order and recalling order is not interfered. First, that is under challenge, my lords. In this case, my lords, as per the pay rules, my lords, as per the chart on the last date of hearing, your lordship has perused, page 83. Lords, there is no wrong fixation which is sought to be recalled, my lords. As per the
No wrong fixation.
no wrong.
Recovery no order madara?
Recovery ಮಾಡಿದ್ದಾರೆ, tribunal has set
As per
aside.
2015 Supreme
ಹೌದು.
Court. It's not wrongly fixed, it's
It
rightly
is,
fixed.
it's rightly fixed.
And you torsi.
Chart is at 83, my lords, page 83, annexure A3. Page 83, my lords. My lords,
Pay scale ಇದ್ದ ಇದು?
ಹೌದು, ಪೇ ಸ್ಕೇಲ್ ಇದೆ. ಮೇಲ್ಗಡೆ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಪೇ ಸ್ಕೇಲು, ಕೆಳಗಡೆ ರಿವೈಸ್ಡ್ ಪೇ ಸ್ಕೇಲು. As on 1/5/2017, my lords, the petitioners were in the basic pay of 21,600.
1/7/2017.
Please, my lord. ಒಂದು increment 600 rupees add ಆದರೆ 22,200 ಆಗ್ತದೆ. Revised is
200 to 39,000, corresponding is 39,800.
Yes,
ಅದು next year 24,600. Next column.
ಹೌದು. Now this 39,800 is audit objection is it should have been 38,850.
38,850
ಆಗ್ಬೇಕಾಗಿತ್ತು, 39,800 ಅಲ್ಲ.
ಅಂತದ್ ಯಾವ್ದು ಇಲ್ಲೇ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ.
ಏನ್ ಮಾಡ್ತಾರೆ? 21,600 ನಲ್ಲಿ ಇದ್ದಾಗ ಎಷ್ಟು ಇನ್ಕ್ರಿಮೆಂಟ್ ಇತ್ತಲ್ಲ, 950 ರೂಪಾಯಿನ?
ಹೌದು.
May I point out? In page 78, my lord.
78.
The column, my lord, table between 36,000 to 39,800, the increment is 950. Column.
ಯಾವ page?
ಅದೇ 83 ಅವರ
83 refer ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ನಾನು
Table.
78 ಕೊಟ್ಟು, I beg your
ಅದೇ
pardon.
ಸೇಮ್ ಟೇಬಲ್.
ನೀವು pagination ತಪ್ಪು ಕೊಟ್ರೆ ಏನ್ ಮಾಡೋಣ? How she should work?
ಅಪಾಲಜೈಸ್.
83.
ಅದೇ.
36,000 to 39,800, my lord.
36,000
Yes,
ಅದಿಲ್ಲ. 36,800 ಎಲ್ಲಿದೆ?
ಮೇಲ್ ಟಾಪ್ ಅಲ್ಲಿ.
top, my lord. Top left hand side.
36,000.
36,000 to
9.
39,800. Lord,
Correct.
it's 950. Now, my lord, if my lords may kindly peruse, down, if it is 20,000, my lord, it will be, so my lord, apparently, my lord, 950 should be added.
1 second. If it is 22,200,
If I take my lords from 20,000.
20,000, all right, 20,000, that becomes 35,150.
Yes. 20,500, then it becomes 36,000, my lord.
36,000.
21,000, my lord, it becomes 36,950.
That means 950 is the value,
Yes,
incremental
yes,
value.
my lord. 21,600, my lord. It is shown as
37,900.
My lord, if my lord.
22,200 ಗೆ 950 add ಮಾಡ್ಕೊಳ್ಳಿ.
57,900 ಆಗಲ್ಲ. If 950 is added, it will be 38,850. As such, there was an objection raised by the audit.
ಅದು 21,600.
37,900, my lord. 950 is added, it becomes 38,850.
Not 39,800.
There is double jump, my lord, for which, my lord, there was an objection raised.
ಅದು ಎಲ್ಲರಿಗೂ ಮಾಡ್ಬೇಕು, all employees.
1900 add ಆಗ್ಬಿಟ್ಟಿದೆ ಅದಕ್ಕೆ.
Yes, ma'am.
950
Double,
ಬದಲಿ
double, yes. Double increment is given. If my lords may kindly peruse page 62, the increment which they are entitled is one increment. 62, my lord, 65, but pagination, if it is wrong, it can't. This is the government proceedings of the government, my lord, those who have participated in ST.
ಸಾಮಾನ್ಯವಾಗಿ ಇಬ್ರು ಜಡ್ಜಸ್ ಡಿಸ್ಕಸ್ ಮಾಡುವಾಗ
And I'm-
minimum manners is to keep quiet.
I beg your pardon.
Because we are not playing card here. Important aspect which will have repercussion on rest of the
I did
employees.
not.
950 ಅಲ್ವಾ? ಮೊದ್ಲು ಆ ಆಡ್ ಮಾಡ್ಕೋತ ಬಂದ್ರೆ ವೀರಪ್ಪನ್ ಇದ್ರಲ್ಲಿ ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ಪ್ರೂಫ್?
ಅದಕ್ಕೆಲ್ಲ ಆರ್ಡರ್ ಇದೆ. 21,600 ಇದ್ದಿದ್ದು ಅವ್ರಿಗೆ 600 ಕೊಡ್ತಾ ಇದ್ರು ಬಂದಾಗ ಈ
ಎರಡು ಇನ್ಕ್ರಿಮೆಂಟ್
ಆದ್ರೆ ಈ ಟ್ರೀಟ್ಮೆಂಟ್ 22,200 ಇಟ್ಬಿಟ್ಟಿತ್ತು. ಅವ್ರಿಗೆ 600 ಹಿಡ್ಕೊಂಡು ಇಷ್ಟ ಇತ್ತು. ಆ 600 ಇನ್ಕ್ರಿಮೆಂಟ್ ಅಲ್ಲ, ಟ್ರೀಟ್ಮೆಂಟ್ ಮರ್ಜ್ ಹಾಕೊಂಡಿದೆ ಅಂತ ಅನ್ನೋದಾದ್ರೆ ಇದಕ್ಕೆ ಬರುತ್ತೆ. ಏನ್ ಮಾಡ್ತಾನೆ ಆಡಿಟ್ ಮಾಡಿ ಈ ಇನ್ಕ್ರಿಮೆಂಟ್ ಒಂದನ್ನು ಬೇರೆ ಇಡ್ತಾನೆ. ಮರ್ಜ್ ಮಾಡೋದಿಲ್ಲ, ಮರ್ಜ್ ಮಾಡಿದ್ರೆ
ಕರೆಕ್ಟ್ ಇದೆ.
ಮರ್ಜ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಆಡಿಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಸರಿ ಇದೆ. That 600
21,600 ಅವ್ರದ್ದು ಮೊದಲಿನ
ಪೇ ಸ್ಕೇಲ್.
ಅದಕ್ಕೆ ಒಂದ್ ಇನ್ಕ್ರಿಮೆಂಟ್ ಅನ್ನ ಕೊಟ್ರಿ.
Please.
ಹೌದೇ? ಯಾವಾಗ ವೀರಪ್ಪನ ಗ್ಯಾಂಗ್ ಅಲ್ಲಿ ಹೋಗಿದ್ದಕ್ಕೆ. So it came to 22,200 they were drawing. When this pay scale was revised.
Yes.
So 22,200 ಗೆ 39,800 ಆಗುತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಅದೇನೆ
950 is not taken note of.
950 ಇದು ತಗೊಳ್ಳಲ್ಲ ಅಂತ.
It is not taken into account. 950 regular increment is one thing. A special increment is given because he was in the Veerappan operation. ಅದೆಲ್ಲಿದೆ ಆರ್ಡರ್?
ಅದು ಫಸ್ಟ್ annexure. ಅದು 2005 ಅಲ್ಲೇ ಸೇರೋಗಿದೆ ಬೇಸಿಕ್.
ಅದು ಪರ್ಟಿಕ್ಯುಲರ್ ಮತ್ತೆ ಎಡಪ್ಪ ಆಗ್ಬಿಟ್ಟದ. ಅದೆಲ್ಲಿದೆ?
My lords, annexure A1, my lords, page 62.
62. ವೀರಪ್ಪನ್ ಮತ್ತು ಆತನ ತಂಡದ ವಿರುದ್ಧ ಕಳೆದ 14 ವರ್ಷಗಳ ಅವಧಿಯಲ್ಲಿ ನಡೆಸಿದ ಕಾರ್ಯಾಚರಣೆ ಪಡೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ ಪೊಲೀಸ್, ಅರಣ್ಯ, ಸರ್ಕಾರ ಮಾಹಿತಿ ನೀಡಿದ ಸಾರ್ವಜನಿಕರಿಗೆ ಬಹುಮಾನಗಳನ್ನು ಮಂಜೂರು ಮಾಡುವ ಬಗೆಗಿನ ವಿವರವಾದ ಪ್ರಸ್ತಾವನೆ ಸಹಿತ ಮುಖ್ಯವಾಗಿ ಕಾರ್ಯಾಚರಣೆ ಪಡೆಯ ಸಿಬ್ಬಂದಿ ವರ್ಗದವರಿಗೆ ಘನ ಸರ್ಕಾರವು 50 ಕೋಟಿಗಳ ಬಹುಮಾನವನ್ನು ಘೋಷಿಸಿದ್ದು ಈ ಮೊತ್ತವನ್ನು ಈ ಕೆಳಕಂಡ 3 ವಿಧದಲ್ಲಿ ವಿತರಿಸಲು ಕೋರಿದ್ದಾರೆ.
Relevant is page 65, my lords, regarding increment.
65.
Please, on the top line. ದಿನಾಂಕ 18/10/2004 STF ಪಡೆಯಲಿದ್ದ ಎಲ್ಲಾ ಸಿಬ್ಬಂದಿಗೂ ಒಂದು ಬಾರಿಗೆ ಮಾತ್ರ ಒಂದು ವೇತನ ಬಡ್ತಿಯನ್ನು.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ?
65 on the top line.
ಅಲ್ಲದೆ
ದಿನಾಂಕ 18/10/2004 STF ಪಡೆಯಲಿದ್ದ ಎಲ್ಲಾ ಸಿಬ್ಬಂದಿಗೂ
ಒಂದು ಬಾರಿಗೆ ಒಂದು ವೇತನ ಮಂಜೂರು ಮಾಡಿದೆ. ಇದನ್ನ ಆಡಿಟ್ನವ್ರು ನೋಡಿಲ್ಲ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್?
ಅಲ್ಲ,
ನೋಡ್ಲಿಲ್ವಾ
ಇದನ್ನ ನೋಡಿದ್ದಾರೆ. ಇದು 2005. ಈ ಇನ್ಕ್ರಿಮೆಂಟ್ ಅನ್ನು ಬಿಟ್ರು ಕೂಡ 100 ರೂಪೀಸ್ ನನಗೆ ಕಡಿಮೆ ಆಗ್ಬೇಕು, 950 ಅಲ್ಲ. It was 2005 ಒಂದು increment 100 ರೂಪಾಯಿ ಇದ್ದಿದ್ದು.
ಅವಾಗ
ಹೌದು.
ಅಲ್ಲ, this has been regardless of the value of the increment.
Yes.
Is it noted by the auditing party?
It is noted.
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 We'll have it next week. We'll have some discussion with our senior judges.
Please, ma'am.
Hold on. ಹಿರಿಯರಿಗೆಲ್ಲ ಅವರೆಲ್ಲ ಬರ್ತಾರೆ. Let us see.
Please, ma'am.
ಬೇರೆ ಯಾರಿಗಾದ್ರೂ ಇಂಥದ್ದು ಕೊಟ್ಟಿದಾರಾ?
ಇಲ್ಲ 22 ಜನ ಬಿಟ್ಟು ಉಳಿದವರಿಗೆಲ್ಲ ಸೇಮ್ ಪೇ ಕೊಡ್ತಿದ್ದಾರೆ, ಯಾರ್ದು ರೆಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ. ಇಫ್ ದಟ್ ಚಾರ್ಟ್ ಇಸ್ ರಾಂಗ್ my lords, all employees should be reduced.
ಬೇರೆಯವ್ರಿಗೆ ಏನ್ ಮಾಡಿದ್ರಿ?
That is wrong. That is my instruction.
But
ಅದು ಎಲ್ಲರಿಗೂ
others
ಮಾಡಿದ್ರು.
you have not taken any revising, rectifying measure.
ಮಾಡಿ ಕೆಲವು ಜನಕ್ಕೆ ಬಿಡದೆ ಅದ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಿ?
ಅದ್ರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಹೇಳ್ಬೇಕು ನೀವು.
22 ಜನಕ್ಕೆ ಮಾತ್ರ ಈ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
22%.
ಹೌದು.
ಎಷ್ಟು ಜನ ಇದ್ರು ಅದರಲ್ಲಿ? ವೀರಪ್ಪನ್ ಇದರಲ್ಲಿ
750 plus.
750.
ಹೌದು.
ಅವನ್ನ ದೊಡ್ಡ ಮೆರವಣಿಗೆ ಮಾಡಿ ಕೋಟಿ ಏನೋ ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ರು. ಅರ್ಧ ಕೊಟ್ಟಿದ್ರೆ ಅವನೇ ಓಡಿ ಹೋಗ್ಬಿಡ್ತಿದ್ದ. Let us see, brother. We'll discuss with some service law experts from our his brother's side. Yes. After 2 weeks. Other, we have some difficulty. All right. After 2 weeks, buddy. All after 2 weeks.
I beg to appear for the respondent in this matter.
ಎಲ್ಲಿ ನಿಮ್ಮ ಫ್ರೆಂಡ್
First,
ಸಂಗಮೇಶ್?
what has happened in this, your lordships may kindly peruse the order sheet. Lordships may kindly peruse the order sheet. I'm sorry to say, my lords, my learned friend is not well. In fact, it is recorded in the order sheet
Not well.
for quite long time. And in fact, my lords, yesterday I called on his number. His son picked up the call. He has suffered a brain hemorrhage and he's hospitalized for quite long time for last 2 years, my lords. His son spoke to me.
Oh.
And I happened to collect his junior's number. I spoke to him also, one Mr. Hussain. And he said, my lords, he also does not have information about this file. So may I request, my lords, kindly peruse the order sheet also in the last 3 hearings, my lords. If a notice can be issued to the appellant party himself, my lords. I know Mr. Ramesh, my lords. He had appeared, I had argued at the time of
Lawyer,
admission.
Good service side lawyer he was. He is. ಅಲ್ಲ ಅವರಿಗೆ
It's a specific performance suit, my lords. Trial court has ordered for refund of the advance. I am the owner of the property. He is the purchaser and he is challenged, my lords. Refund is not proper. A sale deed should have been directed to be executed, my lords. In fact, on 1/12/2022, it is recorded in the order sheet also, my lords.
A coordinate bench of this court, wide order dated 1/12/2022, had said as under. First. It appears, learned counsel appearing for the appellant has suffered some health hazard and not able to come before the court. First. In view of the above, registry is directed to send a notice to the appellant for arranging for representation in the matter. First, said notice shall be sent by way of emergent notice. The same shall be by way of emergent notice, returnable within 2 weeks. Okay.
Any date after January, my lords?
Call this matter in the 3rd week of January 2025.
I am obliged.
Sorry.
There may be an interim order in his favor. In case if it is there,
interim
your
order,
lordship may
continue.
extend that.
We appreciate your fairness.
Obliged.
Very good, lawyer fees. Yes.
For the petitioner, kindly pass over the matter.
Pass over?
Yes.
All right. Pass over. ಇದು ನಡ್ಸೋಣ ಪಾಸ್ ಓವರ್ ಕೇಳಿ ಆಮೇಲೆ ಟೈಮ್ ಕೇಳ್ಬಾರ್ದು ಒಂದರ ವಾರಕ್ಕೆ ಮುಗಿಸ್ಬೇಕು.
I have given a NOC Wakalat and T1, Mr. T.S. Venkatesh is filed Wakalat on behalf of the respondents. His name may be shown.
PS Venkatesha.
T.S. Venkatesh, T.S. Venkatesh.
Mr. Srinivas Gowda is permitted to retire from the case on request. First, in his stead, Mr.
T.S. Venkatesh, my lord.
T.S. Venkatesh appears for respondents 1, 3, and 4.
4.
2 Karilwa?
2 K. Expert again.
We'll have it next week.
Please, much.
Next week, ಮಾಡ್ಕೋಬೋದಾ? Okay, next week.
Great.
Just need to show. Yes.
Private respondents.
The question is that, my
The
lord.
request for pass over, please, Milord.
Pass over.
Please. We are ready in the matter, Milord. We also filed for.
In the matter.
Yes, Milord, we are ready.
My lord, there is two circular, I want to place it on record, my lord. In fact, my submission is that it would help them. That is 2018 circular, my lord. This is 2016 rules, my lord. After 2016 rules, my lord, 2 circulars have been issued by the government of India, my lord. Those circular, I am also relying upon those circulars, but that particular circular says that a physically handicapped person, he can compete with a unreserved category, but he cannot compete with a OBC category or a SC/ST category, that is a reserved category. I'll just place those circular, my lord, then they can also develop their argument. I will also, my lord. Tomorrow also it can be taken up.
Very well. We'll go through the circulars.
Next week, ಹಾಕೋಣ?
Yes,
Please.
Sir, thought
yes.
the circulars, the memo
With circular,
with circulars filed by learned CGC na?
Yes, ma'am.
CGC is taken or taken on record, is taken on record. Call this matter, ಅದೊಂದು date ಕೊಡಿ.
Except 28, any date, ma'am.
Fourth of.
Please.
Much.
Grateful.
ಇದು ರಾಜು ಇದ್ರಲ್ಲ ಇದೆ. ರಾಜು ನೆಲ್ ಕಳಿಸಿದ್ರಿ ನಾಯಕ್ರೆ?
Yes, madam.
ರಾಜು ಅವ್ರು ನೆಲ್ ಕಳಿಸಿದ್ರಿ ನೀವು?
ಎಲ್ಲಿ ಹೋಗಿ
ಇದ್ರಿ ಆಗ್ಲೇ ಯಾವ್ದೊಂದು ಮ್ಯಾಟ್ರಿಗೆ.
ಇದರಲ್ಲಿ
ಹಾ.
ಇದರ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ 2010ಗೆ ರಿಟೈರ್ಮೆಂಟ್ ಆಗೋಗಿದ್ದೀನಿ ನಾನು ಅವಾರ್ಡ್ ಬರೋ ಅಷ್ಟೊತ್ತಿಗೆ and enquiry was set aside and then my lord the labor tribunal industry tribunal holds that charge not proved. ನನ್ನ ಯಾಕೆ ಹಾಕ್ತಿದ್ರೆ 75% ಕೊಟ್ಟಿದ್ರು ಫುಲ್ ಕೊಡಿ ಅಂತ ಹಾಕ್ತೆ because ರಿಟೈರ್ಮೆಂಟು. He did not even receive 1 rupee gratuity because of this pendency of this writ appeal and all that. Writ petition, I'm sorry. It's a CGIT award. Division bench ಅಂತ ತಮ್ಮ ಮುಂದೆ ಇರೋದು. ಸ್ವಲ್ಪ ಒಂದು
ಪೇಪರ್ ನಮಗ್ ಬರ್ತದಾ?
ಹೌದು CGIT ತಮ್ಮ ಮುಂದೆನೆ ಬರುತ್ತೆ. CGIT ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ಗಲ್ಲ ಇವಾಗ ತಮ್ಮ ಮುಂದೆ ಬರುತ್ತೆ. ಸ್ವಲ್ಪ ಏನಾದ್ರು ಮುಂದಕ್ಕೆ ಹಾಕಿದ್ರೆ ಸ್ವಲ್ಪ ಹತ್ತಿರ ಕೊಟ್ಟರೆ ಒಳ್ಳೇದು, ಮುಗಿಸ್ಬಿಡ್ಬೋದು. 2010 ನಾನು ರಿಟೈರ್ಮೆಂಟ್.
ಕರ್ಕೊಂಬಂದ್ಬಿಡಿ.
ಆಯ್ತು, ನಾನು ಐದು ವೇಟ್
ಪಾಸ್
ಬಟ್ ಪಾಸ್ ಔಟ್ ಆಗಿಲ್ಲ.
Sheikh Saud.
There
Sheikh
is a
Saud.
case regarding acceptance of the resignation letter below. It is covered
Acceptance
by.
of
a judge.
resignation letter.
Yes, ma'am. She was working as a FDA miller. And she resigned, thereafter she withdraw the resignation letter. It is covered by the judgment, no, recent judgment.
She resigned.
She resigned.
Effect from which date?
6/6/2000.
Letter is dated
6/6, my lord.
6/6/20.
I will,
She remained unauthorized absent, Your Lordship.
6/6/19, my lord.
Letters were issued to her.
6/6/19.
6/6/90,
2019.
2019.
Yes, my lord. 19, my lord.
Annexer,
Um,
ಏನದು annexer?
Annexure ಇದೆ, yeah.
Page ಯಾವ್ದು?
24/6/2019 ಅನ್ನ.
Annexure. Sorry, my lord.
Lordship may kindly see para 13, your lordship, page
No, I will
66,
come, I will come that. I will come that.
page 66.
My lord, thereafter, my lord.
She remained unauthorizedly absent for what period? From which which date to which date?
She remained, your lordship, from 22,
Ah,
2/2/2019, your lordship, 2/2/2019.
19.
Up to the date, she has tendered her resignation, they say, lordship.
136, my
Almost
lord.
90 days.
6/6/2019.
Please. That she has not submitted according to us, lordship.
Not given at all.
No, that is all.
Page
How
number-
you sent
Only
that letter?
after, lordship may kindly see the letters issued to her, reminders
One
to
second.
explain.
How you sent that resignation letter? When it was sent, how?
My lord, it was in person, it was sent, my lord, on 6/6/2019, my lord, at page 136, my lord.
136.
Yes. It was received on 24/6. I think there is endorsement on that.
25/6.
25/6, yes.
ಇದು ಇನ್ವರ್ಟ್ ರಿಜಿಸ್ಟರ್ನಾಗ ರೆಕಾರ್ಡ್ ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ ಅಂತ ನಾವು ಹೇಳೋದು.
ಆಗಿಲ್ಲ. ಎಲ್ಲಿ where have you taken up that
6/6.
contention?
You have stated in reply itself, your lordship,
ಎಲ್ಲಿ?
that reply, lordship, para 4, 60, page 60, lordship,
Court.
of the order itself, KT order.
ಅಲ್ಲ ನಿಮ್ಮ ಸ್ಟ್ಯಾಂಡ್ ನಲ್ಲಿ ಎಲ್ಲಿದೆ? Where have you drawn your legal? The battle lines are drawn ಆಗಬೇಕಲ್ಲ. Come to 96.
They admit that, my lord, and they ask for explanation, my lord. I have given the explanation.
Later, regarding 6/6/2019, and however, the applicant had submitted one more application on 24/6/2019. The respondent content that letter dated 22/12/2010 was issued to the applicant to submit her explanation and unauthorized absent her resignation, to which there has been no reply.
Two 2019 to 25/6/2019.
She remained unauthorized absent, your lordship, all the documents she has kept under lock, all the registers as well.
My lord, it was a COVID-19 period, my lord.
25/6. No.
No,
No.
it's not a COVID.
No.
It was not.
COVID came to be declared on
March
25.
2020.
25/3/2020.
2020.
COVID is only an invention. Unless your party was a she had complicity in generating that virus
So,
in advance.
Lord, on 24/6/2021, Milan, I have sent a letter, Milan, at page 46, Milan. We kindly put
That is
that.
6/6/2019.
24/6/21, Milan.
24/6/21.
Yes, Milan.
No, you have remained absent and you had not even given the key of the cupboard which contained important records for delivery.
I explained everything, Milan.
Where, what you have explained?
The 24/6/2021.
Page?
Page 46, Milan.
46.
Annexure P, Milan.
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡ್ಯಾರೆ?
Sir, she served, my lord, she served, was appointed, my lord, on 17/10/2012, my lord. As a SDC, my lord. She was promoted, my lord, thereafter, my lord, as a FDA on 27/6/2018, my lord. And she was sent,
For unauthorized absent, what action you took?
She has not at all explained anything, Your Lord.
All, she did not explain. You called for explanation. She did not reply. Then what happens in law?
They accepted that as resignation, Lords.
No resignation ಕೊಟ್ಟು ಹೊರಟೇನಿ ಅಂತ.
Para 50, page 53, Lords. ಮೇಲಿನ
you-
ಪ್ರಸ್ತಾವನೆಯನ್ನು 53, Lords.
53.
ಮೇಲಿನ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿ ವಿದ್ಯುತ್ ಪರಿವೀಕ್ಷಕರು ಶಿವಮೊಗ್ಗ ಕಚೇರಿಯ ಪ್ರಥಮ ದರ್ಜೆ ಸಹಾಯಕರಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಶ್ರೀಮತಿ ಶೈಲಜಾ KL
53 ನಾ? ಏನೋ ಪೇಜಿನೇಷನ್ ಸಮಸ್ಯೆ ಆಗಿದೆ.
53.
ಕರೆಕ್ಟ್ ಪೇಜಿನೇಷನ್ ಮಾಡೋದೇ ಇಲ್ಲ ಲಾಯರ್ಸ್ ಎಲ್ಲ. ನಿಮ್ ಕೊಡೋದೇ ಒಂದು, ನಮ್ಮ ಹೊತ್ತಿಗೆ ಒಂದು, ಅವ್ರ ಹೊತ್ತಿಗೆ ಒಂದು. ನೆವರ್ ವಿ ಆರ್ ಆನ್ ಸೇಮ್ ಪೇಜ್.
not,
Except few, Your Lord.
no, it is not 53.
You 48.
40?
Annexure ಎಷ್ಟು?
48.
You page 48 ಮಾಡಿಕೊಳ್ಳಿ.
ಅದು 28/1/22.
Please, Lord.
Yes, ma'am.
Please, Lord.
28.
ಅಧಿಕೃತ ಜ್ಞಾಪನ ಪತ್ರ,
ಅಧಿಕೃತ ಜ್ಞಾಪನ ಪತ್ರ.
ಆಮೇಲೆ ಆದೇಶ.
ರಾಜೀನಾಮೆ ಅಂಗೀಕರಿಸಲಾಗಿದೆ.
That is the only reason, my lord, not for our unauthorized absent.
For unauthorized absent, there in so many words. So many words. We
Similar-
flooded with those words.
Similar circumstance, my lord, is covered by judgment.
You want to withdraw the resignation?
No, my lord, I want to continue, my lord.
In-
We
in-
continue.
Continue in employment,
Yes, my lord.
but that has been accepted.
That is illegally accepted, my lord.
How?
That's the reason I have challenged it, my lord. It
How?
is not my explanation, my lord. It was not considered, my lord. It was not received, my lord.
It has been, where is the requirement of communicating? What in Indira Nehru Gandhi versus Randhara in Supreme Court said, a resignation need not be communicated, acceptance of resignation need not be communicated.
I'm a very small man, my lord, FDA, my lord. That
All
is-
are
that
small
will lead.
before law. We are also not tall. ಅದೇ ಮಾಡ್ಲಿಕ್ಕೆ.
Sir. So,
Then resignation, Supreme Court said, ordinarily can be retrieved before it is accepted. Sometimes, in very special cases, even after acceptance, resignation is permitted to be withdrawn, provided the vacancy is not filled up and plausible explanation is offered. That's the law. That's how Samaraditya Paul treats the matter in his service law book.
one submission, my lord. After a designation, my lord, it has to be, explanation has to be called from the person, my lord, employer, my lord. For that reason, if that notice is not served on him,
Made
my lord.
absent from 2/2/2019 to 25/6/2019. On, you gave letter on 25/6/2019,
I was
which is
not-
dated 6/6/2019, which you have admitted in your own letter in other letters. You have admitted that. You have referred to that letter. ಅದೇನು ಅದು ಯಾವಾಗ ಬಂದೆ ಯಾವಾಗ ಹೋದೆ ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದ? ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಪಬ್ಲಿಕ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆ ವೇಕೆನ್ಸಿ ಏನಾಗಿದೆ ಈಗ? ವಾಟ್ ಹ್ಯಾಪನ್? ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? You can't withdraw that way. So there is only one ILR 1990s Bank of Baroda versus so and so. There is only one judgment of Justice Thakur's judgment from our High Court.
So,
That correctly lays down the law. Ali, withdrawal.
Just here, my lord.
Krishna Dikshit on withdrawal of resignation. Take out that judgment. ಏನು ಪ್ರಿಪರೇಷನ್ ಮಾಡ್ಕೊಂಡ ಬರೋದಿಲ್ಲಲ್ಲ, ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತೀರಿ ನೀವು? ಒಂದು ಗೂಗಲ್ ಹೊಡೆದು ಸಿಗ್ತಾವಪ್ಪ ಜಜ್ಮೆಂಟ್. law relating to resignation by Neelendra.
May I submit?
Kumar.
Mr. Milord? The latest letter
Please.
judgment. Please.
That was a case where the employee said, on a future date, I am retiring from the case. Resignation letter ಕೊಟ್ಟರು. ನಾನು ಈ ಗ್ರಹಣ ಆದ್ಮೇಲೆ ರಿಸೈನ್ ಮಾಡ್ತೀನಿ ಇದ್ದಾಗ ಗ್ರಹಣ ಆಗುವ ಪೂರ್ವದಲ್ಲಿ ಯಾವ ಬೇಕೋ ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ದಟ್ಸ್ ದಿ ಲಾ. ಅದೇ ರೀತಿ ಇದ್ರ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ. Come to para 11, come to page 7. I'll reproduce ಮಾಡ್ಯಾರ ನೋಡಿ. Not a
Submit.
single judge has given best reason. That's the law. Right from the days of Indira Nehru Gandhi. In the present case, the resignation which was submitted on 5/12/2013 with a request to accept it at a expiry of 1 month was stated to have been accepted only on 15/4/2014. There is undue delay in accepting the resignation by respondent. In the above decision, the delay of over 13 days in communicating acceptance of the resignation is held to be not an undue delay, so as to infer that resignation had not already been accepted. Therefore, decision in Vadapati is also of no help. In this, I am of the view that petitioner, having submitted his letter dated 26/5/2014, seeking to withdraw the resignation much before the effective date. That's not your case. Okay. Dismissed. Keeping in view the law developed precedent by precedent to the effect that resignation can be withdrawn anytime before it is accepted. Sometimes soon after acceptance also courts have permitted withdrawal, reason being shown and the vacancy continuing. There is no requirement of communicating acceptance of resignation unless the rules otherwise provide for. First off, this is how the apex court decision in SD Manohara reflects the matter. First off, in view of the above, petition is dismissed. Next. Yes, Satisha. Why lawyers are not doing research? Research ಹೊಸದಲ್ಲ, ಈಗಾಗಲೇ ರೂಲಿಂಗ್ಸ್ ಇರ್ತಾವಲ್ಲ ಅದನ್ನೇ ನಾವು ಕೇಳ್ತಾ ಇರೋದು. ಹೊಸದು ಇನ್ವೆನ್ಷನ್ ಮಾಡೋ ಅಗತ್ಯನೇ ಇಲ್ಲ ನಮ್ಗೆ. ಅದನ್ನೂ ನೋಡ್ದಂಗೆ ಬರ್ತಿರಲ್ಲ ಯಾಕೆ? ನಾವು ಅದರಲ್ಲೇ ಟೈಮ್ ಕಳೆದ್ಬಿಟ್ರೆ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೇಗೆ? ಎಲ್ಲಿ ಅಪ್ಡೇಷನ್ ಇದೆ? ಬಾಂಬೆ ಲಾಯರ್ಸು, ಡೆಲ್ಲಿ ಮಡ್ರಾಸ್ನವರು ಹೆಂಗೆ ಎಷ್ಟು ಅಪ್ಡೇಟ್ ಹಾಕೊಂಡು ನಾವೊಂದು ಜಡ್ಮೆಂಟ್ ಹೇರ್ ನೋ ದಟ್ಸ್ ನಾಟ್ ದ ಕರೆಕ್ಟ್ ಪೊಸಿಷನ್, ಲಾ ಹ್ಯಾಸ್ ಮಾರ್ಕ್ಡ್ ಅಂತ ಇಮಿಡಿಯೇಟ್ಲಿ ಹೇಳ್ತಾರೆ ಅವರು. ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ ಟು ಅವರ್ ಬಾರ್? ಇನ್ ಸಿವಿಲ್, ಕ್ರಿಮಿನಲ್, ಸರ್ವಿಸ್ ಎಲ್ಲದರಲ್ಲೂ ಹಿಂಗಾಗ್ತಾ ಇದೆ. ಬಿಕಾಸ್ ಇನ್ ವೇರಿಯಸ್ ಬ್ರಾಂಚಸ್ ಐ ಆಮ್ ಸಿಟಿಂಗ್. ಏನು ಪ್ರಿಪರೇಷನ್ ಇಲ್ದಂಗೆ ಹಂಗೆ ಇಲ್ಲಿ ಬಂದು ನಿಂತ್ಕೊಳ್ಳೋದು, ನಾವು ಹೇಳಿದ್ದಕ್ಕೆ ತಲೆ ಹಾಕೊಂಡು ಹೋಗಿದ್ರೆ ನಿಮ್ಮ ರೋಲ್ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ ನಮಗೆ. ನಾವೇ ಇನ್ನೂ ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡು ಹಂಗೆ ಡಿಸೈಡ್ ಮಾಡಿಬಿಡ್ಬೋದು. Yes, madam.
May I, my lord, service is not.
We are only saying not finding fault. You are paid. ನಿಮ್ಗೆ ದುಡ್ಡು ಕೊಡ್ತಾನೆ ನಿಮ್ಮ ಕ್ಲೈಂಟ್. ದುಡ್ಡು ಕೊಟ್ಟಾಗೂ ಕೆಲಸ ಮಾಡಲ್ವಾ? ಹಂಗೆ ಪುಕ್ಕಟೆ ಜೋಬಿಗೆ ಹಾಕೋತೀರಾ? ನಾವು ಸ್ಯಾಲ್ರಿ ತೋತೀವಿ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ನಾವು ಓದ್ತೇವೆ, ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೋತೇವೆ, ಯಾವ ರೀತಿ ಜಸ್ಟಿಸ್ ಮಾಡಬೇಕು ಅಂತ ನೋಡ್ತೇವೆ. ಯಾಕೆ ನೀವು ಲಾಯರ್ಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ? ವೈ ಲಾಯರ್ಸ್ ಆರ್ ನಾಟ್ ಡೂಯಿಂಗ್ ದಟ್? ನಿಮ್ಮ ಲಾಯರ್ಸ್ ಮೇಲೆ ಇನ್ನೂ ಯಾವ ಕ್ಲೈಂಟ್ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮ್ಗೆಲ್ಲ ಹೋಗಿಲ್ಲನು? ಯಾಕೆ ಕೇಸ್ ಹಾಕ್ತಾರೆ? ಇಂಗ್ಲೆಂಡ್ ಅಮೆರಿಕ ಆಗಿದ್ರೆ ನಿಮ್ಮ ಮನೆ ಮಠಗಳೆಲ್ಲ ಹರಾಜಾಗ್ತಿದ್ವು. ಏನು ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ಪ್ರಿಪರೇಷನ್? ಸೆಕೆಂಡ್ ರೇಟ್ ಪ್ರಿಪರೇಷನ್. ಸೆಕೆಂಡ್ ರೇಟ್, ಐ ವಿಲ್ ನಾಟ್ ಸೇ third rate. Yes,
Service is not
but
completed.
in some judgments, we are making scathing attack on lawyers when they do not perform. More particularly, the standing counsel, government lawyers, so and so counsel, etc. ಒಂದು ಬಿಗಿಯಾಗಿ ಒಂದು ಬರಿತೇವೆ, ಆಮೇಲೆ ನಮ್ಗೇನು ಅನ್ಬಾರ್ದು ಅಷ್ಟೇ. ಒಂದ್ರಲ್ಲಿ ಬರೆದು ಹಾಕ್ತೇವೆ ನಾವು. Yes.
Lord, service is not completed in so far as respondent.
ಯಾರಿಗೆ?
1 to 2 is concerned, my lord.
Lord, respondent may not be necessary, but short question is, my lord, an articles of charge was issued under Rule 12 of the CCA rules. Rule 12 is pertaining to, my lord, procedure for imposing minor penalty. But an articles of charge was issued against the petitioner.
But major penalty issue ಮಾಡಿದ್ರು.
ಇಲ್ಲ, minor penalty ನೇ ಮಾಡಿದ್ದಾರೆ. Lord, the law on this point is, my lord, once an articles of charge is issued, delinquent appears before the government and denies the articles of charge, then, my lord, it should be
Inquiry is there.
preceded by, my lord, a regular inquiry. Though, my lord,
Minor.
what is contemplated in Rule 12 is, my lord, minor penalty.
Still inquiry is there.
Still
If
inquiry
there
is
denial.
is, my lord, the law laid down by this honorable court in V. Srinivas Rao and, my lord, OK. Bharadwaj. Court of-
Justice ದತ್ತು ಸಾಹೇಬ್ರದ್ದು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು.
Yes. Court of-
ಇವ್ರು ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಲಿಲ್ಲನೋ?
Inquiry is not done, my lord.
ನೋ ಎನ್ಕ್ವೈರಿ.
My lord, punishment is withholding of 1 increment, my lord, without cumulative effect, my lord. That is, my lord, under Rule 8, my lord, subclause 3, my lord, punishment.
No, question is not that.
May I
It is
read?
like one saying, we have taken only 1 gunta of land. Therefore, we did not go by the due process. Law says, whatever, because it will be stigmatic.
Please, ma'am.
Though minor punishment will not come in the way of he earning promotion, but it is stigmatic. One thing. Number 2, it puts a hole, small hole, a pinhole in his pocket.
Please.
ಅಷ್ಟು ಕಡಿಮೆ ಆಗುತ್ತೆ ಅವನಿಗೆ ಸ್ಯಾಲರಿ.
Rule 12, my lord, pertains to procedure for imposing minor penalties, my lord.
12.
Please, my lord.
Padi. Does it dispense with the inquiry even when allegations are denied? 12.
Please, ma'am.
Read. Subject to the provisions
subject
of
to the
11A.
provisions of
No other,
sub-
no order imposing on a government servant a penalty specifying shall be made except after informing the government servant in writing of the proposal to take action against him and of the imputation of misconduct which is proposed to be taken, and giving him a reasonable opportunity of making such representation as he may wish to make against the proposal. Holding an inquiry in the manner laid down in, holding inquiry is a must.
My lord, further, my lord, first one
Provided
case-
that no order imposing a penalty of withholding increments with cumulative shall be made without holding an inquiry in manner laid down. ಇದು ಕ್ಯುಮ್ಯುಲೇಟಿವ್ ಅಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡೋದು ಬೇಡ ಅಂತ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್. ಇಫ್ ಇಟ್ ಫಿಟ್ಸ್ ಇಂಟು 12B,
Rule 12 is summary proceedings, my lord.
12B summary proceeding
My lord, first is opportunity should be given, my lord.
to
Second,
make
my lord,
representation.
please, my
etc.
lord.
And 2
Second,
is
my lord,
holding inquiry.
2 is holding inquiry in the manner laid down in sub-rule
3
to 23. 3 to 23, my lord, deals with other
ಅಲ್ಲೇನ್ ಹೇಳ್ತಾರೆ?
major,
It is major penalty.
major penalty of Rule 11. In every case in which the disciplinary authority is of opinion that such inquiry is necessary.
Such inquiry is necessary.
Please, my lord.
If he feels that it is necessary, then alone
Yes, my lord.
the obligation to hold the inquiry, not otherwise.
Yes, my lord.
How he will form opinion, in which case inquiry to be held, in which case inquiry need not be, which is the normative basis for that.
Lord, may I submit, my lord? The respondent, my lord, he was working as a PDO, my lord. While he was working, my lord, there was an encroachment in the public road, which was not removed by the respondent, my lord. For that, my lord, they have imposed a minor penalty of withholding 1 increment, my lord, without cumulative effect, my lord.
So inquiry need not be held at the stand,
Since
per stand, based upon
yes,
the rule position.
please, my lord.
But share the copy of the judgment. 89 Karnataka,
Para 5,
Ramajoy's judgment. 5.
Para 5, my lord, of the judgment. In our opinion, the contention urged by the learned counsel for the appellant is well founded. We respectfully agree with the view expressed by the Kerala High Court. We are also of the view that even in cases where a minor penalty is proposed to be imposed against a civil servant, if the nature of the charge or charges leveled against him are such that a finding of guilt could be recorded only after holding a regular inquiry, in which oral and documentary evidence in support of the charges should be recorded, and the delinquent should be given an opportunity of cross-examining the witnesses or explaining the documents. Holding of an inquiry as provided under Rule 12(1)(b) becomes mandatory, and disciplinary authority is bound to form an opinion that holding of an inquiry is necessary and to hold an inquiry. Then, my lord, the charge is that, my lord, I have not removed the encroachment.
ನೀವೇನ್ ಹೇಳಿದ್ರಿ?
Please,
What you said in your reply.
Lord, I have stated that I have removed the encroachment while I was working as Panchayat Development Officer, as in charge Panchayat Development Officer for 52 days. I was only in charge, Lord, Panchayat Development Officer. I was not a regular holder. Nevertheless, my lord, I was bound to, my lord, remove the encroachment.
Where is that? You said that I have removed the encroachment.
Yes, my lord. Page,
You have to prove it.
page 90, annexure A7 is the reply to the charge memo, my lord. Before that, your lordship may kindly come to page 81 is the charge.
81.
81 is the charge. Is that, my lord, in respect of survey number 46, I have failed to remove the encroachment. First charge, the sole charge, my lord.
All right. What
Page 90 is my reply.
90. You said that I have removed.
Yes, ma'am.
How you show that you have removed?
Yes, ma'am. Page 90.
All right. You said that you have.
I have,
removed.
then,
Show
my
that
lord,
you have removed. Now they need not prove anything because you accepted the charge.
yes,
And your reply is I have removed.
removed.
Let's show that removed.
Not removal, my lord, no document is produced.
Charge is because because
Yes,
whether it is removed or not, you said I have removed.
yes, ma'am.
They said you have borrowed money and you have not repaid. You say I have repaid. Then borrowing need not be proved at all.
But it is to be, my lord, when I, my lord, deny the charge, it is to be tested in evidence whether, my lord, there is an encroachment removed or not is a, my lord, question of
You
fact.
have taken, correct. Encroachment remove ಆಗಿದೆ. So prima facie ತೋರಿಸಿ remove ಮಾಡಿವಿ ಅಂತ.
My lord, page 90, my lord.
ಅದು ನಿಮ್ಮ ವರ್ಷನ್ ಆಯ್ತು. ಅದು ರಿಮೂವ್ ಮಾಡಿದ ಬಗ್ಗೆ ಒಂದು ಮಹಜರ್ ಡ್ರಾ ಮಾಡಿದ್ದೇವೆ.
ಮಾಡಿದೀನಿ,
ಎಲ್ಲಿದೆ?
ಮಾಡಿದ್ದೀನಿ. Lord, yes,
ಅದು ತೋರಿಸಿ.
yes. Last line, my lord, ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆಯವರು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ರವರಿಗೆ ಈ ದಾರಿ ತೆರವುಗೊಂಡಿರುವುದನ್ನು ಸ್ಪಷ್ಟಪಡಿಸುತ್ತಾರೆ. ಸದರಿ ದಾರಿ ತೆರವುಗೊಂಡಿರುವುದರ ಬಗ್ಗೆ ಗ್ರಾಮಸ್ಥರ ಹೇಳಿಕೆಯನ್ನ ನೀಡಿರುತ್ತಾರೆ.
ಎಲ್ಲಿದೆ ಅದು?
ಪೇಜ್ 90, my lord.
ಅದು ನೀವು ಓದ್ತಾ ಇದ್ದೀರಾ? ಅದೆಲ್ಲಿದೆ? ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದು.
ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಮತ್ತೆ
At any rate, my lord, they admit that, my lord, I have given my reply, which is at impugned order, also refers that, my lord, I have given my reply, and my lord, it does not say that, my lord, encroachment is removed. Prima facie, my lord, he has worked for 52 days, only 52 days.
ಅದು ರಿಮೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಏನಿದೆ? ಆ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಳ್ಳಿದ್ರೆ perhaps you would have been better. You have taken a particular stand which you have to adumbrate.
But impugned order itself says that, my lord, I have removed the encroachment.
ಎಲ್ಲಿದೆ?
Page 97.
97.
Yes, ma'am. But, Lord, it says that only after giving complaint to the Honorable Uplokayukta, I have removed the encroachment. Page 97, my lord. ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರ ವರದಿ, ದಾಖಲೆಗಳು ಮತ್ತು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ಇವರ ವರದಿ ಮತ್ತು ದಾಖಲೆಗಳ ಮತ್ತು ಆಪಾದಿತರುಗಳು ಸರ್ಕಾರದ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸಿಗೆ ನೀಡಿರುವ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನ ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದಾಗ
Madam.
Yes,
He
ma'am.
has removed, after
After the complaint being made before the Uploka Act.
ಆಮೇಲೆ ರಿಮೂವ್ ಮಾಡಿದೀನಿ ಅಂತ ಆಫ್ಟರ್ ಗಿವಿಂಗ್
ಮಾಡಿದೀಯ ನೀನು ಎಲ್ಲಿ ಮಾಡ್ತಿದ್ದೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ ಅವ್ನ ಕಣ್ಣಿಗೆ ಯಾರೋ ಒಬ್ಬನು ಅದಾದ್ಮೇಲೆ
ಮೇ ಬಿ ಲಾರ್ಡ್ ಆಫ್ಟರ್ ಗಿವಿಂಗ್ ಕಂಪ್ಲೇಂಟ್
ಬರ್ಕೊಳ್ಳಿ. State and it's the state is invoking the writ jurisdiction of this court. Kutwali.
Yes.
Grieving against the state administrative tribunal's order dated 25/10/2021, whereby private respondents application number 1800 of 2021 having been favored, the punishment order dated 19/3/2021, whereby one annual increment without cumulative effect has been withheld, has been set at naught. First, the tribunal has reserved liberty to the petitioner to hold inquiry if it so chooses, hold regular inquiry in accordance with law. First, learned AGA appearing for the petitioner vehemently argues that the subject punishment is specified as a minor penalty under section Rule 8
Rule 8(3).
Rule 8(3)
Yes, ma'am.
of KCS or CCA rules 1957. Semicolon.
8(3).
When the charge memo was issued, articles of charge was issued, kutkonde heli. The delinquent employee had sent his reply denying the charge. In the considered opinion of the competent authority, the regular inquiry was dispensed with, and looking into the records, the subject punishment was awarded, and that would not come in the way of the respondent earning promotion. That being the position, the tribunal is not justified in setting aside the punishment order for want of a regular inquiry. First, next join. Learned counsel appearing for the respondent employee with equal vehemence makes a submission in justification of the impugned order of the tribunal and the reasons on which it has been structured. He presses into service a coordinate decision of this court in V. Srinivasa Rao versus State of Karnataka, 1989 SCC online, Karnataka 363, in support of his stand that inquiry is a must, even if the charge memo is issued for a minor punishment, once allegations are denied. First, he also draws attention of the court to the 12-2 report, government order, to the punishment order, wherein the alleged encroachment of a public road has been removed, albeit after complaint was carried to Upaloka. First. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we declined indulgence in the matter, broadly agreeing with the submission made on behalf of the delinquent employee consistent with the division bench judgment, wherein judgment in Srinivasa Rao Supra, wherein paragraph 5 reads as under. First. Next paragraph. The other reason for declining indulgence is that the liberty has been reserved to the petitioner government to institute a regular inquiry if it so chooses and accomplish things in accordance with law. First, in the above circumstances, petition being devoid of merits is liable to be dismissed, and accordingly it is clear. Costs having been made easy.
Lordship may add, Lord, he is retired on 31/5/2024.
Oh,
That is
and
one
last
more.
line brother, if it chooses liberty, then I'll add madikebek. Now that liberty cannot be availed in as much as we are told at the bar that the delinquent employee has retired peaceably on
31/5/2024.
before on attaining the age of superannuation. Okay. Six. We'll come back. We have one recruitment committee meeting, judges recruitment committee meeting.
Judgment ಹೇಳಿ ಶ್ರೀನಿವಾಸ ರಾವ್ 1989. ಶ್ರೀನಿವಾಸ ರಾವ್
1989 CC AR is contention before he paid what repair is not That is in orders.
ನಾವು ಬಯಸ್ಕೊಳ್ಳೋದಲ್ಲ ಅಲ್ವಾ? ನಾವು ಬಯಸ್ಕೊಳ್ಳೋದಲ್ಲ.
I have rightly pointed out, 8 3 and
suit is filed.
You did not,
I did not avail the opportunity.
I have not made me party and notice was not served in earlier proceedings, my lord.
you
He
you
was a
were-
party. I
He
have,
was a party, but notice was not served.
in fact, she contested it.
It was filed on 5/7, my lord.
Your appeal is also there.
No, no,
You want to resist the appeal
yes.
on the ground?
On the, is having a valid judgment of the lower court.
Saying,
Partition is valid.
no, he is saying, I had no opportunity, reasonable opportunity
No,
of
no,
contesting the suit.
yes, my
And
lord.
there are many grounds on which suit could have been resisted. Therefore, give us one more opportunity by sending the matter back by remand.
And put me on any terms.
On terms.
My lord, permission, my lord. In his petition filed before this court, he is saying is a stranger. Respondent number one is a stranger.
Respondent number one
That
is a
is, that
state.
is contesting defendant.
He, appellant, no.
Now, here, my lord, he is contesting against me only, my judgment in the lower court.
Huh.
He stated in the RSA, RFA, my lord, in the para 9.
Huh.
But he is saying, I'm
Suit is
stranger.
of which year?
Suit is of the year
2007, my lord.
2007.
Seven, my lord.
He can.
And my lord.
2007.
Not only that, my lord, they filed.
And
RFA
appeal was filed in
In
2000.
2015, after 2015 till 2022, file was lying. They were not, office objection was not passed on. Sorry, ma'am.
With this, sir. This
Sorry,
was-
sorry, ma'am.
Do you come from kindergarten?
Yes.
But this option is there. Suppose. That is there also, but Justice Swami's judgment. Suppose now you think of the opportunity. Can you still sustain the treatment merely because it is getting older? Setting the settings particularly. Why, why you were served with the court notice?
I was served with the notice, my lord.
What is
There-
your educational qualification?
We are all villagers.
Huh?
Villagers.
No, what's your educational qualification? What is he standing in the life? What he does do for earning livelihood?
Agriculture.
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 How many acres of land?
My lord, first plaintiff is aged about 71 years. First defendant is aged about 71 years. Second defendant is aged about 60 years. And so also are all rustic villagers.
That your 4127.
Yes, ma'am.
What are the grounds?
There are two, in fact, along with the Article 41 Rule 27 application. In fact, in respect of this very suit scheduled property,
Res judicata.
there was an earlier suit filed by defendant 7 and 6 and 7. That was dismissed by the trial court, confirmed in the REA. In fact, after the filing of this suit, our contention is, after filing of this suit, we brought to their, the plaintiff was also a party to that suit, earlier suit.
Has he mentioned it anywhere in his plaint?
No, there is absolutely no mention
Not
about,
mentioned.
no, there is absolutely no mention about that earlier suit.
Have
And
you-
we have said that because in respect of this very property, there was an earlier partition suit, we informed her, you withdraw the suit. And she assured us that she will not pursue the suit. And thereafter, because we didn't, on her assurance, we did not contest the suit. That is what we have stated in my application for, along with Article 41 Rule
It's
27.
not that you should avail order 9.
Rule 13.
I could have, Malla. I could have.
Then there is one judgment which has come, I think by Supreme Court, which says that 9 rule, if you are pressing any
That is
of
more
the-
efficacious remedy.
of the grounds which are amenable under order 9,
True, my lord.
then you should go there.
True, my lord.
Here, we cannot consider 9.
Yes.
The grounds which are available for 9, order 9.
Yes, madam. I fully agree with that.
If you want to go on merits, yes, but not 9. The
True, my lord.
choice is yours. This forum, appellate forum, is only in respect of the merits of the case. You cannot avail the grounds which are available under
Order 9. Yes.
That if you want to test it, you have to go there only.
If that
ground
liberty
we
is
cannot
given, my
consider.
lord,
That
I
is
shall-
your choice. This is what
understand.
earlier we were having Justice K. Swami or judgment ittu. Otherly, even that ground also we considered. That was there. But I think that situation has changed anta ansutte.
May I look into that and make my
ನಿಮಗೆ
submission.
ಲಿಬರ್ಟಿ ಕೊಟ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ತೀರಾ?
Liberty ಕೊಟ್ರಲ್ಲಿ ಹೋಗಿ we will pursue order 9 rule 13 petition.
ಒಂದು ಮೆಮೊ ಕೊಡಿ.
Please, ma'am.
And for a period of 6 weeks, you will not enforce the decree in question. Because he is withdrawing the appeal on the ground that alternate remedy is available where he can take up those contention and you can take up your contention also. We will give that liberty to you.
Whether the notice was served or summons was served or
Ah.
not served, all those things.
Yes, my lord.
That has to be
Tested there only.
tested there only.
My client is 92 years old. We will fix, I will make it a time bound exercise also. If that
In-
application is filed, should be
instead-
heard and
Instead-
decided.
I may appeal to my lords like
Yes,
this. Lord, instead of my, because the plaintiff is already 92 years, miscellaneous petition will take couple of, instead of that, appeal, judgment can be set aside, fixing time bound
No, my
direction.
brother has said because of 2019 judgment, 2019 or some judgment. Earlier view, Justice Swami's view was,
Yeah.
the availability of order 9 rule 13 is no ground for sending the client back, litigant back. That also can be examined, was the view. That view appears to be loosened now.
Yes. May-
Therefore, if you file a memo, we'll give you liberty. You have to file the application actually. Because order 23 rule 1 ಕೆಳಗಡೆ application ಹಾಕ್ಬೇಕಾಗ್ತದೆ.
Can it be taken up?
Tomorrow.
Day after tomorrow.
Next week ಹಾಕೊಳ್ಳೋಣ?
Please,
Next week. All.
grateful.
One or two matters we have done that exercise while I was. in
Please.
Harvard in a division bench.
Please, ma'am.
Just ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. just.
Great.
ನೋಡಿಕೊಂಡು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ. ನಾವು
ಆಯ್ತು.
ಹೇಳಿದ ಹಾಕ್ಬೇಡಿ. ಹೇಳಿದ್ದನ್ನ ನಾವು ಇಕೋ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಅಷ್ಟೇ. ಹಂಗಾಗಿ we do not know because what objections he will have, we do not know. Because you have to serve copy of the application on him. He may have his own objections, we do not know.
Yes.
He may not now reveal all his cards.
Yes.
So you take your own decision as to
Please.
what should happen to your litigation.
Yes.
We only discussed legal aspects.
Oh, please.
Much.
Great.
All. 2007 suit.
Sorry, my lord, I represent PB Raju. I'm sorry, my lord, for not
Ah.
being present. And the
Yes,
case-
Renuka madam.
But, I'll shorten my argument, my lord. I'll not take much time, my lord.
You can take whatever time you want.
No, no, my lord, I just want, because I
We
have.
know you will not take much time, we know that.
That's the reason, my lord.
Ah.
My lord, I just
ಏನಿದು?
take, first charge ಹೇಳ್ಬಿಡ್ತೀನಿ, ಆಮೇಲೆ, my lord,
Ah.
2-3 sentences, my lord.
Ah.
My lord, Annex C, my lord, page 54, the charges are listed, my lord.
54.
Yes, my lord, 54. In my writ petition, my lord, that is 4059, my lord,
Ah.
of 21. My lord, the first charge, my lord, the inquiry officer, my lord, after holding an inquiry, the inquiry officer, my lord, submits his findings holding that charge number 1, 4, 5 and 7 as proved, my lord. Charge number 2, 3, 6 is not proved, my lord. One is proved, my lord, and 4, and 5 and 7, my lord.
1457.
Yes, my lord, because this is, the findings of the inquiry officer has been accepted by the disciplinary authority, my lord.
7.
My lord, the first charge, my lord, is colluded with Mr. Manivannan and Shivadasan to defraud the company. My lord, it's an insurance company, my lord. He was working as an assistant, my lord, in the insurance company.
Ah.
And colluded with Mr. Manivannan and Shivadasan to defraud the company and help Mr. Manivannan to fabricate bogus motor OD claims with a view to cheat the company. he used to meet Mr. Manivandan and Shivadasan under the pretext of, sorry, my lord, fourth one.
Bogus motor OD claims, huh?
Yes.
OD another?
My lord, overdraft. Claim. Then my lord, fourth one, my lord, approached Sri Tyagarajan and requested for the names of his friends and relatives having bank accounts. 5 is approached Mr. Shivadasan and requested him to furnish the names of the persons with bank account.
I
Number
think
7,
for how it will be a charge.
well, it's last one, my lord, misused the common fund of the office and also took huge amount of loan from the common fund without giving any receipt and other documents. My lord, mainly, my
So
lord,
1 and 7 ಆಗ್ತದೆ.
yes. My lord, after holding an inquiry, my lord, he was dismissed from service. And there was also an order, my lord, to recover a sum of rupees, my lord, 3,34,865. That came to be modified, my lord, by removing the recovery portion. The appeal came to be rejected. And after the appeal came to be rejected, my lord, the recovery portion has been removed, my lord, by the
Appeal
company.
came to be partly allowed.
My lord, it was-
Employees
well,
appeal.
Appeal was dismissed, my lord. After the appeal was dismissed, my lord, the order was reviewed, my lord, and that portion, my lord, the disciplinary authority itself has removed, my lord, subsequently, by way of corrigendum, my lord. The recovery portion, because there were 2 orders, my lord. One is dismissal from service. The second one is recovery of 3,34,000. My lord, that order, recovery of 34,000 was modified and removed, my lord. That portion was
Recovery was given up.
by the, my lord, and he raised, my lord, before the.
If recovery was given up on what ground?
My lord, the portion
loss
was
is the case.
deleted, my lord, by the, that portion of the order, my lord, was deleted by a corrigendum order, my lord. The disciplinary authority deleted, my lord.
Disciplinary authority deleted before proceedings began.
Before proceeding with the appeal, my lord, before he filed an
Appeal
appeal.
it was done.
Appeal ನಲ್ಲಿ file ಮಾಡಕ್ ಮುಂಚೆನೆ corrigendum issue
ಮಾಡಿದ್ರು.
ಅವರೇ ಮಾಡ್ಬಿಟ್ರು. Well, first, maybe, my lord, that they felt that, my lord, recovery may not be proper and the recovery. The appeal was rejected, my lord, against which, my lord, he raised a dispute, my lord, before the industrial tribunal.
Yeah.
Well, just take your lordship to the tribunal's order, my lord, page 87, my lord, in page 87. Well, at the third line, my lord. Now, having admitted the fairness of the domestic inquiry, the ownerships on the workman to convince the tribunal on perversity of the finding, had it there was a contradiction between the actual documents marked in evidence and the inference drawn by the inquiry officer on those documents, it was for the first party to establish the same by producing copies of those exhibits before the tribunal. Without making any effort in that direction, first party is more at seeking intervention of this tribunal in the punishment order, firstly, on the ground of harshness and disproportion of the punishment order, that is 4 charges proved against him. Secondly, on the ground of his acquittal from the criminal case.
Acquittal of the criminal case, was it honorable acquittal or for any other reason?
But it was
Honorable acquittal. There were 3.
ತೋರಿಸಿ ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಉಪಯೋಗ ಇಲ್ಲ.
and now that, my lord,
Where is that order of acquittal?
produced. Just take your lordship to the, my lord, now that he is retired, my lord, during the pendency of the case, my lord, he came to be retired. And now the award, my lord, I'll take your lordship to the operative portion of the award, my lord, page 101.
Retired ಅಂದ್ರೆ
Attained the age of superannuation.
ಹಂಗೆ ಹೇಳ್ಬೇಕು.
Sorry, my lord. Attained the age of superannuation, probably 2011, my lord. Yes, sir. 11, my lord, he attained. His dismissal, my lord, is dated 20th of September 2000, my lord. He retired in 2011. Now the order, the direction is to treat the first party workman on duty continuously till the date of his superannuation and released 75% of his back wages for the period, my lord, against which I am before your lordship, my lord.
Where is that judgment of acquittal?
ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಬಂದಿದ್ದಾರೆ. ಇಲ್ಲೂ ಇದೆ, ಮಾರ್ಕ್ ಆಗಿದೆ. ಟ್ರೈನ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಬಂದಿದೆ. ಅದರೊಳಗಿದೆ.
In fact, my lord, the matter was referred to CBI, my lord. Idralli records produced madilla annod one of the reasons, my lord, I suffered an order. But the officer said the records he could not trace, but he should have mentioned that all the original records, my lord, was with the police, my lord. Instead of saying so, he said, the witness said, my lord, that I made hectic efforts to search the documents. And later, my lord, it was,
How the judgment is structured by the criminal court? Same charges before the criminal court also,
ಅವರೇ ಆ ಮಣಿವಣ್ಣನ್ ಮತ್ತು ಅವ್ರ ಮೇಲೆ ಅವರಿಬ್ರು ದೇ ಆರ್ ಹೆಲ್ಡ್ ಗಿಲ್ಟಿ.
same set of circumstances, same witnesses.
ಶಿವದಾಸ and myself, ಮೂರರಲ್ಲಿ ಕೋದಂಡ ರಾಮನ್ is acquitted. ಮಣಿವಣ್ಣನ್ and ಶಿವದಾಸನ್ are convicted. ಅಲ್ಲೇ
They are convicted
ಹೌದು.
in the common trial.
Yes, my lord. Yes.
A1 and A2 convicted.
Para 186, my lord. Page 98, my lord, para 186. Para 186, my lord,
Of
the
criminal court judgment.
judgment.
ಇದೇನ್ ಬೇರೆ ಬೆನಿಫಿಟ್ ಆಫ್ ಡೌಟ್ ಕೊಟ್ಟು ಮಾಡಿದ್ದೋ ಅಥವಾ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದು ಏನು?
My lord, the prosecution has established the guilt beyond reasonable doubt in the case of accused number 1 and 2. And it has failed to prove the charges against. Though sanction order is held to be valid in respect of A3, the prosecution has failed to prove the charges against him. Hence,
ಫೇಲ್ ಟು ಪ್ರೂವ್ ಚಾರ್ಜಸ್. ಪಿ ವಿ ರುದ್ರಪ್ಪ ಏನಾಗ್ತದೆ ಗಾಯತ್ರಿ?
Sanction order is valid ಅಂತ ಹೇಳಿದ್ರು ಅಲ್ಲಿ. There was a
Well, it's
doubt with regard to sanction order, it is valid against me also.
You have not seen ಪಿ ವಿ ರುದ್ರಪ್ಪ yet.
ಆಮೇಲೆ ಇವ್ರ ಲಾಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ರುದ್ರಪ್ಪ ಅನ್ನೋದು.
ಪಿ ವಿ ರುದ್ರಪ್ಪ
Sorry.
ಏನು 5 postulates ಹೇಳಿ.
Sorry.
ಕೊಡಿ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಕೊಡಿ, ಆ ಪೇಜ್. ಪಿ ರುದ್ರಪ್ಪ ಯಾವ ಪೇಜ್ ಅದು? 2024 ಅಲ್ವಾ?
my lord,
No, no.
on the ground that, my lord, non-examination of the sanctioning authority fatals the prosecution case. ಅಂತ ಹೇಳ್ತಾರೆ. In respect of, it was very much argued for A3 that non-examination of the sanctioning authority fatals the prosecution case. And on the said count alone, it has to be held that sanction orders are not.
That was the argument.
86.
There is very little evidence to be sufficient to connect the accused with common commission of crime. The prosecution has miserably failed to prove the charges against the accused. The prosecution interests are unworthy of any credit and their version does not generate any conflict.
ಇಲ್ಲಿ where is the finding prosecution has failed to prove the charge?
I think para 164 madam.
164.
Admittedly, none of the witnesses referred to above. That is PW3 to PW5, PW26, one set of so. Of the third set have made allegations or pointed out against A3 in respect of any of the transactions, either A3, denied or false or both. This means there is no evidence to show that A3 has entered into conspiracy with A1.
If your lordship could see 175, my lord. Page 170, sorry, para 175. 175.
ಇದರಲ್ಲಿ ಮಿಸರೇಬಲಿ ಅನ್ನೋ ವರ್ಡ್ ಇಲ್ಲ ನಿಜ, ಬಟ್ ಯಾವ ಅಲಿಗೇಷನ್ ಮೇಲೂ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ ನಿಮ್ ವಿಟ್ನೆಸಸ್ ಅಂತ ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
My lord, page 175, my lord.
170.
Sorry, para 175. More or less, my lord. With the aforesaid documents, we have to refer to the evidence of PW 37, who alone refers to the involvement of A3.
Not there is any evidence that
That too
A3 had
remotely.
conspired with A2 in getting an answer various checks and signs. So when the only circumstance right to be brought on record against A3 is that he had obtained part of the amount provided by so and so. This circumstance is right to be proved through the said witness swears that out of the compensation of received by him towards the damages respect of the scooter owned by him, he had refunded or repaid rupees 10,000 to A1 as agreed to illegally, and that the said amount of was by A1 to A3 in his presence. Thus, the prosecution content A3 by a party to the conspiracy beneficiary of funds. So let's strike here below. The check. In the entire amount of 2,000 returned to A1 A1 ಇವರು A3 ನೋ
A3.
A3 now, A1,
And
A3.
ಒಂದು ಪ್ಯಾರಾ 177 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ
176.
177 ಅಲ್ಲೂ ಅಷ್ಟೇ ಲಾಸ್ಟ್ ಅಲ್ಲಿ 177 page 94 ಮೇಲೋ. If at all A3 had illegally conducted the business in the name of PW32 to have it could not have been clubbed with A1 and A2 ಅಂತ ಹೇಳಿ.
174 ಗೆ ಬನ್ನಿ.
176 makes it amply clear.
Between the same. Pause for So any corroborating circumstance is difficult, rather very difficult to hold it. In fact, prove it. $75. ಇದ್ರದ್ದ ಪಿ ವಿ ರುದ್ರಪ್ಪ. ಪಿ ವಿ ರುದ್ರಪ್ಪ ಆದ್ಮೇಲೆ ಏನಾದ್ರು ಲಾ ಚೇಂಜ್ ಆಗಿದೆಯಾ? ಇಲ್ಲ. Which paragraph, madam?
Para 177 my lord.
177.
177, my considered view, charge against A3 that he had
That he had managed to enroll the name of A2 Soma as a
177.
My lord, yes, my lord, 177. May I read, my lord?
Yeah.
In my considered opinion, charge against A3 that he had managed to enroll the name of PW2 Somo as an agent with an intention to keep a dummy code in his name to siphon huge agent's commission for the wrongful gain to himself, in furtherance of which, had managed to route the commission derived from the policyholders to his dummy code and that he had claimed illegally for the hypothecated articles insured by the insurers, do not become part of the transaction relating to this case. The reason is the period during which the offense or said to have been committed is from March 94 to January 95. PW 32, as already discussed, A3 was appointed as an agent in the year 1980 itself. If at all A3 had illegally conducted the business by securing policies in the name of PW2 to have wrongful to gain to himself, it could be an independent offense not connected with conspiracy with A1 and A2. There is no evidence, nor is the case of the prosecution, that A1 and A2 had conspired with A3 and A3 had conspired with A1 and A2 in getting enrolled the name of PW32 as an agent to achieve the aforesaid alleged illegal objects. Hence, in my opinion, this set of allegations become an independent allegation which could not have been clubbed in this charge sheet.
178 ಬನ್ನಿ.
I have already pointed out that PW33 is not shown to have received any monetary benefit owing to the illegal or criminal acts committed by the A1 and A2. Hence, the investigating officer was not justified in sending him up for trial. PW37 was admittedly development officer in his own case relating to MOD claim of his wife. PW36 consciously he had received 10,000 from A1 in excess of 2,000 that he had encashed it. This shows that he was a party to the conspiracy between A1 and A2 and at least himself.
A3 implication ಎಲ್ಲಿದೆ?
Blood.
ಮೇಲೆ ಏನ್ ಕೇಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರು. Para 175,
178. What I'm trying to submit, my lord, is that what it's been said is that it is an independent altogether, my lord. It's not
ಯಾವ್ದು?
connected with A1 and A2 ಅಂತ ಹೇಳೋದು.
That's right. But
177.
A3
A3,
Very benefit of doubt alla idu. Prosecution, it is difficult, rather very difficult. These are the words used by the learned judge of the criminal court. Where is the discussion about this judgment in the order of the CJIT? Which paragraph treats it?
my lord, only refers, my lord, to the acquittal in the criminal case, my lord.
Paragraph?
Yes, sir.
Lordship may kindly turn to page 98 on.
Okay, that's the one.
98 onwards, sir.
Yes, my lord. Para 14, my lord.
Para 14.
Para 14, page 98, my lord. In the middle, my lord, after the bracket, that is about 10 lines, my lord, the absence of any direct evidence regarding the collusion, that the investigating officer recorded that the involvement of Kodandrama in the scam cannot be ruled out. Of course, collusion and conspiracy will not be hatched or committed in broad daylight in the presence of witness. It is only through circumstantial evidence or inference has to be drawn, and the inquiry officer has done.
No.
the same. He has gone on mercy.
Where is the discussion about the judgment of acquittal?
It's not done.
What date it was, this was decided, which criminal case was decided on what date?
20th/7/2002, my lord.
And this was produced by and this was stated by in the crime statement also before inquiry, before the labor court.
Where did you
CJIT,
please,
By way of evidence. I produced this document.
you had produced this?
This is marked. Criminal case.
Yes, ma'am.
judgment.
That's the finding is at page 81.
It is marked.
In page 81, my lord.
What are the documents produced and all?
Particularly. No, did you produce that acquittal judgment
Yes,
before?
Yes, yes, yes.
It is produced.
Marked as
Page 81, in page 81 only, there's a reference, my lord. In the-
81.
In the award, my lord, there's a reference. The last 4 lines, my lord. That's page 3 of the judgment, my lord, at page 81. The last 4 lines, my lord. On the same charges, he was prosecuted in the criminal case and by order dated 27/2001, he is acquitted of the charges in the special court.
He is acquitted by the, ಇಷ್ಟು ಹೇಳಿ ಮುಗಿಸ್ಬಿಟ್ರು.
Mala?
ಅಲ್ಲ ಇಷ್ಟೇ ಹೇಳಿ, he is acquitted ಅಂತ ಹೇಳಿ ಮುಗಿಸ್ಬಿಟ್ರು. What is the impact of acquittal?
That's his, my lord, his
Resignation.
submission is recorded ಅಂತ ನಾ ಹೇಳಿದ್ದು.
The
His-
judge should have looked into that. Tribunal ought to have looked into because of P.V. Rudrappa. Except saying he has been acquitted, as if ತನ್ನ ಜವಾಬ್ದಾರಿ ಮುಗಿದೋತ್ ಅಷ್ಟು ಹೇಳಿದ ಮೇಲೆ ಅಂತ ಜಡ್ಜಂದು.
ಇಲ್ಲ ಹೇಳಿ. Because my lord, the
ಆಲ್ ರೈಟ್, ಇಷ್ಟು ವರ್ಷ ಆಯ್ತು ಈಗ ಅವ್ರಿಗೆ ಏನು
ಅದಕ್ಕೆ ನಾನು, my lord, that's the reason, my lord, I submitted to your lordship, my lord, that having regard to his submission that the argument was done on the proportionality of punishment, my lord, the lordship could scale down the back to this. Having regard to the serious charges.
And 28 years of service, totally unblemished record.
But you
Not even
occasioned a criminal case against you.
Yes, ma'am.
You occasioned a criminal case against yourself.
CBI, it was referred to CBI, my lord.
But I am acquitted.
Even despite CBI case, nothing has happened. ಅದೇ ಹೆಂಗ್ ಬೇಕಂಗ್
ಅದೇ.
He retired on which, where have you stated about his,
My lord, the order itself says, my lord, from the date of the termination
Yeah.
till the date of his superannuation.
ಏನು
102 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ?
75% ಕೊಡು.
ಒಂದ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿ. ಎಷ್ಟು ಕಡಿಮೆ ಮಾಡ್ಬೋದು?
Another 10%.
Huh?
Another 10%.
Of course, you are right in
Not even
bargaining.
gratuity is paid, nothing, subsistence allowance not paid.
My lord, whatever your
ಇನ್ನು
lordship.
ಉಳಿದಿದ್ದೆಲ್ಲ ಕೊಡ್ಬೇಕಲ್ಲ.
My lord, I'll go to your.
ಪೆನ್ಷನೇಬಲ್ ಅಲ್ಲ ಇದು.
ಹೌದು, pensionable.
Pension.
Pension ಕೊಡ್ತಾರೆ.
Central government.
ಇದು dismissal ಆಗಿದ್ದ no pension.
ಡಿಸ್ಮಿಸಲ್ ಅಂತ
He
ಮಾಡಿದ್ದು.
is now 74 years old. May I give the date of retirement, madam?
Huh?
Date of retirement ಹೇಳ ತಮ್ಗೆ.
ಇಲ್ಲೆಲ್ಲ ಬರ್ತಾರೆ ನೋಡಿದ್ವಿ.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ, ಇಲ್ಲ
ಬಿಡಿ.
ಬಂದಿದ್ದಾರೆ ಕೇಳ್ಬಿಟ್ಟು ಕರೆಕ್ಟ್ ಡೇಟ್ ಹೇಳಿ.
ಕೇಳ್ರಿ. ಅದನ್ನ ಸರ್ವಿಸ್ ವಿದೌಟ್ ಬ್ಯಾಕ್ ವೇಜಸ್ ಮಾಡಂತೆ. ಸೊ ದಟ್ ಅವ್ರಿಗೆ
March 2011.
Huh?
Is it? In the normal course, he would have retired on 16th March 2011.
2016, 2011, he attained age of superannuation.
28 ವರ್ಷ service, totally unblemished record of service. Not even one memo. You are the General Secretary of the All India Federation. India Employees Union. That is there in the record. I produced that and
Partly allowed.
Suffering from serious ailment. Without any medical aid.
Petitioner, the respondent workman attained age of superannuation on
16th March 2011.
31/3/2011, comma, his date of birth being 16/3/2011 to 16th March. Semicolon. At paragraphs 175 and 176 of the criminal court judgment, comma, there is sufficient indication that the prosecution had failed to prove the charge against him, although charge against accomplices was proved and they were convicted. Whereas he was acquitted. First, the word honorable acquittal is not forthcoming from the criminal court judgment, although it can be gathered from the discussion in the said judgment. The CJIT, except saying that the workman has been acquitted in the criminal case, comma, has not discussed this aspect of the matter. And that constitutes a positive ground for, arguably a positive ground for resisting the petition. This judgment was not marked in the evidence.
The evidence nale bantu. My evidence was recorded on
ಅಲ್ಲಿ
11th July 2006.
ನಾವು ನಿಮ್ಗೇನ್ ಕೇಳ್ತಾ ಇದೀವಿ, ಎಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಸುಳ್ಳು ನಾವು ಕೇಳಿದ್ದೆಲ್ಲ ಹೇಳ್ತಾ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಕೋಬಾರ್ದು ನಿಮ್ದು, ನಮಗೆ ಸಾಕಷ್ಟು ಟೈಮ್ ಇದೆ. PV Rudrappa becomes invocable. ಈ ಫೈಲ್ ತೊಳಿ. Judgment of the impugned author ಗೊತ್ತಾಗ. Now that the workman is aged 74 years, 4 years. And fact remains that from the date of dismissal till he attained the age of retirement, he has not put in any service. First, ordinarily in circumstances like that, no work, no pay is invocable. Even otherwise, court has discretion to deny the back wages in the fitness of things also. First, in the above circumstances, petition is allowed in part, and the impugned award of the CJIT is modified to the effect that petitioner shall be notionally reinstated only for the purpose of counting of service with no back wages whatsoever, and for the payment of terminal benefits such as pension, DCRG, PF, etc., which are to be settled within a period of 3 months, failing which the same would carry interest at the rate of 1% per mensem for the first month and 2% per mensem thereafter, till actual payment is made. Ah,
Some portion of the tax.
ಏನಿಲ್ಲ ಅಲ್ಲಿ ಬರುಕ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
ಇರ್ಲಿ, ಆದ್ರೆ
ಅಲ್ಲ ಪೆನ್ಷನ್ ಎಲ್ಲ ಬಂತು, ಸರ್ವಿಸ್ ಬಂತು.
ಇರ್ಲಿ, ಪರವಾಗಿಲ್ಲ. ಅದಕ್ಕೆ ನಮ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಒಳಗೆ ಗೋಲ್ಡನ್ ಮೀನ್ಸ್ 50%.
No, it all depends upon
ಇರ್ಬೋದು, number of
many aspects.
ಇದೆ. But then since,
ಅಲ್ಲೇ PV Rudrappa to be referred.
ಇದು what happened, 11th July, 12th July 2007, he gave the evidence. ಅದ್ರಲ್ಲಿ ಮಾರ್ಕಿಂಗ್ ತೋರಿಸ್ತಿಲ್ಲ, ಬಟ್
ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು.
But it
ನಾವು
is
ಸುಮ್ಮನೆ ಮತ್ತೆ ಲ್ಯಾಬ್ಸ್ ಅನ್ನು ಬರೆದು ಉಪಯೋಗ
It is
at least
not
it is there now,
probably
and it is not bound by the Evidence Act also. Therefore, we have done some exercise. Had you put that as a piece of evidence, what Madam Renuka would have said, told to the judge, we do not know. Therefore, ಹಾಗೆ cursory look ಮೇಲೆ ನಾವು ಇದೆಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. Anyway, that has brought justice.
And only one more thing. Earlier to dismissal, he was under suspension. Suspension period on duty ಆಗದೆ ಇದ್ರೆ, can be break in service, they may not get the money. ಅದು ಸ್ವಲ್ಪ ತೊಂದರೆ.
It is also made clear that even the suspension period shall be treated as a dice non, but will be counted as service for the purpose of terminal benefits. Okay. Both matters ನಿಮ್ದು ಇದೆ ಏನದ್ರಲ್ಲಿ?
ಅದು ನಂದ ಫುಲ್ ಕೇಳಿ ಹಾಕಿದ್ದೆ.
Another 25%, for
25%. So, the employer challenges award of the tribunal in directing back payment of back wage, full back wages, 25% of back wages.
ಅಲ್ಲ 75
ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ಅವ್ರಲ್ಲಿ ಎಂಟೈರ್ ಅವಾರ್ಡ್ ಇಸ್ ಚಾಲೆಂಜ್. ನಂದ್ರೊಳಗೆ to the extent I am aggrieved in denying.
And the workman has challenged the award to the extent it denies 25% of the back wages. What is going on? Yes.
And 4.
For the petition in this case.
23.
Spend indulgence, but pray for a short accommodation, I will file my objections.
ಯಾವಾಗ ಒಂದು ವರ್ಷ ಮೇಲೆ ಆಗಿದೆ, ಒಂದು ವರ್ಷ ಆದ್ಮೇಲೆ ಕೊಡಲ್ಲ.
Ready, my lord.
Ready, ನಿಮ್ಮಲ್ಲಿ ಇಟ್ಕೊಳ್ರಿ.
1 week.
You can keep it in a bank deposit, like you will put depositing the will ಇದೆಯಲ್ಲ, ಆ ರೀತಿ ಮಾಡ್ಕೊಳ್ಳಿ. Why did you not file? ಹಾಗೆ ಒಟ್ಟು ಹಾಕಿದ್ರಾಯ್ತು, ಮಾಡಿದ್ರಾಯ್ತು. Take out our CPC is made applicable for all practical purposes. Rule 37 ಅಥವಾ 39 of writ proceeding rules 1977 make CPC applicable to writ proceedings. You have not filed the WS, you would not have filed the WS there. ಎಷ್ಟು ದಿವಸ ಏನಿದೆ ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ. Already you had filed that na before tribunal. ಬಿಡಿ ಮತ್ತೆ try whatever ಏನು any new thing ಇದ್ರೆ ನೀವು ಹೇಳ್ಬೋದು ಅಷ್ಟೇ.
May I request for Monday mellows or Wednesday mellows?
Huh?
On Wednesday mellows, may I request for Wednesday mellows?
Why not today?
Mellows,
Let's say
the arguing council is is not in town. So
ಹಾಗೆ ಊರಿಗೆ ಹೋಗ್ಬೇಕು ಹೇಳಿ. ನಾವೇನ್ ನಿಮ್ಮ ಟೌನ್ ನಿಮ್ಮ ಟೌನ್ ಹಿಂದಿನ ನಾವು ಅಡ್ಡಾಡಕ್ ಆಗ್ತದ? ಎಷ್ಟು ಸರಿ ಓದ್ಬೇಕು ನಾವು ಇವನ್ನೆಲ್ಲ? ಏನು ಎಲ್ಲ ಸೆಕೆಂಡ್ ರೇಟ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಇರ್ತದೆ, ಎಲ್ಲ ನಮ್ಮ ತಲೆ ಕೆಟ್ಟು ಹೋಗ್ತದೆ. ನಿಮ್ದು ಇದನ್ನೆಲ್ಲ ಹಗಲೆಲ್ಲ ಓದಿದ್ರೆ ಮನ್ಸು ಸರಿ ಉಳಿತದ, ನಮ್ಗಿರೋ ನಾಲೆಜು ಪೊಲ್ಯೂಟ್ ಆಗಿ ಹೋಗ್ತದೆ. ಅವ್ನು ವಿ ಕಾಂಟ್ ಟಚ್ ಸರ್ಟನ್ cases even with a tongue. They will give shock to our mind. ಎಕ್ಕಳದಿಂದನೂ ಹಿಡ್ಕೊಳಿಕ್ಕಾಗಲ್ಲ, ಅಷ್ಟು ಹೊಲ್ಸ್ ಪ್ಲೀಡ್. ಒಂದು 2-3 ಇದೆ, ಅದು ತಗೊಂಡಾಗ ಬರಿತೇವೆ ನಾವು ಅದ್ರ ಮೇಲೆ. Call in the second week, third week of January 2025. At the request of counsel for the matter. Don't say that. You have right, only you can make a submission for adjournment. Then what date should be given is left to the judge. He has better business. See our calendar. ನಿಮಗೆ ಬೇಕಾದ ಕೇಸ್ ಬಂದಾಗ ಆರ್ಗ್ಯೂ ಮಾಡಲ್ಲ, ಅವಾಗ ಟೈಮ್ ಕೇಳಿದ್ಮೇಲೆ ನಾವು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದಾಗ ಆ ಡೇಟ್ ಬೇಡ ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡಿ. ವಿ ಡೋಂಟ್ ಡೂ ದಟ್ ಬಿಸ್ನೆಸ್ ಹಿಯರ್. ಎಸ್. ಎಷ್ಟು ಕ್ಲೈಂಟ್ಸ್ 23 ಅವರೆಲ್ಲ ನೋಡ್ಲಿ. ನಾವು ಯಾಕೆ ಆನ್ಲೈನ್ ಇಟ್ಟೇವಿ ಅಂದ್ರೆ ನಿಮ್ ಕ್ಲೈಂಟ್ ಎಲ್ಲ ನೋಡ್ಬೇಕು ನಿಮ್ಮನ್ನ ನಾವೇನ್ ಮಾಡ್ತೇವಿ ಅಂತನೂ ಗೊತ್ತಾಗಬೇಕು, ನೀವೇನ್ ಮಾಡ್ತೀರಿ ಅಂತನೂ ಗೊತ್ತಾಗಬೇಕು ಅವರಿಗೆ. ದೇ ವಿಲ್ ಹ್ಯಾವ್ ಅನ್ ಆಪ್ಷನ್ ಟು ಚೇಂಜ್ ದ ಜಡ್ಜ್, ದೇ ವಿಲ್ ಹ್ಯಾವ್ ಅನ್ ಆಪ್ಷನ್ ಟು ಚೇಂಜ್ ದ ಲಾಯರ್ ಆಲ್ಸೋ. ದಟ್ ವೇ ಅವ್ರಿಗೆ ಆಪ್ಷನ್ ಬೇಕಲ್ಲ. ಇಲ್ಲಪ್ಪ ನಾವು ಏನ್ ಮಾಡ್ತೀವಿ ಗೊತ್ತಾಗಲ್ಲ, ನೀವೇನ್ ಮಾಡ್ತೀರಿ ಗೊತ್ತಾಗಲ್ಲ, ನಮ್ಗೆ ತರಿಸ್ತೀವಿ ಪ್ರತಿ ಸಾರಿ. ಹಾ,
I am appearing, my lord.
ಹಾ.
I may be permitted to submit, my lords.
Yes, yes, sir.
My lord, in this case, my 2 annual increments have been withheld with cumulative effect, my lord. That is challenged before the tribunal, my lord. Tribunal has dismissed my application. I am before this honorable court, my lord.
On what ground?
My lord,
On what ground punishment was awarded to you?
it starts from 205, my lord, page number 205, my lord. That is the root cause, my lord. Official memorandum, my lord.
205.
Yes, my lord. May I read, my lord? Sri S. Purushottam, working as personal secretary cum judgment writer at Principal by Bangalore, is deputed to KSAT Belagavi bench Belagavi on OD basis for a period of 3 months with effect from 7/9/2000 by relieving him on the afternoon of 5/9/2000 with instructions to report at KSAT Belagavi.
All right, next.
Yes, my lord. Immediately I made a representation for cancellation of the said OOD order, my lord.
Okay.
Because it says that on OOD basis, is deputed on OOD basis, such things is not available in the KCSR because I want TA, DA, everything. It is not mentioned in this, my lord. For that reason, I made a representation, my lord. It is available in 206, my lord, page number 206, my lord. I requested the authorities to cancel my
ನಿಮ್ಮ ಮಗ ಮನೆಯವರು ಮಗಳು ಇಲ್ಲೇ ಅಧ್ಯಯನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಬೆಂಗಳೂರಲ್ಲಿ, ಹಾಗಾಗಿ ನಂಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
One of that contention, my lord.
Other contention?
My lord, in the entire KCSRs, there are more, my lord, about TA and DA, there are more than 200 places KCSRs in the KCSR that has been mentioned, my lord. In this, when I requested the second respondent to
How,
TA and DA,
how tribunal has treated the complaint?
my lord,
Your grievance is treated by the tribunal in what way?
my lord, in between that something has happened.
Yeah,
my lord.
nothing. This is
Yeah,
it code 227 court idu.
Thereafter,
L. Chandrakumar irodakke, not 226 at all.
my lord,
Come to that.
thereafter,
Where is the point which is considered by the tribunal? What is the wrong with the order of the tribunal?
yes, my lord. My lord, commences from para 18, my lord.
Para 18.
On page 267, my lord. My lord, in between that, I was kept under suspension, my lord. I have challenged the suspension order before the tribunal, my lord. during the pendency of that proceedings, this deputation order was cancelled, my lord.
You were given promotion and sent there
No, my lord, no, my
No.
lord, no, my lord.
on duty. you were-
Someone has given promotion, it's been sent, my lord. Another person, my lord.
What your conduct rules say ಸಾಮಾನ್ಯವಾಗಿ
Milord,
employees in LL post ಮಾಡಬಹುದು.
Milord, the tribunal has taken a decision instead of making transfer. Milord, after the constitution of the Belagavi bench and Gulbarga bench, Milord, 3 months, Milord, as OOD, they have sent. They have given the TA and DA also.
He has been given TADA.
TA, DA, yes, if he has gone there, it was given, he has not at all gone, he has refused to go there.
He refused to go.
He refused to go there, therefore articles of charges issue. He seeks for a route and he refused, when the chairman called, he refused to go.
No, my lord.
That resulted in initiation of departmental inquiry, where finding is given after inquiry. My lord, a penalty has been, my lord, imposed, which has been affirmed by the tribunal.
ಏನ್ penalty?
2 increments with cumulative effect.
Cumulative effect ಜಾಸ್ತಿ.
Like they,
Even assuming charge is proved.
my lord, there are three charges. Kindly come to, my lord, page 36. Not only, my lord, disobeying the order of transfer, but also, my lord, he
TADA
signed the register, attendance register after leaving in Bangalore. Page 36, my lord, articles, charge number 2. You have signed the attendance register maintained in the principal bench Bangalore from 7/9/2020 to 11/9/2020 without prior permission or orders from the competent authority, even though it has been recorded against your name in the attendance register that deputed to KSAT Belagavi bench on OOD basis and relieved on afternoon of 9/5/2020. And kindly see trial number 3, my lord, you.
No, he is saying, what is your power to depute me outside Bangalore ಅಂತ ಕೇಳಿಕತ್ತಾರೆ.
My lord, under the, my lord,
ಎಲ್ಲ
my lord, under the, my lord, the administrative tribunals rules of 1991. My lord, na ತಂದಿಲ್ಲ ಇವತ್ತು, but 1991, my lord, chairman is the, my lord, the highest authority in the tribunal.
ನೀವು
He
ಇವತ್ತು
takes
ತಂದಿಲ್ಲ.
the administrative
ಆಯ್ತು.
orders.
ಇವತ್ತು ತಂದಿಲ್ಲ ಅಂದ್ರೆ ಯಾವತ್ತು ತೊಗೊಂಬರ್ತೀರಿ? ನಾವ್ ಯಾವಾಗ ಕೆಲಸ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ, ಮಲ ಇದು ಇರೋದ್ರೊಳಗೆ ನಾನು ಹೇಳ್ತೀನಿ, ಇರೋದ್ರೊಳಗೆ ಹೇಳ್ತೀನಿ, ಎವಿಡೆನ್ಸ್ ಮಾಡಿದೀವಿ. ಎವಿಡೆನ್ಸ್, ಕೈಂಡ್ಲಿ ಸಿ, ಮಲ ಅಗ್ನೆಸ್ಟ್ ಹಿಮ್ there are more than 5 to 6 inquiries. Now he is also suffered with the compulsory retirement of service. Even after compulsory retirement of service, he is coming to the office and he has not participated in the inquiry in the 3 inquiries. ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ 44 ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದಾರೆ ರೈಟ್ ಟು ಇನ್ಫಾರ್ಮೇಶನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ. 1-2 officers are left to work of the petitioner only. ಚೇರ್ಮನ್ ಮಾತನ್ನು ಕೇಳೋದಿಲ್ಲ ಅನ್ನೋರಿಗೆ ಇನ್ನೇನ್ ಮಾಡ್ಲಿಕ್ಕಾಗತ್ತೆ?
ಅಲ್ಲ, ಅವ್ರು ಹೇಳೋದು ಚೇರ್ಮನ್ ಅಧಿಕಾರ ತೋರಿಸಿ ಅಂತ ಕೇಳಿದಾರೆ ಅವರು. ಅದು ತೋರಿಸ್ಬಿಟ್ಟು
ಅಲ್ಲ, ಅಧಿಕಾರ ಅದೇ ಮೊದಲೋಗಿ ರಿಪೋರ್ಟ್
ಹೇಳ್ತಾರಪ್ಪ, ನೀವು ಹೋಗಿ ಒಂದು ಮದುವೆ ಮಾಡ್ಕೊಂಬ ಅಂತಾರೆ.
Chairman is the, he knows it, chairman is the appointing authority for him. Chairman is the disciplinary authority for him. Since he is an appointing authority, instead of transferring for 2 years or 3 years, 3 months ಹೋಗ್ಬಿಟ್ಟು ಬನ್ನಿ, ಎಲ್ಲರೂ ಹೋಗ್ತಾ ಇದ್ದಾರೆ. ಇವ್ರು ಒಬ್ಬರದೇ ರೂಲ್ಸ್ ಕೇಳ್ತಾರೆ. ಅದು ಓವಡಿ ಬೇಸಿಸ್ ಮೇಲೆ ಮಾಡಿ 3 months ಹೋಗಿದ್ದಕ್ಕೆ TA DA ಕೊಟ್ಟು ಕಳಿಸ್ತಾ ಇದೆ.
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ಸ್ ಆಕ್ಟ್ ಕೊಡಿ. ಯಾವ ರೂಲ್ಸ್ ನೀವು ಹೇಳಿ?
91 ರೂಲ್ಸ್ ಇದೆ.
ಅವ್ರಿಗೆ ಪವರ್ ಇಲ್ಲ. ನಂಬರ್ 1 ಫಸ್ಟ್ ಗ್ರೌಂಡ್, ನೋ ಪವರ್ ಟು ಸೆಂಡ್ ಯು ಔಟ್.
I am not asking that, my lord. My request is, I want a TADA, my lord, that is mentioned.
TADA ಅಲ್ಲಿ ಹೋದ್ರೆ ಕೊಟ್ಟೆ ಕೊಡ್ತಾರೆ ಅವರು.
My lord, that is not the case, my lord, is, that's what I want to submit this.
ಅದೇನು?
This is application filed before the tribunal when they have sent me to Belagavi, my lord, at that point of time, my lord. In the year 2020.
ಈ ರೀತಿ ಕೊಟ್ರೆ ಏನ್ ಮಾಡಬೇಕು? ಅವರಿಗೆಲ್ಲ ಕೊಟ್ರೆ ಕಾಪಿನ?
I will, sir. They have the copies, my lord.
So number 1 is TADA ಕೊಟ್ಟಿಲ್ಲ.
Yes, that is the my contention, my lord.
ಬಟ್ ಅಲ್ಲಿ ನೀವು ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಹಂಗೆ ಹೇಳಿರಾ?
Yes, my lord. I will come to that point.
ಕಮ್ ಟು ಈಗ ಹೇಳ್ಬೇಕು.
TADA ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರು ಎಲ್ಲಿ ಹೇಳೇ ಇಲ್ಲ ಸರ್. Even in the writ petition, that note is not taken.
It is taken, my lord. It is there. It is there, my lord.
Our first ground is the chairman has not given TADA to you. Number
Yes, my
one,
lord.
no TADA.
But the second one is, my lord, in the
Second one
entire
is?
KCSRs,
Huh?
in the entire KCSS or general recruitment rules, there is no provision to discipline an employee on the basis of OOD on, deputed on OOD basis, my lord.
Now, suppose if you are posted to some place,
I will certainly, TADA will, that is my contention I have taken in this application, my lord.
ಅಲ್ಲಿ
It
ಹೋಗಿ
is
ಅಲ್ಲ
here, my lord. It is here, my lord.
TADA ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಕೊಡ್ಬೇಕು ಅಂತ ನೀವು ಹೇಳೋದೇನು?
That has to be mentioned in the order. Even I orally spoke to the second respondent, my lord.
Hmm.
We are not giving such TADA. That is in my application.
ಬೇರೆಯವರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದಾರಲ್ಲ TADA ಕೊಟ್ಟಿಲ್ವಾ?
Thereafter, my lord. That is in the year 2000.
ಗುಲ್ಬರ್ಗಕ್ಕೆ 4 ದಿವಸ ಹೋಗಿದ್ರೆ ಇವರಿಗೆ ಕೊಟ್ಟಿರಿ
Yes, my lord.
ಅಂತ ತಂದಿದ್ದೇನೆ ನಾನು.
When he went to Gulbarga,
In the year 2020, my lord.
2020 you were in Gulbarga.
Member, my lord.
2020 ಹೋಗಿದ್ದಾರೆ.
2020 you
Yes,
went to Gulbarga bench
Yes, my lord.
and you were paid TADA.
Yes, my lord.
Alparklama. The first contention is that the order deputing his services to Belgaum bench does not specify or assure the payment of TADA. First, Gayatri submits and the petitioner party in person also agrees that TADA was given to him when he was deputed to Gulbarga bench way back in 2020. Okay. Then,
That is the order accompanying the member, my lord.
huh?
It is in the KCS.
All right, you argue, you have said that one point. Next point.
In rule 516, note 17, it is mentioned, my lord. Whenever the judge transferred to any bench, the personal staff has to be transferred, my lord.
Ah.
For that reason, I accompanied the member in the year 2020. For that period.
All right, now why you did not go thereafter?
Thereafter, it is for a period of 3 months, my lord. That is the main crux, my lord.
The-
What they are doing, my lord.
Next point. He says since deputation was for a period of 3 months to Belgaum bench, comma, he could not go in as much as his family with 2 children, college going children were in Bangalore. Number 2.
My
3.
lord. What now they are doing is, my lord, for the first month, they are giving 400 rupees, my lord. For the second month, they are giving 200 rupees, my lord. For the third month, they are giving only 100 rupees, my lord. For that reason, even at that point, a significant point of time when
He
I
has
was sent-
also a grievance as to diminishing scale of payment of deputation allowances in the sense that for the first month, just
400 rupees,
400 rupees, comma, for the second,
200 rupees,
200 rupees,
50%,
and for the third, it is only 100.
25%, my lord.
100.
After 4 months, no TADA, my lord. No
4
DA.
months ಇಲ್ಲ 3 months ಅಷ್ಟೇ ಕಳಿಸಿದ ಆ ಪಾಯಿಂಟ್ ಹೇಳೋದು.
Some persons have been.
Next, you don't worry
next,
about
my
them,
lord.
tell your case.
In now I have submitted, my lord.
That what is the next ground?
Next, my lord.
Ah,
In the Karnataka Administrative Tribunal at Belagavi, only one personal secretary post was vacant, my lord. That has been filled by giving promotion to another person, my lord, on the same day, my lord. When I was sent to Belagavi, on the same day, someone has been promoted to that post. my
next he contends that there was only one post, one vacant post.
Only
in-
one member.
Of a, ಯಾವ post ಅದು?
Personal secretary come judgment writer,
PS to-
writer, my lord.
PS stroke judgment writer at Belgaum bench. And that post was already filled up. And therefore, he could not have been accommodated.
I requested the authorities to cancel my deputation, my lord.
In that view of the matter, he had requested the chairman to cancel the deputation.
Yes, my lord.
Next point.
My lord, it is available, the order promoting a person to that post is available at page 18 in,
Page,
18 in 3809. Now I submitted on application number. 18, my lord. Annexure 8 to my lord.
he says that even na? Annexure?
8 to my lord,
8 to-
18, page 18, my lord.
He says that the order posting someone else
Promoting.
as junior judgment writer by way of promotion is available, is dated 4/9/2020 at Annexure A1 in the memo for production of lied documents dated 20/11/2024.
Yes, my lord.
Next point.
My lord, thereafter, I was kept under suspension, my lord. I challenged that suspension before the honorable tribunal, my lord. That is the application.
Where is that order? In this, it is not there.
That is this application.
You are challenged that very, suspension and DE.
Only suspension order. At that point of time, I was kept under suspension.
You
That
have
has been.
challenged punishment order in withholding of 2 increments.
That is in this application, my lord. Earlier to that, one more application was filed by me before the honorable.
Argue
tribunal.
this case.
Yes, my lord, that is relevant.
Ah.
Now, in that application, the first and second respondents have cancelled my posting to Belagavi, my lord. They have cancelled that order.
When they cancelled it.
2/11/2020, my lord, by order 2/11/2020. That is-
Because you did not go.
No, my lord, I have challenged the same before the suspension order is challenged before the tribunal. I was kept under suspension, my lord. Because of I challenged the suspension order before the tribunal, the respondents have cancelled my posting to Belagavi bench and I have been reinstated and given a posting in Bangalore, my lord. So thereafter, on that basis, they have framed the charges, my lord. That is one of my grounds, my lord. When the order is not existence, they cannot frame the charges on the basis of non-existing order.
But the order was in existence up to particular point of time. Only later it came to be rescinded. Is it rescinded with retrospective effect? No.
No, my lord. No.
Then
that's
at that time we have violated the
But
order.
I was kept under suspension, my lord. Thereafter, they have conducted the inquiry, my lord. So I have participated in the inquiry, my lord.
Ah.
So that is my main grounds, my lord, in that order.
These are the grounds.
That's all my lord, my grounds.
What is?
The section 13(1)(a) of the Administrative Tribunals Act. May I read, my lord? The 13, the appropriate government shall determine the nature and categories of the officers and other employees required to assist a tribunal in the discharge of functions and provide the tribunal with such officers and other employees as may deem fit. 1(a), officers and other employees of the tribunal shall discharge their functions under the general superintendence of the chairman.
Rule 13,
13(1)(a), my lord.
one small a,
Small, big A, capital A,
capital A.
capital A. Under this, my lord, there are
Staff of
80
the tribunal. Staff of the tribunal.
tribunal.
Officer and Assistant. Mr. Gayatri submits that under section 13(1) capital A, effective from 22/1/1986, employees are under the general superintendence of the chairman, and therefore they have to obey the orders and directions issued by the chairman time to time.
Under this, my lord, there is a rule is also there of 91. It is not in this booklet, my lord. 91 rules, my lord, it specifically says chairman is the appointing authority and as well as the discipline authority. Under which, my lord, action has been taken. Incompetency has not raised the ground before either before the inquiry officer nor before the tribunal.
He adds that under rule,
Karnataka,
rule ಏನದು? ಯಾವ rule?
Karnataka, my lord,
Section ಏನು? Provision ಏನು? Rule provision, which provision?
ಅಷ್ಟು ನೆನಪಿಲ್ಲ, but 81 rules, my lord.
Under the provisions of tribunal rules.
Tribunal rules of 1992.
Section of rules promulgated under the 1985 Act governing the service conditions of the employees of the tribunal, comma, the chairman happens to be the appointing authority and the disciplinary
Disciplinary
authority as well. And therefore, the employees have to obey his orders.
I'm sorry, my lord, he has not raised the ground of competency, therefore I have not brought that particular rule, my lord.
Ah.
Then, my lord, The,
My lord,
regarding my lord,
ಕೂತ್ಕೊಳ್ಳಿ.
regarding my lord,
it is available in the record, my lord, that rules available in the.
ಎಲ್ಲಿದೆ ಅದು?
Yeah, my lord, they have filed the reply statement, in the reply statement they have presented, my lord. Page 33, my lord,
ಎಲ್ಲಿದೆ? ಪೇಜ್ ನಂಬರ್
333, in reply of the respondents, my lord. Annexure R2,
333.
page 33, reply.
ಇದ್ರೊಳಗೆ ಹಾಕಿದ್ರಿ.
ಯಾವ್ದಿದೆ? ಈಗ ರಿಪ್ಲೈ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನಲ್ಲ?
Yes, my lord.
Rule 6, my lord, page 34 of my
ಕೋರ್ಟಿಗೆ
statement.
ಬರ್ಬೇಕಾದ್ರೆ ನಾವು ಓದಿಕೊಳ್ದಂಗೆ ಬಂದ್ಬಿಡ್ತೀರಾ ಪೇಪರ್ಸ್?
My lord,
ಏನ್ ಮೈಲಾಡ್?
ಅವ್ರ ಪಿಟಿಷನ್ ಪೂರ್ಣ ಓದ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ.
ಓದೋ ಅಗತ್ಯ ಇಲ್ಲ ಮೈಲಾಡ್ ಅಂತ.
ಅವ್ರ ಪಿಟಿಷನ್ ಪೂರ್ಣ ಓದ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಈ ರೀತಿ ನಿಮ್ಮ ರಿಪ್ಲೈದಲ್ಲೇ ಕೊಟ್ಟಿರಲ್ಲ, ಹೇಳಿದ್ರಿ.
Disciplinary authority, chairman shall be the disciplinary authority. Appointing authority, rule 3, my lord. All appointments to the staff of the tribunal shall be made by the chairman or such other member or officer of the tribunal as may be government may by special or general order directs. Rule 3, my lord.
Rule 3. R1 ಅದ ರೂಲ್ 3 ನಾ?
ಹೌದು.
R2, my lord.
R2 ದಲ್ಲಿ page 34 ದಲ್ಲಿ. Rule 3 and 6, my lord.
3 and 6. ಅಲ್ಲೇ ರೂಲ್ 3 and 6 ಅಂತ ಬರ್ತೀನಿ. Of Karnataka Administrative Tribunal Conditions of Service etc. Bracket Complete Rules 1992. Rules 3 and 6 are
ಹೌದು.
appointing authority,
And disciplinary authority.
disciplinary authority.
But he has not raised the, my lord, competency ground, my lord.
Disciplinary. All right. He's a party in person.
ಅಲ್ಲ, ಅಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅಂತ.
Though he's not no less than Attorney General.
Then, my lord, my lord, when he was sent, my lord, his grievance was, my lord, not regarding his personal difficulty. He has not stated in the representation that we are not giving the TA or DA, nothing.
ಯಾಕೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲ? ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ನಂಗೆ ಹೆಂಡತಿ ಮಕ್ಕಳಿದ್ದಾರೆ, ಮಕ್ಕಳು ಸ್ಕೂಲ್ನಲ್ಲಿ ಕಲಿತಾ ಇದ್ದಾರೆ, ಬೆಂಗಳೂರಲ್ಲಿ,
ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ.
ಬೆಳಗಾಂನಲ್ಲಿ ಒಂದ್ ಮನೆ, ಆಮೇಲೆ ಗುಲ್ಬರ್ಗ.
ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. My lord, we are taken instructions from the government. My lord, as the government advised us, my lord, we are giving TADA.
ಅದನ್ನ ಎಲ್ಲರ ಒಂದ್ ಕಡೆ ಹೇಳ್ಬೇಕಾ? ನೋಡಪ್ಪ ನಿಂಗೆ TADA ಕೊಡ್ತೇವಿ, ಯಾಕೆ ಹಂಗೆ ಹೇಳ್ತಾ ಇದೀಯಾ, ಹೋಗು ಅಂತ ಎಲ್ಲರ ಹೇಳಿ.
ಎನ್ಕ್ವೈರಿಲಿ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ, ಎನ್ಕ್ವೈರಿಲಿ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ನಿಮ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಈ ಗೇವ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಟು ಯು. ನನಗೆ ಇದೆಲ್ಲ ಸಮಸ್ಯೆ ಇದೆ, ನೀವು ಸರಿ ಮಾಡ್ರಿ, ನಿನಗೆಲ್ಲ ದುಡ್ಡು ಕೊಡ್ತೇವೆ, ಹೋಗಯ್ಯ ನೀನ್ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಅಲ್ಲಿ ಅಂತ ಹೇಳಕ್ ಬರ್ಲಿಲ್ವಾ? ನಿಂಗೆ ಹೆಂಡತಿ ನಮಗೂ ಹೆಂಡತಿ ಮಕ್ಕಳಿದ್ದಾಳೆ, ನಾವು ಹೋಗಲ್ವಾ ಅಲ್ಲಿ ಅಂತ ಹೇಳಿ ಏನಾದ್ರು ಒಂದು ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು ರಿಪ್ಲೈ.
ಅಟ್ಲೀಸ್ಟ್ ಹೋಗಿ ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾ ಇದ್ರು, ಹೋಗಿ ಕೇಳ್ಬೋದಾಗಿತ್ತಲ್ವಾ? That is not his case. When he was gone to the before the chairman, my lord, he has refused to go there. ನಾನು ಹೋಗಲ್ಲ ಅಂತ ಅಡಮೆಂಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕಾಗತ್ತೆ?
ಆಮೇಲೆ ಅಲ್ಲಿ ವೇಕೆನ್ಸಿನೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ವೇಕೆನ್ಸಿ ಇದೆ, ವೇಕೆನ್ಸಿ ಇದ್ದದ್ದೇ ಕಳಿಸೋದು, ವೇಕೆನ್ಸಿ ಇಲ್ಲೇ ಕಳಿಸೋದು ಸ್ಯಾಲ್ರಿ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, ಒಂದು ಪೋಸ್ಟ್,
2 ಪೋಸ್ಟ್ ಇದೆ ಅಲ್ಲಿ. ಅಲ್ಲಿ ಎಕ್ಸಿಸ್ಟೆನ್ಸಿ ಇದೆ,
ತೋರಿಸಿ. ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ಏನು?
ಡಿಪಾರ್ಟ್ಮೆಂಟ್
He has put it in writing. You should put in reply in writing. ಎಲ್ಲಿದೆ? ನೀ ಹೆಂಗೆ ಹೇಳ್ತೀರಿ? 2 ಇದೆ ಅಲ್ಲಿ, ನೋಡು ಅಂತ ಅನ್ಕೊಂಡು ತೋರ್ಸಕ್ ಬರಲ್ವಾ?
ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಎವಿಡೆನ್ಸ್
ಎಲ್ಲಿದೆ? 2 ಇದೆ ಅಂತ. ಈಗ he said, ಸ್ವಾಮಿ ಒಂದೇ ಒಂದು ಪೋಸ್ಟ್ ಇದೆ, ಅಲ್ಲಿ ಇನ್ನೊಬ್ರು ಪ್ರಮೋಟ್ ಮಾಡಿ ಆ ಪೋಸ್ಟಿಗೆ ವೇಕೆನ್ಸಿ ಫಿಲ್ ಅಪ್ ಮಾಡ್ಯಾರೆ. ಯಾವ
ವೇಕೆನ್ಸೀಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕಳಿಸ್ತಾನೆ ಇರ್ಲಿ. His requirement was very much there. Therefore, my lord, order of deputation was issued. And he has not questioned, my lord, order of deputation before the tribunal.
ನಾವು ಹೇಳೋದನ್ನು ಉತ್ತರ ಕೊಟ್ರ ಆತಪ್ಪ.
ಅಲ್ಲ,
ವೇಕೆನ್ಸಿ ಒಂದೇ ಇದೆ,
ವೇಕೆನ್ಸಿ ಇತ್ತು,
ಆ ವೇಕೆನ್ಸಿ ಫಿಲ್ ಅಪ್ ಆಗಿದೆ.
ವೇಕೆನ್ಸಿ ಇತ್ತು ಎಲ್ಲಿ ಕ್ವಶನ್ ಮಾಡಬೇಕು? He has to challenge the order of deputation. He has not challenged the order of deputation.
ಹೇಳಿದಾನ ಅವನು ಬಂದು, ನೋಡಿ ನೀವು ಹಿಂಗ್ ಕಳಿಸ್ತಾ ಇದ್ದೀರಿ,
ನಾವು ಮಾಡಿಲ್ಲ.
ವೇಕೆನ್ಸಿ
Then he has to file an application
ಯಾವುದಕ್ಕೆ?
before the challenging the order of deputation. He has not done.
No, what you have done? He said to you, TADA ಕೊಡ್ರಿ ಅಂತಂದ್ರೆ ನಾವು TADA ತಗೊಳಪ್ಪ, ನೀವು ಕೊಡ್ತೀವಿ, ಕೆಲಸ ಮಾಡು, ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಂಗೆ ಹಿಂದ್ ಕೊಟ್ಟಿದ್ದೇವೆ, ಈ ಸರಿ ಯಾಕೆ ಕೊಡಲ್ಲ?
ತಗೊಂಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಾವೇನ್ ಮಾಡಕ್ಕೆ?
That's what he said. We are telling a model employer, you are not owner of some factory. You are chairman of a body which exercises powers almost on par with High Court. He has to be reasonable. Employee ಹೆಂಗಾರೆ ಇರ್ಲಿ. Employer has to be a model employer.
Also, I agree for that.
But-
But it is not, my lord, this case that.
Why can't you resist your temptation not to answer my question?
ಇಲ್ಲ,
Yes.
ಮಾಡ್ತೀನಿ.
ಚೇರ್ಮನ್ಗೆ ಅವ್ರು ಹೇಳಿದ್ರು, ಸರ್ ಅಲ್ಲಿ ವೇಕೆನ್ಸಿ ಇಲ್ಲ, ಒಂದು ಪೋಸ್ಟ್ ಇತ್ತು, ಪ್ರಮೋಟ್ ಮಾಡಿ ಅವ್ರನ್ನ ತೊಗೊಂಡಿರಿ ನೀವು, ನಾನು ಎಲ್ಲಿ ಹೋಗಿ ಕೂಡ್ಲಿ? ಅವ್ರ ಲ್ಯಾಂಗ್ವೇಜ್ ಬಿಡಿ, ಅವ್ರ ಲ್ಯಾಂಗ್ವೇಜು ಅವ್ರ ಇದನ್ನ ಒಂದು ಸಪ್ರೇಟ್ ದೊಡ್ಡ ಲೈಬ್ರರಿನೇ ಬೇಕಾಗ್ತದೆ, ಎಲ್ಲದನ್ನು ಮನುಸ್ಕ್ರಿಪ್ಟ್ ಇಡೋದಿದ್ರೆ ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಬಟ್ ಈ ಸೇಸ್ ನಂಗೆ ಹೆಂಡತಿ ಮಕ್ಕಳಿದ್ದಾರೆ, ತೊಂದರೆ ಆಗ್ತದೆ, TADA ಬೇರೆ ನೀವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿಲ್ಲ ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ನಲ್ಲಿ, ಆಯ್ತು ಆಗಿಂದಾಗ ಕರ್ತೊಳೆ ದಿಸ್ ಕರಿಜೆಂಡಮ್ ಇಶ್ಯೂ TADA ವಿಲ್ ಬಿ ಗಿವನ್ ಟು ಯು. ನಂಗೆ ಹೆಂಡತಿ ಮಕ್ಕಳಿದ್ದಾರೆ, ಆಲ್ ರೈಟ್, ಹೆಂಡತಿ ಮಕ್ಕಳಿದ್ರೆ ಬೇರೆಯವ್ರು ಹೆಂಡತಿ ಮಕ್ಕಳಿದ್ದಾರೆ, ಅವ್ರು ಹೋಗಿದ್ದಾರೆ, ನೀವು ಹೋಗಬೇಕು.
ಎಲ್ಲ ಎಂಪ್ಲಾಯೀಸ್ ಹೋಗಿ ಬರ್ತಾ ಇದ್ದಾರೆ, including my lord judicial members and administrative members. We are giving TADA. ಎಲ್ಲರೂ ಹೋಗಿ ಬರ್ತಾ ಇದ್ದಾರೆ.
ವೇಕೆನ್ಸಿ ಬಗ್ಗೆ ಏನು ಉತ್ತರ?
ವೇಕೆನ್ಸಿ ಇದೆ ಸ್ವಾಮಿ, ವೇಕೆನ್ಸಿ ಇಲ್ಲ ಅಂತ ಕಳಿಸ್ತಾನೆ ಇರ್ಲಿಲ್ಲ.
ನೋಡಿ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಮಟೀರಿಯಲ್ ವಿಚ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಕೌಂಟರ್ ಮಟೀರಿಯಲ್. ಹಿ ಹ್ಯಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಮಟೀರಿಯಲ್ ಟು ಶೋ ಪರ್ಟಿಕ್ಯುಲರ್ ಲೇಡಿ ವಿಜಯಲಕ್ಷ್ಮಿನ ಯಾರೋ ಒಬ್ಳನ್ನ ನೀವು ಪ್ರಮೋಟ್ ಮಾಡಿ ಆ ವೇಕೆನ್ಸಿಗೆ ಫಿಲ್ ಅಪ್ ಮಾಡಿರಿ, ಹಂಗಾಗಿ ಇಲ್ಲ ಅಂತ ಹೀಸ್ ವರ್ಷ. ನಿಮಗೆ ಗೊತ್ತಿದೆ ವೇಕೆನ್ಸಿ ಎಷ್ಟು ಏನು. ಯು ಆರ್ ದ ಎಂಪ್ಲಾಯರ್, ಯು ಆರ್ ದ ಸೂಪರ್ವೈಸರಿ ಅಥಾರಿಟಿ, ಅಪಾಯಿಂಟಿಂಗ್ ಅಥಾರಿಟಿ, ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ, ಎವ್ರಿಥಿಂಗ್. You will know there is vacancy. Why do you say there is no vacancy? There is a vacancy. Go and report.
ನಾಳೆನೇ ಹೇಳ್ತೀನಿ, ನಾಳೆ ಬೆಳಗ್ಗೆ ಹೇಳ್ತೀನಿ ವೇಕೆನ್ಸಿ ಪೊಸಿಷನ್.
No time. We will never hear the matter on installment basis. We are
ಅಲ್ಲ, ವೇಕೆನ್ಸಿ ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಒಂದು ನಾಳೆ ಹೇಳ್ತೇನೆ.
ನೀವು ಇಲ್ಲಿ ಏನಿದೆ ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಈ ಕಡೆ ಆ ಕಡೆ ಅಷ್ಟೇ. ಅವ್ರು he has taken that contention.
ಅದು ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ಲ, ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. He remained absent and he disobeyed the orders.
Disobey the orders ಅಂದ್ರೆ ಏನು? Your chairman is not Mughal of this country. He is chairman of a tribunal.
ಹೇಳಿದೆ
ಬೇರೆ ಎಲಿಮೆಂಟ್ಸ್ ಆಫ್ ಫೇರ್ನೆಸ್ ಎಲ್ಲಿದೆ ಅಂತ ಅವ್ರು ಹೆಂಗಾರೆ ಇರಲಿ, ನಿಮ್ಮ ಕಡೆಯಿಂದ ಎಲಿಮೆಂಟ್ ಆಫ್ ಫೇರ್ನೆಸ್ ಎಲ್ಲಿದೆ? ಅಂದಾದ್ರೆ you could have called him to the chamber, you could have offered him a cup of tea. ನೋಡು ಬ್ರದರ್, ಹಿಂಗೆ ಅನ್ಬಾರ್ದು,
ಅದ್ ಮಾಡಿದ,
ಎಲ್ಲರೂ ಹೋಗಿದ್ದಾರೆ, ನೀನು ಹೋಗ್ಬೇಕು,
ಅದ್ ಮಾಡಿದ
ವ್ಯವಸ್ಥೆ ಮಾಡೋದು ಮಾಡೋಣ.
ಅದು ಮಾಡಿದ ಮೇಲೆ ಸಸ್ಪೆನ್ಷನ್ ಇತ್ತು.
ಅವ್ರು ಹೇಳಿದ ಪಾಯಿಂಟ್ ಎಲ್ಲ ಅಡ್ರೆಸ್ ಮಾಡಿಲ್ಲ. ನಿಮ್ಗೆ ವೇಕೆನ್ಸಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಅವ್ರ ಜೊತೆ ನೀವು ವೇಕೆನ್ಸಿ ಇದೆ ಅನ್ಕೊಂಡು ಅವ್ರ ಜೊತೆ ವಾದ ಮಾಡಕ್ ಬರ್ತದ? ಒಂದು ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಆತಪ್ಪ, ಒಂದು ಕ್ಲಾರಿಫಿಕೇಟರಿ ಲೆಟರ್ ಕೊಟ್ರೆ ಆಯ್ತು.
My lord, one more thing I may be submitted, my lord.
Vacancy
In
position
my
ಹೇಳ್-
application number, I have specifically stated, my lord, TADA has not been given. They have not. said-
TADA was given to you when you went to Gulbarga for
In this application,
23
in
days.
this case, my lord, in this case, I have stated, my lord,
ಅಲ್ಲಿ ಹೋಗಿ ಅಲ್ಲಲ್ಲ, ಏನ್ ಕೊಡ್ಬೇಕು? You did not go.
my lord, I have given a representation. Personally, I met the second respondent and asked, it has been mentioned in my application, my lord.
Heard, judgment tomorrow. Next. Start. ಎಲ್ಲ ಅಡ್ಜರ್ಮೆಂಟ್ ಮಾಡಿ, ಏನೇನು ಇದೆ ಅಲ್ಲ, ಏನೋ ಬರೀ ಜಡ್ಜಿ ಅಷ್ಟೇ ಇರಲ್ಲ, ನಮ್ಗೆ 10 ಕೆಲಸ ಇಲ್ಲ.
38, it's a covered by decision.
ಬೇಜಾರಾಯ್ತು, ಎದ್ದು ಹೋಗ್ರಿ.
Vacancy ಇಲ್ಲ ಅಂತ ತಗೊಂಡಿಲ್ಲ. Enquiry ತಗೊಂಡಿಲ್ಲ, ತಗೊಳಕ್ಕೆ.
ಸರ್ ಇನ್ನೊಂದು
ಸರ್ ಡೇಟ್ ಕೊಡ್ತೀರಾ ಸರ್? ಡೇಟ್ ಏನಾದ್ರು ಕೊಡ್ತೀರಾ? ಒಂದು ಮೆಮೊ ಮಾಡಿ.
ಲಾಸ್ಟ್ ವೀಕ್ ಇತ್ತು, ಇವಾರ ಕವರ್ಡ್ ಬೈ ಡಿಸೆಮಿನೇಟ್ ಅಂತ ಇವಾರ ಹಾಕಿ ಅಂದಿದೆ.
ಮೆಮೊ ಮಾಡಿದ್ದು ಸರ್, ಇದು 39 ಮೆಮೊ ಮಾಡಿದ್ರೆ ಯಾವ್ದಾದ್ರು ಒಂದು ಶಾರ್ಟ್ ಡೇಟೇ ಕೊಟ್ಬಿಡಿ. ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡ್ಲಿ ಪರವಾಗಿಲ್ಲ. ಥ್ಯಾಂಕ್
ಅವೈಲೇಬಲ್ ಮೆಮೊ ಮಾಡಿದ್ ನಿನ್ನೆ
ಲಾಸ್ಟ್ ವೀಕ್ ಇಂದ ಕವರ್ಡ್ ಬೈ ಅಂತ ಇವಾರ ಹಾಕಿದ್ರು. ಡಿಸೈಡ್ ಕವರ್ಡ್ ಅಂತ ಲಾಸ್ಟ್ ವೀಕ್. ಹೌದೌದು, ಲಾಸ್ಟ್ ವೀಕ್ ಇಂದ ಈಗ ಹಾಕಿದ್ರು. ಕವರ್ಡ್ ಬೈ ಅಂತ ಹಾಕಿದ್ರು ನೋಡಿ.
ಅಂದ್ರೆ ಬಂದಿಲ್ಲ ಅಷ್ಟೇ. ಎಲ್ಲಿ ಬಂದಿಲ್ಲ ಮಾಡಿರ್ತಾರೆ, ನಂಗೆ ಬರಲ್ಲ ಇವಾಗ. ವಯಸ್ಸು ಅಪ್ಲೈ ಆಗಿದಾಗಲ್ಲ.
39
ಅದೇ ಆಕ್ಚುಲಿ ಎಲ್ಲ ಫೋನ್ ಆಗಿತ್ತು. ಬಟ್ ನನ್ನ ಮಗನ ಇನ್ಸ್ಟಾಗ್ರಾಮ್ ಇರ್ತೀರ ನೋಡಿ. ಸುಮ್ಮನೆ ಇದು ಕನೆಕ್ಟ್.
Yes, sir. Start date 2nd of December.
So 10 December. 10 December.
So 40. 40.
ಅವತ್ತು ಇನ್ನೊಂದಿಲ್ಲ ಅದಕ್ಕೆ.
25th.
ಇದು ಹೆಂಗೆ
ಕೇಸ್ ಇದೆ 26. ನಮ್ಮೂರಲ್ಲಿ ಇಲ್ಲ. ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ 40 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? 40 26 26 ನಾನು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್. ಹೇಗೆ? ಹಾ 21st week of December ಕೊಟ್ಟು. ಹೌದಾ? ಸರಿ, ಇರ್ಲಿ ಬಿಡಿ.
TV number 39 now. 39. 39 to 12. Thank you.
ಇಲ್ಲ ಸರ್, ಏನೋ ಹೇಳ್ತಾ ಇದ್ದೆ, ನೀವೇ ಡೇಟ್
ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ರಘುನಾಥ್ ಅಂತ ಇರ್ತಾರೆ ಚೇಂಬರ್ ಭೂಪೇನ್ ಆಧಾರಿತ ಸೈಟೇಷನ್